All right, good morning, everyone. As you know, I'm Adam Thorpe, and I am the St. Thomas St. John Water Island co-chair for the Virgin Islands Bar Association's Moot Court Planning Committee. Good morning. Rob, do you want to take a quick second to say hello, my co-chair for St. Croix?
Good morning, everybody. I'm Rob.
All right. So first, just before anything, I want to say congratulations to all of you. The students, you made it this far. It is an accomplishment just to do that much. And so be proud of yourselves for there. And to the coaches, you deserve a double congratulations. Not only did you coach the students to get here today, but this is singularly the largest number of schools and the largest number of students participating in the program's history. And that isn't due to anything but your ability as coaches to make the students enjoy and learn this and make it something that they want to do. So really and truly congrats to all of you. With that, I would give the floor to Charlotte Perrell. Attorney Perrell is an attorney here on St. Thomas. She is a member of the Virgin Islands Bar Association's Board of Governors, and she is the immediate past president of the Bar Association. For those who don't know, it is the Virgin Islands Bar Association who sponsors this program. It's the self-regulatory arm of the Virgin Islands judiciary that manages all of the lawyers in the Virgin Islands. And so with that, I would turn it to Charlotte for a quick welcome address.
Thanks, Adam. Good morning, everyone. I see a couple of familiar faces, and I'm very much excited to be able to be here. As Adam mentioned, I am the immediate past president, which is really the best job to have because you get to participate in things like this, but yet you don't have all the responsibilities of being the active president. So for me, I'm enjoying this role as well. But I want to welcome everyone and really, again, congratulate you for getting this far. I have been a coach for the Moot Court team for a number of years. I haven't done it the last couple of years because I've been doing other things with the bar. But I have to say it's really probably one of my most favorite programs and traditions. I know last year, I gave a special award to really recognize Adam and Rob for their efforts, and they really do put in efforts all year round, from coming up with the ideas for the topic, for writing it up, for going through all the various iterations of it, and so forth. And then finding the judges and the speakers and so forth. I mean, they really do put an inordinate amount of time in, and obviously it shows. We all get to come here today and enjoy the fruits of those labor. But we know that it is really a tremendous amount of time, and I thank you guys for all of it. And I think you've really just, as I said before, you've elevated this program. It was already fabulous, and you've really just taken it to sort of the next level. To the coaches, been there. It's a lot. It's a lot of time. I think it's probably one of the most rewarding things that I have done. And I think it's just getting to interact with the students is just, to me, it's very fun. And really, I think the best part of sort of the part that I've enjoyed the most and where I've sort of been the most proud is just watching from those beginning arguments, which we all know are kind of rough and painful to watch, to see how it evolves and to see people who, might have been a little concerned or nervous to really just blossom and just to become confident and comfortable in their skin and so forth. And to the students, I have to say, this is a lot of work for you. This is extra. This is on top of. You don't have to do this, but you are doing it. You're putting in the effort, and regardless of what career you choose, this experience is going to be one of those things that will bode well no matter what you do. The ability to get up and to speak in front of people, to make a coherent argument, to do so in a professional way, to persuade a listener, and to be able to think on your feet and to react is a skill that is something that something you'll take with you forever, and will help you no matter what it is that you end up doing. And so at this point, you've studied all you can, you've practiced, you've rehearsed. I know everyone's a bit nervous, but enjoy it. Let that energy, be something to sort of fuel the fire. And best of luck, and let the games begin. Welcome, everyone. Thank you for everyone that is participating, and we look forward to yet another wonderful competition.
Thank you, Charlotte. Thank you. And for those interested, usbibar.org/donations. If every member of the Bar Association donated $10 a year, we would fund all of the scholarships annually, and we would fund most of the cost of the program. That's not a lot of money annually to donate, and it is publicly available to both members of the bar and the public to donate. Next, for our welcome address, we have the Honorable Donna Frett-Gregory, the President of the Senate of the Virgin Islands. And we are very excited to hear from you today. So I will turn it over to Senator Frett-Gregory.
Thank you, and good morning. Can you hear me?
Very well, thank you.
All right, good morning to Attorney Thorpe, of course, and thank you for having me. Good morning to the Virgin Islands Bar Association leadership, coaches, judges, and a extra special good morning to the young men and women who are participating in this year's Moot Court competition. Thank you for giving me the opportunity to speak at the opening of this exciting competition. It is an honor and a privilege for me to speak to you as you begin this year's competition. Moot Court is an annual student event that I anxiously anticipate. In fact, while serving as a commissioner of the Department of Education, the Moot Court competition was one of my favorite student competitions. As a member of the deliberative body of this government of the Virgin Islands, naming the legislature, I understand the importance of conducting research and providing a persuasive argument to get a majority of my colleagues to support my idea. Moot Court allows students to have an immersive experience in putting forth a persuasive argument grounded in facts and laws. Many of us are excellent public speakers, and we can debate facts with proficiency. But what you are about to embark on today not only requires that you speak well publicly or debate facts, you'll be forced to think on your feet. This competition is very much like the legislative vetting process. You will have to take propositions of law and apply these propositions to the facts of the case to make an argument that persuades the judge, the jury, to give you the results you desire. In the legislature, we must be able to convince a majority of our colleagues to vote favorably on an idea we put forward for the measure to, in fact, become law. During the competition, you will be asked questions that you may not have the answer for, or you may hear an argument and begin to question yourself and your ability. But I assure you it's okay. You will not have all the answers all the time, and there may be someone who speaks with more confidence, but your job is to put the work in and believe in your ability and yourself. It's okay to have doubts, but I am certain that you have prepared yourself for this competition, which will enable you to have your best argument. This not only holds true for this Moot Court competition, but it holds true in life. There is no doubt in my mind that I am speaking to future attorneys, judges, politicians, advocates, leaders, humanitarians, and just so much more. Mooting will enhance your critical thinking skills, your verbal communication skills, your research, and your writing skills. It will also allow you to work closely with others for a desired outcome and to learn from your peers. Moot Court is equally intellectually stimulating and rewarding, while also being completely nerve-wracking. So I know that many of you are very nervous today, but you're going to do very well. So I share with you this message on behalf of the members of the 34th Legislature. Best of luck, and more importantly, we are proud of you and what you are about to do. What you have learned preparing for this competition and what you will learn during this competition are lifelong lessons that you will apply many times over throughout your lifetime and in your profession. No matter the outcome of this competition, you will walk well. The mere fact that you are here says that you are all winners. Good luck to all of the participants. Walk with grace today and in the future. Thank you.
Thank you, Senator Gregory. Yeah, that was wonderful, and really, it meets the goal of inviting you. We always try to expose the students to all the branches of government, and you really, without asking, you did a remarkable job of demonstrating how what they learn here is applicable, not just in the judicial branch of government, but also in the first branch of government, the legislature. Thank you very much.
Thank you.
And with that, we will turn to the introduction of the judges. So we have first our representative on St. Thomas, Moot Associate Justice McLean. Attorney McLean was born in Jamaica and graduated high school in Stamford, Connecticut. She received her law degree from Cornell Law School, and she holds a PhD from New York University. She is currently Chief Legal Counsel to the Lieutenant Governor's Office of the Virgin Islands. Justice McLean, do you have anything you'd like to say to the students this morning before we get started?
Good morning. Thank you, Adam. Two things. One, you're good enough, you're bright enough, you're confident. And two, all the best on your performances today.
Thank you very much. Thank you so much. So our second Associate Moot Justice is Attorney Felice M. Quigley from St. Croix. Attorney Quigley graduated Dickinson School of Law in 1985. She currently focuses her practice on mediation, which is a form of alternate dispute resolution, but she does also have a law practice on St. Croix. Attorney Quigley, Moot Justice Quigley, do you have anything you'd like to say to the students before we get started?
Good luck and relax.
Always good advice. Relax. Sometimes easier said than done, but always good advice. Next, our Moot Associate Justice is Gordon C. Ray. Attorney Ray graduated from Stanford Law School in 1974 and began practicing in the Virgin Islands in 1983. He currently practices on St. Croix and is a noteworthy litigator. People regularly, you hear about Attorney Ray's performances in court and his success, and we are very excited to have him. Attorney Ray, would you like to address the students?
Oh, thank you very much. Yes, and congratulations for even having the opportunity to participate in this moot court. It's a real honor. I feel honored as well, and I'm excited about it for this reason. As a practicing attorney for the last 40-odd years, I've argued many an appellate case. I was an assistant U.S. attorney in Washington and argued many appeals up there. And of course, in the Virgin Islands, I argued them both with the Third Circuit Court of Appeals as well as the Virgin Islands Supreme Court. And this is my first time to get to be a judge. And so I hope to be able to put on the kind of performance that I've seen from judges on all of those different courts. So if you think I'm asking questions that sound dumb or stupid, you may be right, but you can't act that way. So
valid. And now to our Moot Chief Justice, Attorney Samuel Hall. Attorney Hall is an alum of Charlotte Amalie High School. He obtained his associate degree in accounting from College of the Virgin Islands in 1968. He then graduated from Harvard Law School in 1975, and he has been admitted to practice law in the Virgin Islands since 1975. Moot Justice, our Chief Moot Justice Hall, do you have anything to say to the students this morning?
Well, I'd like to second what the justices before me said, and I would add that I hope the students have fun. And I would say that on the eve of the confirmation of the first Black woman attorney to the Supreme Court, I find this a really memorable moot court, and I hope it will be for everyone.
Awesome. Thank you so much. With that, I would remind everyone of what the competition is today. So it is the schools are divided up by district. So there are 4 teams competing in the St. Croix district. There are 3 team placements, the championship, second and third place. And then there are 4 individual placements per district: best oralist, first runner-up, second runner-up, and third runner-up. And then those same placements will be awarded for the St. Thomas, St. John, Water Island district. And the top 12 teams overall will advance to the championship round. Individual scores go by the average of the score with the 4 justices. Team scores is the combined total of the 2 participants on the team added together. And with that,
Average is added together.
Sorry, what?
The average is added together.
Yes, the average. And then the 2 averages for the 2 people on the team. Students are evaluated on 5 categories: clarity of presentation, command of factual and legal issues, prepared arguments, responses to questions, and demeanor. Judges, do you all have your score sheets available to you, or do I need to email one here?
I'm fine.
I have mine.
I don't.
Elise has hers.
All right. And I think Felice would be already telling us if she didn't have hers. All right. So Marjorie Raylan is the timekeeper. You will receive a 5-minute warning, a 3-minute warning, a 1-minute warning, a 30-second warning, and time. Be looking in there. She will not speak. When someone speaks, it mutes your argument, and the judges lose the argument. So you have to be looking to watch her. For those who said you can only pin one video, I did contact the court's IT. If that hasn't changed, I would suggest that you pin the timekeeper so that you see the time coming up, because the other video screens, when the judges speak, will automatically move to the front. And with that, we are here with Peter Gruber International Academy appellants. There was a revised schedule sent out yesterday for those who might not have gotten it. I believe all the judges do, but if the teams are wondering what happened, there was an emergency that came up and we did have to rearrange the order. So today, at this time, we should be looking for Attorney Auchincloss and Attorney Zucker. If you guys could turn on your video feeds so we could get notices of appearance. All right. So, Mr. Auchincloss, could you please say and spell your name, the school, the issue you're arguing, and the party you represent?
Yes, I am Jackson Auchincloss. I am from Peter Gruber International, or Virgin Islands Montessori School and Peter Gruber International Academy. I will be representing the appellant, Tommy Z, and will address whether the Superior Court erred when it determined that the best common law rule for the Virgin Islands was to allow minors to disaffirm their contracts and avoid liability. Sorry, I forgot to spell my name. That is Jackson as in nose, Auchin as in nose, CLOSS. You're muted. Sorry, or I can't hear you.
And just for the judges to know, Mr. Auchincloss is actually trapped in transit. He ended up having his flight delayed, so that's why you're seeing him in a car. So he's really doing something quite remarkable today in that regard. Ms. Zucker, could you please unmute yourself and...
Good morning. My name is Amelie Zucker. That's A, M as in Mike, E, L, I, E, Amelie, Z, U, C, K, E, R, Zucker. I attend Peter Gruber International Academy, and I am here on behalf of the appellant, the St. Croix North High School and its principal and vice principal. I will be addressing the issue of whether the Superior Court erred in its findings that St. Croix North High School and its principal and vice principal violated Tracy Flick's First Amendment rights. I'm sorry, you're muted again. You're muted.
You're muted.
Sorry about that. I was just, judges, you all heard that correctly? There's no issues? Okay. Then Ms. Zucker, when you are ready, as soon as you begin speaking, the timekeeper will start the time. You're muted. All right.
Your honors, may it please the court. I ask that the findings of the Superior Court be reversed. Tracy Flick's actions are not protected under the First Amendment, and thus her being expelled was justified due to the fact that her shirt was out of dress code and offensive, that she and her shirts influenced 24 other students to do the same, which materially disrupted the work of the class and invaded the rights of the other students and teachers, and that her violation of rules occurred during class time. The First Amendment and the 14th Amendment, which give citizens the right to free speech and equal protection under the law, are applicable to the U.S. Virgin Islands through the revised Organic Act. However, like in the mainland U.S., not all speech is protected, especially in situations involving public schools. To begin with, Ms. Flick performed, without a doubt, one indisputable violation of the rules, which was breaking the dress code of the school, which was in place both on campus and on Zoom. Thus, the school did have at least one fair reason to punish her right from the beginning. Although I do not think that that infraction was warranted expulsion right away, it does display that she was breaking a rule that was clearly and obviously in place intentionally. Next, the speech on her shirt was not protected under her First Amendment right. In Chaplinsky versus New Hampshire, the court defined what is encompassed in the First Amendment, particularly in regards to clothing. The conclusion was that it does not include words that are, and I quote, lewd, obscene, profane, and defamatory or fighting words, end quote. Although Ms. Flick's shirt did not have any obviously offensive words, the design choice was such as to highlight the words FUT, which is an abbreviation of profanity. Thus, there was a clear intent to use defamatory words. Although the opposition may argue that this rule was not upheld and thus changed in Cohen versus California, where a man wore a F the draft jacket, this was due to the fact that the man's jacket was not, and once again I quote, directed at any reader, end quote. Thus, in that instance, nobody individually could take offense to that jacket in a justified manner. In this case, Ms. Flick is targeting a specific organization, which, may I point out, is a government agency. The school is also funded by the government, so they are closely related. Wearing the shirt in school could be subsequently considered targeted towards the government and thus indirectly the school. With respect to the second point, Your Honors, the school once again did have the right to expel her due to her shirt because, based on the ruling of the court in the case Mahanoy Area School District versus BL, schools have the right to restrict speech that, quote, I quote, materially disrupts classwork, end quote. The case of Tinker versus Des Moines Independent Community School furthermore defined what disruption is in terms of schools to entail the speech that intrudes upon the work of the school or the rights of other students. Ms. Flick's shirts, and when she wore them, did intrude upon the work of and the rights of the other students and teachers, seeing as that in at least one of their classes, their government class, only 25% of the lesson plan was completed in 2 days due to the teacher becoming frazzled due to her shirts.
But isn't that the fault of the teacher and not Ms. Flick?
I think that could be said, Your Honor, but I also think that she was in the wrong at the point she was wearing a shirt that was not customary, considering that usually she would wear a shirt in dress code. So the fact that he would have to address that and the fact that she was already out of the norm, I believe, would excuse him for that.
There was no indication, though, was there, that any of the students were unable to learn, or that their learning ability was disrupted? Is that fair enough?
I believe that it said that the students also were sharing her shirts and talking about it on social media during class time, which would be further distracting them from their schoolwork, and thus also not allowing the teachers to teach as they had to address it. So overall, it was disrupting the whole school. In addition, the government class that was only had 25% of its lesson plan that was able to be completed was an AP class, meaning that it was already on a tight schedule and would affect their grades of the students all more. Thus, overall, her shirts did distract the entire school and violated the rights of the teachers and the students from being able to do their work. The last point I would like to address is the time during which the protest occurred. It was not only in part planned during school hours, but also occurred during school hours. In other cases where a student spoke something considered not acceptable by the school or disruptive like this, it was made clear that one of the primary reasons they won their cases was due to the fact that it did not occur during school hours. Thus, by this logic, the fact that Tracy Flick's actions did occur during school hours should be one of the largest factors as to why she does not win her case. For example, the JS versus Blue Mountain School District case distinguished that part of the reason the students involved, who in that case had posted offensive content about schools officials at home on social media, was because it was not, I quote, on campus or done during campus hours. Ms. Flick planned much of this and also conducted her, as already established, offensive speech during school hours. Although she was technically at home, this is because of COVID-19, which changed many norms, which I believe should be taken into consideration in our times. In the Mahanoa Area School District versus BL case, the court also, once again, further distinguished that when and where something takes place is important. Once again, the fact that it was off-campus speech played the largest role in the student who had not made the varsity cheer squad winning the case. Your Honors, due to the fact that the shirt included offensive language, disrupted the students, teachers, and school environment, and it was planned and occurred during school hours, we respectfully request that you find Ms. Flick's actions are not protected by her First Amendment right, and thus reverse the decision of the Superior Court. Thank you for your time.
I have one other question. Is there anything that the students could have put on a T-shirt that would have expressed their outrage at the grievance they had that would have passed the First Amendment test, in your opinion?
I believe so. If it was not more so targeting and more so asking for improvement. So maybe saying something like asking for perhaps less power outages, something like that, and not just targeting the organization and not explaining it thoroughly on the shirt and doing it in a way that is offensive. Thank you.
So is Ms. Flick, in your view, committing a violation because she recommended that other students wear a similar T-shirt, or is she denied her First Amendment right to speak based on the fact that she wore a T-shirt that you feel was vulgar or somehow in violation of school policy?
I think both, Your Honor. First of all, her shirt was offensive to begin with, and the fact that she then convinced others to do it led to further reasons as to why she should be expelled, which were the fact that it disrupted the entire school.
But the other students had the right to decide or not decide whether they would wear a similar T-shirt. Isn't that right?
Yes, Your Honor. And I do believe that they are also at fault, but the fact that she started it does mean something.
All right.
Question for you, Attorney Zucker.
Yes.
I believe you said earlier, you made a reference that the writing on the T-shirts were offensive and shorthand for obscene. Mm-hmm. But what is obscene, objectively obscene about the words "forget you"?
If you look at the shirts, the words F, U, and T are capitalized. So when you look at it, it jumps out at you as FUT, which, although it's not directly profanity, I've saying that the intent is there and it is obvious to anybody seeing that it is targeted.
So are we to penalize intent?
I believe that if it is defamatory, which it is, because it says FUT, then yes, it should be penalized.
And how is it defamatory to say forget you T, regardless of which letters are capitalized?
I don't think that part, if you disregard the capitalization, is offensive, but if you look underneath it, I believe it says you suck, which is not a very polite and also defamatory thing.
So is it your position today that Ms. Flick should be denied access and entry, schooling, education in a government institution because she said something that was not nice? Isn't the goal of the First Amendment to protect even speech that is not nice?
I believe that perhaps expelling her was extreme, but I do think that she should be punished and that her actions should not be forgotten, as they were with the decision of the Superior Court.
But if we do as you urge here, which is to overrule the Superior Court, to reverse the Superior Court's ruling, she would be expelled, even though you just admitted that ought not to be the case.
I think you bring into consideration very good points that I had not entirely thought about. So I think that perhaps a new decision would be in order, something that is more lenient with her, but also not entirely excusing her actions.
Thank you, Attorney Zucker.
Thank you.
All right, with that, our time is up and we will be giving the judges please give me the okay, whatever sign when you complete your score sheet. And we will be having Mr. Auchincloss speak next once the judges are ready to go. Okay, let's see, Gordon's got it.
I'm done.
All right. Justice Hall. Quigley. And McLean. All right, Mr. Auchincloss, it is your turn.
May it please the court. The judgment of the Moot Superior Court should be reversed because the court erred in finding that the bank's analysis favored, as a rule of the territory, allowing minors to disaffirm contracts after reaching the age of majority. And, even if deeming such a standard proper, Tracy Flick never in fact disaffirmed her contract with Tommy Z, thereby inducing him to expend resources in order to complete her order. In regard to the first point, the bank's analysis decision should be overturned. In today's society, it's simply not practicable for contracts or agreements like this, the one in question, to be voidable after age of majority is reached. It is not reasonable for minors to have responsibilities as large as buying a car, becoming a parent, defending one's country, or having a job, and yet still remove them from responsibility for a contract or agreement. No, it's really not. For example, is it okay to accept that minors can take on the responsibilities of starting their own business, as happens more and more often nowadays, and yet not accept that they can take on the responsibility of being in a contract? Owning a business itself consists of many contracts, and the court could be setting a dangerous precedent of minors taking advantage of the sport of voidable contract law with any of number of things, from money to services. My second point is that Tracy Flick was the age of majority when her parents disaffirmed her contract for her. However, even if this court sustains the rule as established by the lower court, Tracy Flick had reached the age majority before the contract was complete. Here in the VI, the age of majority, as stated by Statute 16 VIC, Section 261, is 18 years of age. I'd like to draw the court's attention to several facts about the case, including the fact that Tracy Flick was 17 on April 13th, which is when she made the deal for the t-shirts with Tommy Z. Also, that the day that Ms. Flick reached the age of majority was 6 days after, on April 19th. And finally, that the t-shirts were ready on April 20th, one day after Ms. Flick turned 18. According to Section 261, after turning 18, a person shall, quote, have control of their own actions and business and have all the rights and be subject to all the liabilities of persons of full age, end quote. Yet, Ms. Flick never disaffirmed the agreement. What is worse, Ms. Flick knew that she no longer wanted the shirts, well before Tommy Z produced the garments. A simple notice would have removed Ms. Flick from any responsibility and saved Tommy Z from expending sums on an order no longer desired. But Ms. Flick's actions show no intention to disaffirm. Indeed, the only parties who advised that the contract was no longer wanted were her parents, Mr. and Mrs. Flick, and then only because Tommy Z contacted them. At that time, Tracy Flick was the age of majority and was therefore subject to the liabilities that come with being a legal adult. Additionally, Ms. Flick filed a suit against St. Croix North High School on April 20th, further affirming her status as a person of majority. It is simply unacceptable that she exercises her rights as an adult when it is to her benefit and then turns around and denies her liabilities exist when it is to her detriment. Next, Ms. Flick never officially disaffirmed her contract. According to the case, Kiefer versus Fred Howe Motors, quote, any act which clearly shows an intent to disaffirm a contract or sale is sufficient for the purpose. From the case Engelbert versus Troxel et al., quote, deeds by a minor are not void, only voidable, and, end quote, and, quote, to avoid them, he must, by some act, clear and unmistakable in its character, disaffirm their validity, end quote. Did Miss Flick ever disaffirm her contract? No. Her parents did in her stead, who, as previously stated, had no authority to do so, her being a person of majority. Finally, Tommy Z should be made whole for the t-shirts produced to benefit Miss Flick. Even assuming arguendo, the communication of her parents could affirm the agreement on behalf of Miss Flick, the money spent to fulfill the order for Miss Flick's benefit are due and owing to Tommy Z. In conclusion, the decision of the Moot Superior Court should be reversed because the decision in the bank analysis was unreasonable. Tracy Flick was of majority age when Tommy Z fulfilled the contract, an agreement she herself never disaffirmed and caused the expenditure of funds for her benefit that should be reimbursed. Thank you.
Why was the bank's analysis even appropriate? I mean, isn't public policy something that a legislature states? And in this case, there was no legislative statute that determined what the liability of a minor would be?
Yes, so the bank's analysis was necessary to rule whether, to analyze whether it was favorable or unfavorable to adopt sections 12 and 14 of the second restatement of contracts, which would define whether a minor was liable to a contract in certain conditions.
So is it your position that this court should do a bank's analysis even in areas where the legislature hasn't enacted some rule that indicates the direction of the law?
Yes.
Okay. And that's why you think it's unreasonable?
Let me understand something. Is it your position that someone who is not yet 18 years old does or does not have the authority to enter into a contract?
It is my position that they do have the authority to enter into a contract, and until they reach the age of majority, have the authority to void the contract. But once they reach the age of majority, they no longer have the authority to void the contract.
And where is the legal authority that leads you to believe that in the Virgin Islands, people who are under the age of majority, who are under 18, do have the authority to enter into contracts?
I am sorry, but I do not know the answer to that.
Okay, very good. And just finally, is there any age at which you say someone would be too young to enter into a contract? 12 years old, 10 years old?
Would this be me personally or?
As a legal principle across the board.
I'd say that there probably be some requirement of or level of understanding that an infant would need to enter into a contract. They should at least be able to read the contract themselves before they enter into it, and fully understand what they're getting into. So yes, I think there should be a necessary age for someone to enter into a contract.
So I take it then you'd ask for a judicial inquiry into whether or not the minor entering into the contract understood what they were doing and wanted to do it. Is that your position?
Yes, I think that would be reasonable.
Okay.
Do you think there's any responsibility on the part of the shopkeeper or on the part of a third party to determine whether or not someone is of the age of majority before they enter into a contract like this? I mean, in this case, there was quite a few T-shirts ordered, quite a few. And I would think that perhaps there would be some responsibility on the part of the vendor to establish whether or not this was something that the person who was ordering the goods was able to do in the first place. What do you think about that?
I definitely think it is the responsibility of a shopkeeper to ensure that their client is above the age of majority if they're worried about cases like this happening. But I don't think that Tommy Z was worried about this, and also because the Miss Flick heard that, or Miss Flick found out about her not wanting to use the T-shirts on April 14th, which is one day after she made the agreement with Tommy Z. The T-shirts weren't even ready until April 20th, so she had 6 days to disaffirm her contract with him, or even just say, I would not like to order these T-shirts anymore. And he most likely could have gotten the order canceled by that time. So I think it's not Tommy Z who's at fault here, but Tracy Flick.
Thank you.
All right, with that, we will let the judges finish their score sheets, and our next team will be St. Croix Educational Complex appellees. Each year, the teams have to have a minimum of 2, and they are allowed to have up to 3 person per squad. This year, this team of appellees had an alternate. Ellery Monsanto was the alternate. She will not be arguing today, but she is a member of the team, and we do want to recognize her participation and efforts. Azaria Providence and Kiana Alphonse, are you both ready to make your notices of appearance now?
Yes, we are.
All right. The judges are still scoring, so just hold with us for a second.
I'm done.
All right.
And then
I'm all finished.
All right, we're just waiting on
All right, the race is ready.
All right, so Ms. Providence, please say and spell your name, school, party, and issue.
Good morning. My name is Azaria Providence, spelled A-Z-A-R-I-A-H. P as in park, R-O-V-I-D as in dog, E-N-C-E. I am from the St. Croix Educational Complex High School, representing the appellee team. The issue I will be presenting is whether the Supreme Court erred in its finding that the St. Croix North High School and its principal and vice principal violated Ms. Flick's First Amendment rights.
All right, and Ms. Alphonse, could you please give your notice of appearance?
Good morning. My name is Kiana Alphonse, which is Keanna Alphonse, ALP as in Park, HONSE. I am representing the St. Croix Educational Complex High School, and I am on the appellee team. The issue I will be addressing is whether the Superior Court erred when it determined that the best common law rule for the Virgin Islands was to allow minors to disaffirm their contracts and avoid liability.
All right, and with that, Ms. Providence, could you, when you begin speaking, the time will begin to run.
Good day, may it please the court. Your Honors, we live in America. The Virgin Islands is a U.S. territory. In America, we are guaranteed the constitutional right to freedom of speech. But in this case, Ms. Flick was wrongfully robbed of this right. According to the U.S. Constitution, Ms. Flick should have been well within her rights to express her displeasure with the Territorial Electrical Agency. The First Amendment gives citizens the right to petition the government for a readdress of grievances. The multiple hours without electricity that is being paid for, is quite the grievance. Coming from a student who trusts her school to be a safe place to learn and grow, Ms. Flick's efforts should have been examined, and her teachers and administrators should have gave her the proper platform. Under the First Amendment, students have the right to criticize the government. Our First Amendment right does not stop at the schoolhouse gate. The judgment of the Moot Superior Court should be affirmed for the following reasons. Ms. Flick evidently wants to learn. She was not expelled because she broke a school rule. Her protest contained no profanity or vulgarity. And she wasn't given any warnings or progressive punishments prior to her expulsion. What child do you know gets expelled for expressing her concerns on an issue that is solely school related? The first point I will be addressing is the simple fact that Tracy wants to learn. Many students take advantage of power outages and do not attempt to continue with virtual learning for the time being. Ms. Flick evidently cares about her education because she made the effort to create a sign, got her entire civics class involved, and both her and her peers put their money together to carry out the protest. Prior to the class deciding to make the t-shirts themselves, Ms. Flick took it upon herself to contact Tommy Z and have the shirts professionally printed. No child who does not want to gain knowledge will go through everything Ms. Flick did. This leads me to address the fact that Tracy did not use any profanity or vulgarity in her protest. Nowhere in the fact pattern does it state that her actions contain obscene language or that she had an ulterior motive. A public high school cannot constitutionally prohibit a peaceful student protest consisting of pure speech on school property during the school day.
So is your argument in favor of Ms. Flick that she was actually doing a good thing by expressing concerns that people should attend to? Is that
yes.
Your position?
Yes.
What if this had been a private school? Would your position be any different?
Yes, it would be different because public schools would have different stands than private schools would have. So for example, according to Primary Authorities Part 1, a public school cannot stop pure speech on the school property, but a private school's rules would be different from public school.
Okay.
Did she have less disruptive ways to express her dissatisfaction? Were other ways available to her?
Absolutely. She could have gone about it in a different way, but the issue here is that her punishment was too extensive for what she did. So she could have got progressive punishments or perhaps been talked to before she was expelled.
Mm-hmm. And would there have been worse ways for her to do it than she did?
Absolutely. She could have actually done it. Perhaps it could have been a week-long protest. She could have completely told the class not to log in at all to their classes. It could have gone completely worse than it did. So she handled it in a good way.
Okay, and understanding that, then where would you say the line should be drawn as to what is okay and what's too extreme?
So the line should be drawn as far as what disrupts the class. So if what she did, and as far as what the teacher permits. So if she had got her civics teacher involved and he gave them the okay, then it could go on in class. But the line should be drawn as far as what the teacher or administrator gives them permission to do. So I also plan.
Oh, please, I'm sorry, go ahead.
Referencing the JS versus Blue Mountain School District case, which is in Primary Authorities Part 1, page 47, JS was suspended for 10 days because of a MySpace profile she made mocking her school principal. The court held that the school's punishment for JS was permissible because her profile was vulgar and offensive, and JS was suspended for 10 days for making this profile. Whereas Tracy's flick shirts had no vulgarity or offensive nature, yet JS was only suspended for 10 days for making an inappropriate profile regarding her principal, and Ms. Flick was completely expelled from school during her senior year for voicing her concerns about the conditions of her online learning experience. Next, I would like to point out that Tracy was not expelled because she broke a school rule. She was expelled because Principal Rooney found the impact she had on her peers intimidating. He said, and I quote, "I don't trust this kid any further than I can throw her." What is so dangerous about—
Let me ask you about the harm that's at issue here. Is the harm Ms. Flick's fault that the school teacher became frazzled and frustrated and couldn't finish his lesson plan? Is that something that should be in the column against her, as opposed to the public interest that she was positively trying to stimulate?
Absolutely. So in the fact pattern, it does state that Mr. Keating, the teacher, is who held the discussion. Ms. Flick never asked him to address it. She never said anything. He saw the teachers and decided to hold a discussion. So it should be taken into consideration that the teacher is who stopped the class, not Ms. Flick trying to disrupt it herself.
Should we consider, as it important, Ms. Flick's intent, whether or not she intended to disrupt the class or whether she simply intended to make a different point that she was protesting about?
Yes, we should consider it because her intent was to bring light to a situation that the school had yet to address. So one of the reasons she also probably didn't go to the school was because they were being affected from the power outages as well, but nothing was being done. So she brought light to an issue that affected her, her classmates, and the school overall. Next, I would like to point out, again, that she was not expelled for breaking a school rule. Principal Rooney found the impact she had on her peers intimidating, and Vice Principal Vernon agreed, and this is why she was expelled. The fact pattern is vague in stating what troublesome events Tracy Flick had done or encouraged in the past, if any. However, it does state in the last paragraph of the last sentence of paragraph 1 that she organized a memorial service for her friend and classmate Jay Peterman in 2018, which is an extremely positive gesture. So based on the facts we are given, it was never identified what Tracy did that caused Principal Rooney to see her as such a threat to his authority or why he thought expulsion was necessary. Tracy was also not given any warnings or progressive punishments prior to her expulsion. Nowhere in the fact pattern does it state that Principal Rooney or Vice Principal Vernon spoke to Tracy one-on-one or contacted her parents prior to expelling her. She wasn't given anything like detentions or community service hours to gradually make up for her actions. How fair is it that she was expelled for trying to voice a concern about her schooling?
Attorney Providence, are you suggesting that it is okay for Ms. Flick to have an issue with T and yet express that concern in the learning environment? Why would she not express it at T? Why not demonstrate in front of T headquarters?
She didn't do it at TA because it wouldn't have the same impact it has at her school. At TA, they're not guaranteed to listen to her. At school, she gains the support of her peers, her teachers, and again, she brings light to an issue that the school had yet to address.
But isn't that exactly the problem? That Ms. Flick wants to, as you say, gain the attention of her peers. She's on social media texting. She's
All right.
I think we're frozen.
Yep, looks like she's frozen.
losing.
Yeah.
Oh,
Did we lose?
I think you're
Yeah, you
back.
froze.
yeah, you froze, Delace. Go ahead with your question.
Oh, I'm sorry. Everybody else froze to me. Miss Flick's actions, can we not consider them a teenage girl's attempt to raise her popularity in school with her friends and her peers?
No, Ms. Flick's intent was to shed light on an issue that was affecting her students. As it said in the fact pattern, she was already well known around the school for great things she's done prior in the past. So trying to gain popularity wasn't her intent at all. She just wanted to learn, and it was her senior year. So she wanted to learn as much as she could and shed light on an issue that had not been addressed as yet.
Wouldn't there have been a more productive and less intrusive manner in which Miss Flick could have accomplished this?
Yes, absolutely. The issue here is not that we do agree that she could have went about it in a different way, but we think that the way she did went about it was not warrant expulsion. She should have been talked to by the principal, vice principal, or even an administrator if they felt her actions or anger was misplaced. But the punishment she was given was not warranted what she did.
Well, is there any case law or rulings that support your position?
Yes, actually. The one I mentioned with JS versus Blue Mountain, she created a MySpace profile with vulgarity, and she was only suspended while Ms. Flick was completely expelled. Then also in another case, I see my time has come to an end. May I please conclude?
Yes, please.
Okay. Your Honors, the expulsion that took place drastically affected Ms. Flick, as it impacted her admission to college, eligibility for jobs, and ideally her entire future. Therefore, I hereby suggest we affirm the court's decisions. Thank you.
All right. As always, judges, give me the sign when you are finished with your score sheet. And Ms. Alphonse, get ready to give your arguments as soon as the judges are done with their scoring.
Okay.
All right.
I'm done.
All right.
I'm finished.
Okay.
Good morning, Your Honor.
Yes, go ahead, Ms. Alphonse. I apologize.
Good morning, Your Honors. May it please the court? Your Honors, the judgment of the Moot Superior Court should be affirmed. Tracy Flick was a minor. Even though she was 17 years old, she is still a child. As a local business owner, Tommy Z should set an example. Although she was very close to the age of being a legal adult, Ms. Flick was still a student in the local school system, being taught how to navigate the real world. She has the rest of her adult life to be bound by restrictive contracts and unbending regulations. At the time of the incident in question, Ms. Flick, she was a high school student, healthily exploring her rights to publicly defend her education. There was no malicious intent when Ms. Flick made the order from Tommy Z. She was simply provided with new information, forcing her to change her plans. Ms. Flick should not be held accountable for a number of reasons that can be summarized as such. The consent of a minor is not enough to base a contract, especially when there was no witness present, and there were no contractual protocols followed. Starting with reason 1, the fact pattern states that Ms. Flick was 17 years old, which means she is a minor. Referencing the Galvin versus Hess Oil Corporation case, it reads that all persons are deemed to have arrived at the majority age of 18 years, and thereafter shall have control of their own actions and businesses and have all the rights to be subject to all the liabilities of persons of full age. In this case, Ms. Flick could not be held liable because she is a minor and she had not yet reached her majority age. Also referencing the Banks case, the Virgin Islands in this case decided that the best rule to adopt is that a minor cannot enter a contract. Nowhere in the fact pattern did it state that Tommy Z asked her for an ID, nor did he ask her for a deposit. And it is common knowledge that when you're making a product that consists of materials, you ask for a deposit to cover at least a percentage so you can get started on that product. It also did not state that there was an actual written agreement for her to follow through and what would be her consequences if she did not follow through. As a minor being close to the age of a legal adult, I cannot just go in the gas station and decide I'm going to buy a heavy alcoholic drink, because then the worker in the gas station would then ask for my ID to know that I am a minor, and she would then prevent me from buying that drink. It is illegal to enter a contract with a minor. A contract is an agreement between two or more consenting parties. The general rule reads that the underpinnings of the general rule allow minors to disaffirm his contracts were undoubtedly to protect the minor. The adult may be taking advantage of the minor instead of using good judgment because the minor may be young and naive. It is also widely accepted that a minor's consent is not considered legal consent. We can speak about statutory rape, and whether the minor gives consent or not, the adult is still held liable because the adult should have good judgment. In this case, Tommy Z did not use his good judgment to prevent.
Attorney Alphonse, is it your position that people over 18 who enter into contracts with people under 18 are automatically taking advantage of those younger persons?
No, Your Honors. However, in my position is arguing that there are certain protocols to follow. And whether 18 or not, you are to ensure that this person knows what is taking place and what would happen if they don't follow through or what's going to take place in the contract. In this moment, Ms. Flick did not have this opportunity as the fact pattern did not state so.
Well, Ms. Flick was very deliberate. She was very calculated. She knew what she wanted to do. She ordered these T-shirts with the full intent to purchase and distribute them to the students. She only got sidetracked because she heard that the administration might be coming down on her. Why should Tommy Z have to suffer because she changed her mind?
It's not a matter of suffering, but a matter of he did not follow protocol. Even though Ms. Flick made the order, as I stated, there was no actual written agreement that was listed in the fact pattern that she was to follow protocol or what would happen. The right procedures weren't taken to ensure that if she decided that she was not going to follow through, what would happen.
But we are told that Ms. Flick and Tommy Z had an agreement on April 13th of 2020. And they even agreed not just how many T-shirts, but we can presume the cost of those shirts because she was going to pick them up on Monday.
It stated that there was an agreement, but it didn't state that there was an actual written agreement. And also to address that she was a minor, even though she is close to the age of being a legal adult and well calculated. As a human, sometimes you may not know certain things. So she may have just thought that she was putting in the order and there was no confirmation. So since there was no confirmation stating, even though there was a date given, that maybe just because she didn't confirm her decision, that the order would have just been discontinued.
So are you suggesting that with every agreement or every contract, it has to be in writing? or that there's a responsibility on the part of both parties to confirm their agreement after they have entered into a preliminary contract?
Yes, Your Honors, that is what I'm stating, because as I stated before, if you're making a product that consists of materials, you need a deposit. There was no deposit listed in the fact pattern. So maybe Ms. Flick may have just thought, as I stated, that she didn't need to discontinue the order because she didn't know if he started it or not, and there was no confirmation. Communication has to be held in order for stuff to be proceeded, and Ms. Flick and Tommy Z both did not hold good communication. However, that falls on Tommy Z because he did not follow protocol.
I'm sorry, please go ahead.
Go ahead.
Okay, I was going to ask, does it matter what was in Tommy Z's mind? In other words, did he have to know that she was not 18? Or what if he reasonably believed that she was 18 or above because she looked mature, spoke maturely, and seemed to know what she was doing? Does that make a difference?
Well, it does make a difference. However, Tommy Z knew she was a minor because when she made this contract, he did not contact her parents, but he knew to contact her parents when she did not pay. And if you're considered an adult or at your majority age, if you do not follow through with something, they don't contact your parent. You only contact parents when it's a minor. And in this case, Tommy Z knew exactly what was taking place, which is why the fact pattern didn't state that he contacted her, but he contacted her parents straight.
Do you know if he ever saw her when this transaction was being made? It's not clear to me whether or not they were face to face and he could see what her age was, or whether or not this was all done by phone. And so he never really saw her and had no reason to believe that she was under 18.
Well, Your Honors, yes. The fact pattern was very vague on that clarity. However, it did state that he contacted her parents when she did not pay, which is safe to assume that he did know she was a minor, because minors are under the care of their parents or guardians. So why would you contact their parents if they're not a minor?
Well, if you're an 18-year-old and you're in high school and you're not paying, and you're a businessman, wouldn't you contact the parents of that child even though they may be above 18?
I would contact the child first, and then I would contact their parents. However, whoever you enter a contract with and you make your business deal with, you must have direct communication with them first. It never stated in the fact pattern that he tried to contact her and he tried to make her pay, and then he proceeded to asking her parents for the money or as to why she did not pay.
Would it make a difference to you if Ms. Flick had made 30 prior orders from the time she was 14 up to 17, and she paid for them and she received the goods, but this one order, she didn't pay for it? Would there be any modification to the best rule that should take that into account?
Yes, Your Honors. Ms. Flick could be held liable for not paying for the order, but she can't be bound by a contract because she's a minor. In the order that she may have paid for, maybe she had direct response. She didn't have a reason to change her plans. And so proceeding with her orders and getting them would be a different impact as to her not paying for this order because she was trying to defend her education and her plans were changed.
So under what's the support for enough is enough? You know, she's done it a number of times correctly, rightly, and this time she doesn't do it. The liability protection should not apply. What's your rationale?
May you please repeat?
What is the rationale for making an exception if she had a prior history of payment with Tommy Z?
Well, that in cases she always followed protocol, she always proceeded with her business orders, she always took responsibility. But in this one case, because she's a minor and she probably didn't have the right guidance because there was no parent there to guide her. that maybe that this is not her fault. She can't be held liable if there was no proper guidance. Or may I finish answering the question and conclude? If there was proper guidance, Ms. Flick would more have likely to proceed with this order or to know that she had to have direct communication to cancel it. In conclusion, Tom is the neglected protocol and Ms. Flick should not be held liable. We ask that you respectfully affirm your decision of the Moot Superior Court to ensure our minors are directed in the right direction. Thank you.
Thank you. While the judges are completing their score sheets, could we have All Saints Cathedral School appellants come up and get ready? This year, Ariana George served as the alternate on this team. She will not be arguing today as the two primary members of the team will be, but we do want to recognize that she participated and is fully prepared for this today as well. Judges, obviously, give me the go-ahead sign when you are done with your score sheets. All right, Gordon, Felice and Gordon. McLean Hall. All right. Annadelle Brown and Dejanay Boland. Ms. Brown, can you please say and spell your name, the party you represent, your name, school, the party you represent, and the issue you're arguing.
Good day. My name is Annadelle Brown. A as in apple, N-N, A as in apple, D-E-L-L-E, B-R-O-W-N. I am a part of All Saints Cathedral School, and I am the appellant representing St. Croix North High School's principal and vice principal. As the Supreme Court should overturn the decision of the Superior Court, as they're incorrect in finding that St. Croix North High School's principal and vice principal violated Ms. Flick's First Amendment rights.
All right, and Ms. Boland, please enter your appearance.
Good morning, my name is Dejanay Boland. It is spelled D-E-J-A-N-E-E, B-O-L-A-N-D. I'm representing All Saints Cathedral School, and the issue that I will be representing is whether the Superior Court erred when it determined that the best common law rule for the Virgin Islands was to allow minors to disaffirm their contract and avoid liability.
All right, thank you. And Ms. Brown, you are up first. As soon as you begin speaking, the time will begin to run.
Good day. May it please the court. Your honors, the Supreme Court should overturn the decision of the Superior Court as they were incorrect in finding that St. Croix North High School's principal and vice principal violated Ms. Flick's First Amendment right. The principal and vice principal of St. Croix North High School had a right to expel her because her conduct was significantly disruptive. She disobeyed the school dress code policy, and the language displayed on her shirt incited a school-wide disruption. They had a right to take action against her and enforce the rules upon her. As stated in Chaplinsky versus New Hampshire, the constitutional right to free speech is not absolute. As the rule in Chaplinsky states, the government narrowly limits classes of speech in cases of speech that is lewd and obscene, the profane and fighting words, which by their very utterance tend to immediately breach the peace. In Mahoney, the court held that schools may regulate speech that is indecent, lewd, or vulgar on or during school assembly or on school grounds. As for Get You, TEA, You Suck is lewd and vulgar. It should stand that this school should be able to regulate and enforce the rules and enforce the rules upon Ms. Flick for this statement, for making this significant disruption and displaying it during school hours and a place that is an extension of school. Public institutions have a right to punish students who cause a significant disruption in school, as stated in JS versus Blue Mountain School. St. Croix North High School's principal has said she jeopardizes his ability to effectively govern the student body. While the court found that Blue Mountain School was wrong for punishing their student where the conduct had taken place on the weekend and off campus and did not disrupt active classes, here the student, Miss Flick, was on campus by extension of it being on Zoom, used specifically for classes on a school-issued computer, and it was disruptive to active classes. We're able to fully recognize this fact due to the AP Government and Civics teacher, Mr. Keaton, not being able to complete more than 25% of his lesson plan during the 2 days that the students wore the shirts.
Let me ask you a question here, if I could. I know she was suspended. Why would she be suspended, but all of the other students who wore exactly the same T-shirt were not expended? As a matter of fact, as far as I can tell, nothing was done to them at all. Is that right? They were all saying the same thing through their T-shirt, everybody, but yet only one of them was punished.
Well, yes, Your Honor. Everyone was wearing the same shirt, but Ms. Flick is the leader of this movement. She was the one who caused this significant disruption in the first place. It should stand that the school should be able to punish the leader to cause the movement to come to a halt. Not only did it interrupt lesson plans, but it also interrupted all the classes throughout school, leading to a school-wide disruption. Therefore, they had a right to discipline her. Additionally, as seen in Tinker, the rule that came out states that school officials may forbid or punish conduct that materially and substantially interferes with the requirements of appropriate discipline in the operation of school. While in Tinker, it was a silent political protest against the Vietnam War. Here, where it was only a distraction to the principal, here Ms. Flick's actions were shown to materially and substantially interrupt classes, causing several teachers to lose track of their lesson plans and interfering with the school due to the students sharing on social media during school hours. Therefore, Your Honors, St. Croix North High School's principal and vice principal had a right to enforce the rules upon Ms. Flick for her significantly disruptive behavior that has been shown to break school rules and disrupt the entire school.
Was there a point where she was told, say when she first showed up and the other students showed up wearing that shirt, were she or they told, look, you can't wear that here, go change your clothes, otherwise there's going to be some penalties? Were they given a chance basically to change their activities?
Your Honor, during the class discussion with Mr. Keaton, he addressed the situation of the school shirt that was breaking school policy rules. In that whole discussion, Ms. Flick should have taken it upon herself to realize that that is a breaking of the rules and she should take off the shirt and stop this movement. That whole discussion was her warning.
Okay, thank you.
Was there any attempt at all to discuss with the teachers that were disrupted why the whole disruption occurred? It would seem to me that these teachers have been practicing for quite some time and that they could have paraded through despite the distraction of the shirt. I mean, I don't see that in the fact pattern, but was there any attempt of Principal Rooney to address this with the teachers as well as the students?
Your Honor, with such a massive disruption, causing everyone to just be distracted and overwhelmed with the entire student body just coming on and bandwagoning off of this movement by Ms. Flick, it would seem that he had not had the time to address this and decided it was the time to expel her to stop this disruption and make it clear that there is no way to break rules in this movement. You need to understand that rules are an impossible thing to put in place and that she should not have broken the rules.
So if any other students were to come to the school and express their ideas about issues either in the school or outside the school that were contrary to what the school thinks is let's just say it's inconsistent with protocol or inconsistent with the rules of the school, you think it's fair to stifle a student's ability to express themselves?
While, Your Honor, I do not believe a school should stifle a student's ability to express himself, I do believe the school has a right to stop a movement that is not appropriate for school time during school hours. As we've seen, Ms. Flick decided to take an outside problem and put it inside a school classroom, a place where it does not have any right to be. So if anyone comes outside to address this matter in the school, it should stay outside, as for it was an outside matter that had nothing to do with school or classes.
Well, it didn't actually have a lot to do with learning and with the school, because the disruptions that led to this outbreak were affecting the ability of kids to go online to learn.
Your Honor, if a child misses a part of their classroom, or if they miss a part of class, a teacher should hold that they should be able to express and spend out PowerPoints or emails or lesson plans that allow the student to be able to catch up due to the interference. A teacher should be able to work around these problems.
What happened if this issue arose not as a result of power outages, but rather because the monitors at the school were causing problems and Ms. Flick came in and expressed an opinion by wearing a t-shirt because of a monitor issue? Would that have been more confined to a school issue than an outside issue in your mind?
Yes, Your Honor, I do believe that being more of a school issue. But in that case, she should have taken it up by emailing a teacher or letting someone of school administration know there's a problem with the monitor and she needs it to be changed. Not starting a movement by immediately writing vulgar words on a shirt and displaying it during school hours.
Thank you.
All right, and that is time. Judges, work on your score sheets, and Ms. Boland, please come up and get ready to present your arguments when the judges are ready.
Adam, I've lost the visual contact.
Oh, we can see you still.
Well, I'd like to be able to see the student.
I am not a tech person. What you might try doing is leaving, and I can admit you again. That might restart.
No, we're back. I think our video went out for a second. Apologies from all.
Oh, okay.
Went out for a second. I apologize. This is Tina Comisan. All
right.
And we're back up.
I'll leave the.
We should be good to go now.
Oh, okay.
I think our video went out for a second. I apologize for that.
Yeah, I think it did, but I think his went out too. If you didn't notice it, he ended up with an icon displaying, and that was it. So I think he had something going on.
Okay, thanks.
Let's see here. He should be back in pretty quickly. All right, just looking here.
Only lost it there. Yeah.
I can see Ian Gordon.
I see on my upper part, but a purple box with S in the middle of it popped up in the middle of my screen.
Yeah. Can you see everything, Chief Justice Hall?
I can see you, Adam.
All right. And All Saints, can you speak?
Yes,
Can you
Okay.
see them in there?
testing, testing.
Yeah, mine's back on normal now.
How about you, Sam?
I'm still on one person. It's
I wonder, maybe in the top corner of your screen, if you move your cursor to sort of the top right,
mm-hmm.
And it says view, try gallery view.
I'm on an iPad and I don't
Oh, shoot. Okay.
I don't see gallery view. I see participants.
Yeah, I don't work on an iPad, so I don't know. All Saints, can you make some noise and see if Zoom moves you to the top again?
Testing, testing.
Do they appear for you when they do that, Sam?
I can, well, I saw the student just before you came back on.
Okay, I will be quiet during this, and so you should be able to see them. So I believe everyone should be done scoring, and when she starts talking, you'll be able to see them. So with that, unless the judges are stopping me, Ms. Boland, when you start speaking, the time will start running.
Good day. May it please the court. The Superior Court was wrong in determining that the best common law rule for the Virgin Islands is to allow minors to disaffirm their contracts. In the Virgin Islands, minors are held responsible by the courts and by the laws made by the legislator for a variety of actions. Minors can be tried as adults in criminal matters, and minors can be held liable for accidents they cause as they drive. Therefore, the courts in the Virgin Islands recognize certain things minors are responsible for. Entering a contract to make t-shirts requires less responsibility than driving a car. If she could be mature enough and held responsible for driving a car, she is mature enough to be held responsible for ordering t-shirts and should be held to pay for them. There is a public policy interest in the Virgin Islands for ensuring that minors are not taking advantage of businesses and causing them to lose money by recklessly entering into agreements that they do not intend to honor. Although the Superior Court did undertake the required analysis, this case demanded by conducting a Banks analysis as outlined in the decision in Connor, they got the third part of the analysis wrong. They properly noted that the courts here had not adopted a particular rule and that the slight majority of courts in other jurisdictions do allow minors to disaffirm their contracts, but they then were incorrect in determining that the best rule and soundest approach for the VI was to allow minors to disaffirm their contracts in a reasonable amount of time. There is a public policy interest in the VI for holding minors accountable for their actions and responsible for entering contracts when they are mature enough to do so and do not come back to cancel them upon turning 18. Even though the legislator did not change the language of the law specific to contracts, they have begun to move in that direction and have recognized that the best rule for the Virgin Islands is to hold minors accountable for certain things. The court in Bagley got it right. A person who enters into an agreement just a few days shy of turning 18 is mature enough to be held accountable, especially if they never came back after turning 18 to cancel it, and they should be held responsible. This concept and policy is the best common law rule for the Virgin Islands and is what the Superior Court should have rightfully decided here. If you represent yourself as a mature adult, but capable of making the purchase, and are just a few days shy of turning 18, you should be held responsible for paying for it. Similar to Bagley, Miss Flicks was almost 18 and she didn't go back to cancel it before the shirts were made, so she should be held responsible for paying for them.
In Engelberg versus Troxel, the court said that a contract should be voidable if the services hadn't already been provided. In this case, Tracy Flick signed a contract and Tommy Z incurred the expenses of making the shirts based on her representation that she was capable of placing the order and entering the agreement. She did receive a benefit, even though she hadn't yet picked up the shirts, as she had them printed and prepared at her request. There is an important public interest in protecting the person who spent money to create the order or perform the services.
Let me ask you a question here, if I could. Is there any age at which you'd say someone is too young to enter into a contract? What about an 8-year-old or a 12-year-old? And how are we to determine that?
Your Honor, in this case, she was just a few days of turning 18, which showed that she had the capabilities of being responsible to handle this contract.
Okay. So is it a case-by-case analysis that a court should make as to how mature and adult-like a person is to determine whether or not they have the capacity to enter into a contract? Or is there a bright line rule that says 15, 17, 18?
Your Honor, in the Virgin Islands, there is not truly a clear state, a clear law, my bad, that says that a person that is just 17 or 18 can disaffirm this contract, a contract.
Mm-hmm.
So there is not a clear statute to defend that.
So what should our rule be?
Our best rule should be like if they look mature enough to handle this contract, they should be liable for it.
And do we determine if they look mature enough based upon what in this case, the businessman perceives? Or should we as judges stand outside of all of that and look at other factors?
Your Honor, I believe that in this case, Tracy, she came to the businessman and he took her as a person that could have been responsible for the situation. So if you look responsible enough, you should be held liable because of the way you represent yourself. And she was just a few days of turning 18, which shows the capabilities that she could be responsible.
Did the businessman have any obligation to ask her how old she was?
No, Your Honor, he did not. But her representation showed that she could handle this contract.
Okay, thank you.
In Porter, the court required the minor to pay for the benefits he received. The court decided that even though a minor may disaffirm a contract, he or she is still liable for the expense they created. Hence, here, Tracy should be responsible for the expense of making the product, and Tommy Z should not lose the money he used to create the shirts, even if he was not awarded the full charge to include his profit by the Superior Court. The contract was a low-level contract, so even though he should have asked for her ID, it's not like she was buying a house, and it was a transaction requiring a lot of documentation. He should not have to suffer the law's expenses by allowing her to completely disaffirm the contract and avoid liability completely. The Supreme Court should have the Superior Court reconsider its decision as the best common law rule for the Virgin Islands that has been determined in other instances in the Virgin Islands has been to hold minors accountable for their actions. They should not allow her to avoid liability for this contract and should enforce that she is responsible for the expenses she created and the benefits she received by entering into the contract. Thank you.
Let me ask you, if I may. I'm sorry, I'm getting some feedback here. Let me ask you, if I may, whether or not the legislature should play a role. Whether the legislature instead of the court should decide what the best rule is. How would you respond to that?
Your Honor, I believe in the Virgin Islands, we use the Banks analysis to go ahead by how we state our clear laws. And it would make sense in the VI since it is a very small community, which is.
Well, the Banks analysis is done by the court. And I guess we have the power to do a Banks analysis, but is it appropriate or where the legislature has set some rules in place as to, the age of the majority, but somehow forgot to, or maybe decided not to set a rule of liability for minors. How should one figure out which way to go in this instance? Should it be the legislature that decides? Should we be the ones that decide what the best rule is?
Your Honor, I believe that the courts should be the one to decide since it is within this community.
And why do you feel that?
Because, Your Honor, may you repeat the question, please?
Sorry, I didn't hear you.
Your Honor, may you repeat the question, please?
Well, my question was who should decide what the best rule would be, and is there any way to make that judgment? Anything in the case law or the statutes that suggest that maybe the legislature hasn't decided, or maybe it has decided?
Your Honor, in the world, minors are allowed to drive cars and can be charged as adults, which is why I believe they should be accountable, which is why I believe Tracy should be accountable for this contract, because they look mature enough to handle it. And she was just a few days from turning 18, which means she had the capabilities of being responsible for handling her side of the contract.
If the courts have to decide whether individuals are capable of entering into agreements and contracts on a case-by-case basis, doesn't that open the floodgates for many, many decisions that we on the bench are going to have to make when a legislative body has already determined a cutoff as far as the age of majority as being 18?
Your Honor, the legislature should be able to understand how minors can be responsible for their own actions. As in the Porter case, he still paid for the benefits because he still paid for the contract. He was still liable because as a minor, they realized he was responsible enough and he did get the benefits. In this case with Tracy, the product was already made, so it would be very unfair to the businessman due to the fact that the Virgin Islands has a public policy interest for business men and women, so that they do not get taken advantage of the way Tommy Z was.
Thank you.
All right, with that, the time has expired. And while the judges are scoring, could Eudora Ken High School's squad please prepare to present their arguments? All right. And judges, as always, give me a note that you're ready to go.
Okay.
I'm ready.
All right.
Okay.
Good morning. Representing Ivana
Just a second. Just a second. We got one judge still writing. McLean. Oh, okay. All right. So then please, the appellant Lou, please say and spell your name, school, party, and side, followed by appellant Whalen doing the same for notices of appearance.
Good morning. Representing Ivania Durakan High School, my name is Mariah Liu. MariahLoo. I represent appellee Tracy Flick and will be addressing the first issue of whether the Moot Superior Court erred in its finding that St. Croix North High School violated Ms. Flick's First Amendment rights.
And Ms. Liu.
I have a feeling you could put this on here. You can't put it on. Why isn't your phone connected to this?
All right. Is Ms. Wallen? Okay, there you are, Ms. Wallen.
Good morning. My name is Anissa Wallen. ANISSAWALLEN. I represent the appellee Tracy Flick. I'm arguing issue 2, whether the Moot Superior Court erred when it determined that the best common law rule for the Virgin Islands was to allow minors to disaffirm their contracts and avoid liability.
All right, Ms. Liu. When you start speaking, the time will commence.
May please support. This case is on appeal from the Moot Superior Court of the Virgin Islands. Your Honors, I ask that the judgment of the Moot Superior Court be affirmed because of 3 reasons. The first is that Ms. Flick's First Amendment rights were disregarded when the administrators of St. Croix North High School expelled her in response to her pure speech. The second, as there were no substantial disruptions, Ms. Flick's actions did not rise to the Tinker standard. And third, American public schools must protect the unpopular opinions of students, as these schools should be interested in producing well-rounded individuals. With respect to the first and second points, Your Honors, it is incontestable that pure speech should be given comprehensive protection to the First Amendment of the Constitution. Ms. Flick's speech was in its purest form and was used to express her views on a topic she felt strongly about. In the holdings set forth in John F. Tinker v. Des Moines Independent Community School District, the Supreme Court recognized that minors do not abandon their right to speak freely when they enter a school's campus, or in this instance, a school's online platform. In exercising her right to speak freely, Ms. Flick made no substantial disruptions in the school's ability to teach and maintain order, nor did her speech substantially prevent any student from retaining lessons. Based on the holdings set forth in Mahanoy Area School District VBL, the minor's vulgar and indecent language and symbols, which included the F word and an image of a middle finger, did not rise to the Tinker standard. And while yes, Ms. Flick's use of suck may not be entirely appropriate for school, Justice Alito's concurrence in Mahanoy Area School District VBL stated that, and I quote, "Speech may not be suppressed simply because it expresses ideas that are offensive and disagreeable," end quote. The offensiveness of opinions expressed and diction used in all speech are subjective. As for the third point, St. Croix North High School is a public school on American soil, a school that should be interested in listening to what its students have to say, especially if opinions expressed by these students differ from the majority and/or address a public issue. The principal and vice principal's disagreement with how Ms. Flick chose to express her views is not a sufficient reason for permanently removing her from a learning environment. In Tinker, the Supreme Court recognized that, and I quote, "In order for the state and the person of school officials to justify prohibition of expression of opinion, it must be able to show that there was more than a mere desire to avoid the discomfort that always accompany an unpopular viewpoint," end quote. The school officials at St. Croix North High School decided that because they did not like how Ms. Flick expressed her opinions, her rights were expendable. On the date of her expulsion, it had already been 2 days since the students wore the shirts. Administrators had no reason to anticipate that any further actions from Ms. Flick during the rest of her mandated time in high school would result in any substantial interference with schoolwork or impinge upon the rights of staff and students.
Let me ask you a question here, if I could. Can you tell us whether or not the school was upset about the opinion that she was expressing or the manner in which she was expressing that opinion?
Yes, Your Honor. The viewpoint that is unpopular in this case is a student deciding to boldly address a public issue in a relatively uncommon way. Protests against agencies on school campuses that are organized and executed by students are not daily occurrences, and evidently, they make individuals very uncomfortable. This is viewpoint discrimination because Principal Rooney stated that the last thing he needs at this point in his career is, and I quote, 1,500 Tracy Flick disciples running around these halls, end quote. His choice to expel Ms. Flick could be disguised as a sole interest in the welfare of other students and staff. However, Principal Rooney simply did not want Ms. Flick or other students to exercise their right to pure speech and foster an environment where his word is not the only sound voice. To conclude,
Attorney, I have a question for you. Do you agree, yes or no, that there was substantial disruption on the day these t-shirts were worn?
No, I do not agree that there was a substantial disruption on the day that these t-shirts were worn. In regards
to 25%, for a classroom teacher to be only able to get through 25% of his scheduled teaching, what would be the percentage that you would consider disruptive?
previous courts have not identified a specific percentage that would be considered disruptive, nor have they used percentage in any way to address a acceptable form of disruption. And while yes, 25% of Mr. Keating's curriculum was not taught, he did not need to follow that curriculum in its entirety in order for the class to be productive. The discussion
but he has I'm sorry, counsel, but Mr. Keating has an obligation as a teacher to follow the public school curriculum so that students are properly educated. If we have disruptive incidents where students allow him to only complete 25% of his planned teaching, how does that comport with him being able to discharge his function properly?
While yes, Your Honor, I agree that Mr. Keating is obligated to follow the curriculum, he also chose to have a discussion based on the t-shirts during his class. It should also be noted that the students wore the shirts to an AP Government and Civics class, a class where the rights afforded to citizens are discussed. One of these rights being that of free speech, which these students were exercising as they engaged in a form of quiet, passive protest by wearing the shirts.
But it has been the precedent in appellate courts throughout the United States, indeed the Supreme Court, that words that are lewd, offensive, insightful are not entitled to free speech protections. Ms. Flick incited those students to wear these t-shirts. She whipped them into a frenzy for this particular day. How is that entitled to any kind of free speech protection?
Ms. Flick did not whip students into or coerce them into wearing the shirts. She simply presented the idea that they could protest TEA's unreliability during their AP Civics and Government class. And as previously stated, based on the holdings set forth in Mahanoy Area School District VBL, that minor's vulgar and indecent language, which included the F word and an image of a middle finger, did not rise to the Tinker standard and thus was not a substantial disruption. To conclude, Ms. Flick's expulsion was a gross violation of her rights. A high-achieving high school student, frustrated by the irregularities of an agency interfering with her classwork, should not then be entirely removed from her learning environment. Ms. Flick's education and rights are not less valuable than any other individual. solely because she decided to express her opinion on an issue of public concern. For
So
these
council, is it your position that if Ms. Flick once a month decided to target, I don't know, a different government agency, another T-shirt, another government agency, that would be protected activity?
In this instance, Ms. Flick was protesting something that was affecting not only her, but other students and the staff members at St. Croix North High School, and quite frankly, the citizens of the Virgin Islands as a whole. Their irregularities and unreliability was directly affecting her schoolwork and the other students' schoolwork and what everyone was able to accomplish in the school environment.
Now, we know Ms. Flick is an attention seeker who wants to be governor one day. Does that idea that we know, does that fact that we know that she has such ambitions not lead to the conclusion that Ms. Flick is willing to do whatever it takes to garner attention from her fellow students?
Well, yes, I do agree that the record does state that Ms. Flick wants to be a governor one day. Her supposedly attention seeking in this case would not benefit a potential career in the distant future. There are other ways that Ms. Flick could have tried to gain the support of her peers and of staff members of the school, but in this particular instance, she is simply protesting the unreliability of an agency that is directly affecting everyone's ability to complete work.
And why do that at the school? Why not protest at the agency? The message is not getting to the agency. The message is just disrupting students' learning. Why not protest elsewhere? Why bring it to the school?
Ms. Flick does not need a particular reason to bring a certain issue to the school. In this instance, the school has not previously addressed the unreliability and the loss of instructional time that occurs when there is a power outage. It benefits everyone, including the administrators who wrongfully punished her, when they are fully aware of just exactly how the unreliability of this agency is affecting everyone.
And my final question for you, counselor. Isn't there some other way Ms. Flick could have approached it? If she had a problem with T and she felt this was a problem affecting everyone, why did she not actually go to Principal Rooney and sit with him and say, Principal Rooney, what are we to do? Why incite her classmates to make T-shirts with offensive language? Wasn't there a better approach that would more squarely fall within First Amendment protections?
Your Honor, I do agree that there are several ways that Ms. Flick and her counterparts could have approached this issue that they found concerning. However, in this particular instance, the way that her and her counterparts decided to address the issue should not result in her expulsion, and it should not result in her First Amendment rights being violated.
Thank you, counsel.
All right, with that, we have time. And while the judges are scoring, the next litigator should be getting prepared to speak. Judges, as all usual, give me the signal. And while we're doing that, I would ask the coaches to take pictures in your locations today. Each year we forget to ask you to do this, and each year we're scrambling to find pictures as reporters are asking us to have pictures to put in the various newspapers. So please help us this year to actually get this in the newspapers and get the coverage that everyone deserves. And you can email those to me and Rob.
Okay.
All right. Sam, we got you. Gordon's good. DeLace, you look like you got yours done. And all right, Ms. Wallen, you are up. Time will begin when you begin speaking. Ms. Wallen, are you prepared? All right.
May it please the court. Your honors, Your honors, we ask that you affirm the Moot Superior Court's final judgment in favor of Tracy Flick. As both parties agree to the first and second factors under the bank's analysis, I submit that the best common law rule for the Virgin Islands should be to allow minors to disaffirm their contracts for 3 reasons. First, the legislature has not directly amended statutes concerning the age of majority as it relates to contracts. Second, the onus should be on the adult lender who seeks to benefit from the contract to ensure its enforceability. Third, minors should be protected due to their immaturity. As to the first issue, Title 16, Section 261 of the Virgin Islands Code states that all persons are deemed to have arrived at majority at the age of 18 years. After 18, a person shall have control of their own actions and business and have all the rights and subject to all the liability of persons of full age. Ms. Flick was 17 at the time she entered into the contract with Thomas Z. Mediocre T-shirts, thus had not reached the age of majority. In Galvin versus Hess Oil, the Third Circuit stated that if the legislature has not directly amended a statute, it is only in its rarest case that a court should rule the statute amended. There is currently no statute in the Virgin Islands that will allow for minors to enter into a binding contract. Secondly, the court should have told the Moot Superior Court because it is a vendor's responsibility, in this case, Thomas Z, to identify the age of a person that they conduct business with. In Kefner versus Fedha Motors Incorporation, the court found that when an appellant does not take affirmative steps to determine a person's age, they cannot claim misrepresentation. There is no evidence in the record that Thomas Z asked for Ms. Flick's age, an ID, or a driver's license. Lastly, minors should be protected because they lack the experience in contracting before the age of majority. As there are very few instances where minors will find themselves entering into a contract on their own behalf. Thus, as a direct result of their age, minors are at a severe disadvantage in terms of negotiation skills, experience, and power.
Council Wallen, are you saying Miss Flick was a few days shy of her 18th birthday? Are you saying that the few days in between being 17 and 18, she lacked contractual maturity?
Yes, because Ms. Flick was an infant when she entered into the contract with Thomas Z.
And so on the day she becomes 18, she automatically gains contractual maturity?
No.
So how do we determine if someone's mature or enough or experienced enough to enter into a contract?
Well, a minor cannot enter into a binding contract. And as Ms. Flick was 17 when she entered into the contract with Thomas Z, she is seen by law as an infant.
And so as soon as she turns 18, however, had she made that contract 3 days later, it would have been binding, is what you're saying. She would have had the requisite maturity.
Yes, because she would be seen as the law as an adult. Oh, because she would not.
But if the law, but there are instances where the law says you are 17, you have committed a murder. We are going to treat you as an adult. Why should this be any different?
Well, and as the legislature in that case, the legislature had not directly amended a statute, and there is a law that excuse me, as Ms. Flick is a minor, and if she was to, it is different because as is a different law. There's a law that states the legislature set a law or amended a law that states that a minor could be filed as adults if they commit a murder. But there is no direct. The legislature had not directly amended the statute that a minor could be held into a contract if they are an infant.
Except currently the law does not, it's silent. The statutes are silent as to at what age may a person disavow a contract. What is the age of minority? This is the court, the Superior Court deciding that it is the age of 18. Why would the Superior Court make that distinction in the contracting arena when the legislature has indicated that it's willing to abandon the 18-year-old threshold when it comes to certain other things?
Okay, so I would say that it is binding because for example, if a minor was to go and get an abortion, they would still not be liable for that because it would be seeking medical attention would be left to the patient and the doctor and is distinguished for a minor entering into a binding contract. And that could be entering into a contract, and as the vendor, it could be very harmful for this victim.
So we allow minors to drive machines. We allow minors to make life-changing medical decisions regarding their bodies. We allow minors to be imprisoned for allegedly, if they get convicted, committing certain criminal acts. We hold them accountable. We think they're mature enough in those instances, but when it comes to a contract, we decide that they're children. Where's the reasoning?
Okay, so I would say because as Ms. Flick should not be held to the contract because in cases of seeking medical help or being held to a law because of murder, it would be different because Ms. Flick was a minor and she should be held as a minor because there's no law that states, or there is no existing statute that states that a minor should be held to a binding contract. And there are two exemptions that shows that a minor should be held to a contract.
Let me ask a question on that. Would you agree that when Ms. Flick was 17 years old and 365 days old, that she was really the same person as far as her mental capacity and her ability to know what she was doing when she became 17 years and 366 days old? In other words, 2 or 3 days difference in age didn't change in any appreciable way her ability to understand what she was doing, whether or not she could enter into a contract, right?
Right.
So why should we draw an arbitrary line? Why shouldn't it be in every instance, we'll take a look at the person who does the contract. If they're 17 years old, but they have the understanding and reasoning ability of an 18-year-old or of a mature person, then they're bound. If they don't, if there's some mental disability or some other reason, then they're not. What's wrong with that standard instead of a bright line standard that may have nothing to do with reality?
A minor cannot be held to a contract, as reinstatement 12 stated, that when you are an infant, or you are disabled, or you do not have the mental capacity to uphold a contract, they cannot be held to the contract, and it should be different because as Ms. Flick because she was a minor. And a minor cannot be held to a contract when thus, a direct result of their age, minors are at a severe disadvantage in power negotiation skills, experience, and power. In light of this imbalance, minors should be allowed to disaffirm their contracts prior to the age of maturity. Minors are a vulnerable population that can be taken advantage of by more knowledgeable vendors. May I conclude?
Sure.
To conclude, the court affirmed that the Moot Superior Court decision that the best common law rule for the Virgin Islands is to follow the reinstatements and decline to hold minors to binding contracts because the onus should be on the vendor seeking to enforce their contract is binding.
All right. With that, while the judges are completing their score sheet, St. Peter and Paul appellees should be, yes, all right, I see you guys there. They will be doing that. Again, there's a few irregularities at this moment. We had one school with an odd number of squads, so there's one more squad of appellees than appellants. So this next argument is from appellees. And as we had said, there are alternates on different squads. In this squad, Diego Ken was the alternate. He participated in this season, but will not be arguing today. Judges, as always, give me the heads up when you are ready. McLean looks ready already.
Okay.
All right, Quigley's ready.
I'm ready.
All right. And so could Mr. Joseph and Mr. Esprit please put their notices of appearance on the record?
I am Pierre Joseph. P as in pencil. IERRE. Joseph. JOSE. P as in pig. H. The school that I attend is St. Stephen Paul, and the issue that I'll be arguing is whether the Superior Court erred in its findings that St. Croix North High School and its principal violated Ms. Flick's First Amendment rights, and I represent the appellee. You're muted.
Mr. Esprit.
I am Diana Esprit, D as in dog, AYANAESPRIT. I attend St. Peter and Paul Catholic School. The issue I will be arguing is whether the Superior Court erred when it determined that the best common law rule for the Virgin Islands is to allow minors to disaffirm their contracts and avoid liability. And I will be representing the appellee.
All right, Mr. Joseph, it is you. When you begin speaking, time will run.
Good morning, Your Honors. May it please the court. My client, Tracy Flick, strongly believes that the Superior Court was correct in its findings that St. Croix North and its principal and vice principal violated her First Amendment rights. Here are the three reasons why Tracy Flick is protected under the First Amendment. First, Ms. Flick did not materially and substantially disrupt the education process. Second, Ms. Flick's shirt is seen as a form of free speech, therefore it is protected under the First Amendment. And finally, Ms. Flick did not infringe on the rights of her fellow students. First, Ms. Flick did not materially and substantially disrupt the education process because in the case of Malinois versus BL, although BL used vulgar language in her speech, the criticism of the team did not include highlights that would put it outside the protection of the First Amendment because her speech occurred outside of school grounds. The Supreme Court concluded that since BL's speech did not identify the school and was not targeting the school with vulgar or abusive language, it is considered that her speech is not a material and substantial disruption. In this matter, on-campus speech and off-campus speech does not have a difference for Ms. Flick, because the main issue is to look at whether the speech of Ms. Flick identified the school or was targeting the school with vulgar or abusive language. And clearly, Your Honors, she did not target the school with vulgar or abusive language because her shirt said, "Forget you, TEA, you suck," which is why it should not be considered that her speech was a material and substantial disruption. Furthermore, in the case of Cohen, the Supreme Court concluded that Cohen's speech is not considered as an offensive conduct. This is because Cohen was showing his personal feelings about the Vietnam War. The ruling of Cohen applies to Ms. Flick because to materially and substantially disturb the peace of others is by causing any act that disturbs the peace of others. And Ms. Flick did not meet that requirement because the message written on the shirt could not justify that it had caused a violent reaction that would materially and substantially disrupt the class. It is understandable that Mr. John Keating was frazzled when he saw 25 of his students being out of uniform, but this should be considered as a minor disruption because when Ms. Flick joined the classroom, she did not engage in any acts of violence, did not make any loud or disruptive noises, and did not consist fighting words that were directed at anyone in the school. What is clear is that a peaceful protest is not materially and substantially disruptive. Second, Ms. Flick's shirt is seen as a form of free speech. Therefore, it is protected under the First Amendment. Because in the case of Tinker, the Supreme Court concluded that the wearing of armbands is seen as a form of free speech and decided it was therefore protected under the First Amendment, which should not be restrictive. In March of 2020, Ms. Flick had been taking virtual classes because of COVID. Now she must rely on TEA, a Kasai government agency that provides electricity. In the span of 3 weeks, Ms. Flick had power outages 2 times a week, with it usually lasting 45 minutes to an hour. So she missed a lot of classes due to these power outages, which infringes on her education process. Tinker applies to Ms. Flick because Ms. Flick used clothing as a form of free speech to portray her frustrations on TEA. And finally, Ms. Flick did not infringe on the rights of her fellow students. This is because 24 other students decided to wear the shirts themselves because they felt that TEA was causing an infringement on their education. These are students that are really smart and really care about their education, which is why they thought they were in need of doing this silent protest. Also, the disruption occurred during the AP government class, which it did not cause an infringement because the matter of this situation relates to an AP government class. What the teacher could have done is adding lessons they learned from AP government class to a real life situation that the students are going through. Instead of questioning that Ms. Flick caused an infringement, they should be.
Excuse me. You would agree that there are certain confinements on free speech, correct? That it's not absolute.
Yes,
correct?
Your Honor. It's not absolute.
And you said that the fact that 24 other students put on a shirt evidenced the fact that they were all for the cause, basically, correct?
Yes, Your Honor.
Well, how are we to know that? And how are we to know that that was not a disruption and that they were compelled to do that because of the pressure that was asserted on them? And isn't the fact that there's 25 people wearing a shirt that says you in foul language, isn't that enough to show that this is not an absolute right?
Yes, Your Honor. That is true, Your Honor. But in the school, for the school to punish the student for that will be considered them violating her right, because the school do not have the right to discipline her, because the speech of Ms. Flick was not directed to the school. The speech must be directed to the school in order for them to take action, Your Honor.
But didn't the principal have a concern about the snowballing effect? It was not just the fact that this shirt was being worn on one day, but that it would lead to a bigger and bigger and worse situation. Didn't he have an obligation as principal to kind of prevent that from occurring?
Yes, Your Honor. But to punish her because of that, it will still be considered as a violation to our First Amendment. Because in Tinker, they concluded that clothing is used as a form of free speech. And that's what Ms. Flick decided to do. She used clothing as a form of free speech. To do any acts that would discipline her because of that matter would still be seen as a violation to our rights, Your Honor, to our First Amendment rights.
Well,
to conclude,
I understand your argument that maybe the punishment didn't fit the crime, but what leeway or what criteria should a principal apply faced with a situation that this demonstration could get out of hand?
May you phrase that question, please, Your Honor?
So what criteria should the principal consider in determining the preventative action he should take to prevent the situation from getting out of hand?
It should be a warning, Your Honor. No acts of disciplining the student because of a freedom of expression, Your Honor.
Even though, so was the principal supposed to go to all of the students that wore the shirt and give them a warning, and that would have been enough?
That would be enough instead of expelling her for this action, because to punish a student for that would still be a violation in her First Amendment rights, Your Honor.
So by your analysis, nothing besides a warning should have been part of the sanction of the principal.
Yes, Your Honor.
All right.
I've got a question.
I'm sorry, go ahead.
I'm sorry, go ahead, Felice, you were talking earlier.
Doesn't this open the floodgates for students to come in and wear T-shirts and carry signs and wear hats if they don't like anything that's going on in the community? I mean, what happens if all of a sudden, Sam's at home and his mother starts complaining about the cost of produce at Pueblo? So does that mean Sam can walk into the school with a "We Hate Pueblo" sign or a "We Hate Pueblo" shirt? I think that's what we're talking about here, aren't we? Freedom of speech, yes, but there has to be some checks and balances, doesn't there?
Yes, Your Honor, that is true, Your Honor. But then again, what the principal could have done was give a warning or have a discussion about it on why they should not be doing that in the school time. But then again, when they expel her, that still violated her First Amendment rights, because what she did was showing her having a freedom of expression on TEA that was causing infringement on her education. Not only but other students. That's why 24 other students decided to wear the shirts themselves. To conclude, Your Honors, Ms. Flick's speech is protected by the First Amendment because she did not materially and substantially disrupt the education process. The shirt is seen as a form of free speech, not infringe on the rights of her fellow classmates. Therefore, the punishment was impermissible. The court should affirm with the ruling of the Superior Court that St. Croix North High School and its principal and vice principal violated Ms. Flick's First Amendment rights. Thank you.
Okay. I think there's 30 seconds there. I just have one question for you. As I understand your argument, the school violated her First Amendment rights because her protest was against a organization other than the school. Wouldn't you agree that even if she's protesting something other than the school, if she does the protest in a manner that disrupts the school, then the school has a right to say, no, you can't do that?
That is only if her action was causing a substantial disruption. But that was not the case. It is considered as a minor disruption. Because if we can compare to what TEA has done and to what Ms. Flick has done, you would view Ms. Flick action as a minor disruption. Because in a span of 3 weeks, multiple students were having power outages that were lasting 45 minutes to an hour. And to compare to Ms. Flick minor disruption is nowhere near TEA disruption is nowhere near to the disruption Ms. Flick had caused.
So we should expel TEA then. Probably that's what should happen, right?
All right. They have been marching around TEA instead of the school. But anyway, okay.
Right. It's all right with that. That's time. Mrs. Free, please come up. Judges. All right. We got one. Quigley is locked in. McLean is locked in.
And I'm done.
All right.
I'm done.
All right. It is right. This is Free. As soon as you begin speaking, time will begin to run.
Good afternoon, Your Honors. May it please the court. I am Diana Esprit, and I appear on behalf of the appellee, Tracy Flick. Your Honors, the Superior Court was correct when it determined that the best common law rule for the Virgin Islands was to allow minors to disaffirm their contracts and avoid liability for the following 3 reasons. First, it protects minors from entering into contracts with responsibilities and obligations that they may not understand. Second, it gives minors a chance to affirm or disaffirm any contract after reaching the age of majority, and in this case, Ms. Flick disaffirmed the contract. Third, it protects minors from being held liable for benefits they have not received. And in this case, Ms. Flick did not receive any benefits. Your Honors, it states in the restatement second of contract sections 12 that no one can be bound by contract who has no legal capacity to incur at least voidable contractual duties. Ms. Tracy Flick was only 17 years old, a minor at the time of the establishment of the T-shirt contract on April 13, 2020. Ms. Flick contacted Thomas Z via phone, and Thomas Z acted oblivious and never sent on an email or text message inquiring for government issue ID to verify if she reached the age of majority or not. And as an experienced business owner, he should have asked for a deposit for such a large amount of T-shirts being made. Your Honors, as ruled in the case Engelbert versus Traxel, contracts made by minors for items other than necessities are voidable and may be disaffirmed when the minor comes of age. In this case, the T-shirt was not a necessity. It was for a protest, and she wasn't in dire need of it. In a similar case, the Bagley versus Mount Bachelor case, where the plaintiff, after reaching the age of majority, exploited his key pass 119 times, which affirmed the contract he made with the defendant when he was a minor. Ms. Flick, after reaching the age of majority, never received or contacted Thomas about the T-shirts, therefore disaffirming the contract. And as stated in 16 Virgin Islands Code section 261, that all persons are deemed to have arrived at the age of majority at 18 years and thereafter shall have full control of their actions. Ms. Flick, after reaching the age of majority, had full control of whether to go pick up the T-shirts or not, but she did not pick up the T-shirts because they weren't essential to her. Your Honors, in another similar case, which is the Porter versus Wilson, it was ruled that an infant may disaffirm their contract and is liable in an action seeking restitution for benefits they have received. Ms. Flake did not receive any type of benefits. She never received or collected the t-shirts, and the t-shirts are still in Thomas Z's possession.
Well, let me ask you this. Would you agree that Ms. Flick on her 18th birthday was the same person as she was 6 days before that birthday? Nothing had really changed about her ability to reason or to understand what a contract was or to make promises? She was the same?
No, Your Honor, I would not agree because at the time of the establishment of the t-shirt contract, she was a minor. And after her birthday, she had reached the legal capacity to affirm or disaffirm the contract, Your Honors.
But was there anything that had changed in her ability to know what she was doing, to understand what the contract was, and to make decisions and accept responsibility for it within those 6 days? She was the same person, wasn't she?
She was, but she was still a minor. She was a minor during those 6 days, Your Honor.
But isn't that change within the 6 days simply basically a fiction? She was really the same. There was nothing different.
Well, Your Honor, she was still a minor she was still a minor and could have still been taken advantage of and be deceived, Your Honors. Your Honor.
She was when the day she turned 18, she also, since she had the same abilities as she did 6 days before, could have been deceived or taken advantage of, right?
Well, no, Your Honor, because she had reached the age of majority, so she still couldn't have been taken advantage of or be deceived, Your Honor.
Okay. So, Counselor Spree, for you, it's a bright line rule. Either you're 18 or you're not.
Yes, sir.
Right? Is that what we're to understand?
Wait, could you rephrase, Your Honor?
I said for you, it's a bright line rule. Either you are 18 and yes, you can contract, or you're not 18 and no, you cannot contract.
Yes, Your Honor.
So, but now with the Superior Court's ruling, we're gonna have a negative impact, because if I'm 17 or 15 or 12 and I decide to go to another establishment now, let's say Subway after school, or to the store across the street to buy some food, based on the Superior Court's reasoning, those store owners can say, I'm not going to serve you anything. I'm not going to sell you a pencil. I'm not going to sell you a book. I'm not going to deal with you because you're not 18. Where does that leave young people who need to purchase things?
Well, Your Honor, in this case, he should have asked for a deposit, because before a transaction, most of the time is completed, you're paid, but he did not ask for payment from Ms. Flick, Your Honor. And
so had you received the payment, you're saying the Superior Court would have been wrong in that instance? Had you received the payment, then she could not disaffirm the contract. Is that what you're saying?
No, Your Honor. What I'm saying, after reaching the age of majority, you can affirm or disaffirm the contract. During its establishment of the t-shirt contract, Ms. Flick was a minor, Your Honor. She did not understand the responsibilities and obligations of a contract, Your Honor.
So had she made a deposit, we would have taken that as evidence that she understood the contract?
No, Your Honor.
Okay.
Yes, Your Honor.
Is it yes or no?
Yes, Your Honor. Yes, Your Honor.
Yes, what?
Well,
what is the argument?
Okay.
Walk me through your argument that you're saying yes.
Okay. So Miss Tommy Z should have asked for a deposit from Miss Flick, because so he can be compensated for his time and resources that was spent on the t-shirts. But Miss Flick was a minor, and the contract was made over phone, Your Honors. It was made over phone, and he has never physically saw Miss Flick, never physically saw her, and he should have asked her to come in so he can know who is he dealing with. But the fact that he took on the risk that she was a minor, Your Honor, he took on the risk by not asking or inquiring for her age, is taking on the risk that she was a minor, Your Honor. And these are the consequences that come with the fact that she was a minor, Your Honor.
So Tommy Z should ask everyone for ID, and this is COVID time, so, or ask them to do a Zoom conference and show proof before he does business with them?
Well, if it's over the phone, Your Honor, if it's in person, it wouldn't have to happen. But if it's over the phone, it should, because you have never physically saw the person. You don't know what type of person it is. It could have been a prank call. And so if it's over the phone, he should inquire for an ID, Your Honor.
But Tommy Z and Miss Flick had several conversations. She was very detailed. She explained what she wanted. She even set a pickup time. And Tommy Z should suffer because Miss Flick decided, well, I wasn't old enough. Even by a few days, I was 6 days shy of my 18th birthday, so I shouldn't have to pay for this.
Well, Your Honor, Miss Tommy Z should have asked for deposit to be compensated for his time and resources. The fact that he didn't is the consequence of his action, Your Honor. He should have taken further action to ensure the person that he was working with and to assure that the t-shirts were going to be picked up or not, Your Honor.
So we're not really, the Superior Court wasn't really creating a policy in favor of people like Ms. Flick. They were really trying to punish Tommy Z for being a bad businessman. Is that what we do?
No, the Superior Court was protecting managed, Your Honor, but it was also showing that businessmen should be more sophisticated and know more of how to do business. He should have insurance and know more about how to do with business, Your Honor.
Well, and so if we end up in a situation where business people now decide that, you know what, I must ask for ID, and B, if you are under 18, I will not sell you anything, provide any service, we're okay with that?
Well, Your Honor, it depends on the type of business. In this case, it was customized t-shirts that cannot be resold to anyone. So he should have taken affirmative action to know who he was working with, Your Honor.
But in that case, under the Superior Court's holding, we would have to refund the money because we're saying she was a minor. She couldn't contract. So if she made any payments in furtherance of that contract, even that payment would have to be refunded. So how is Tommy Z protected?
Well, Tommy Z has reached the age of majority, Your Honor, and he has full control of his actions. It's his loss and it's his consequence of his inaction to acquire a deposit to be compensated for his benefits, Your Honor. Compensated for his time and resources that was spent on the t-shirt, Your Honor.
What would your answer be if she, when she's 17, 6 days shy of 18, if she had told him she was really 18, if she had lied, but she wasn't, then did she have a contract?
Your Honor, I see my time has exceeded. May I answer your question and have leave the court to conclude?
Yes.
Even though she lied, he should have asked for a government issue ID to verify if she reached age of majority or not, Your Honor.
And so if she lied, then she still didn't have a contract, even though he believed her, if she was 17.
Could you phrase that, please, Your Honor?
If she's 6 days short of 18, tells him she's 18, and he believes her, by your analysis, I take it you don't think she actually had a real contract because she wasn't yet 18 and therefore didn't have the ability to make a contract?
Yes, Your Honor, that's right. Well, Your Honor, he should have he shouldn't believe, he should have inquired for a government issue ID to verify if she's age of majority or not. And that is his mistake on his part, Your Honor.
Okay.
To conclude, Ms. Flick never showed up to the set pickup date and never contacted about the t-shirts, therefore disaffirming the contract. And this is the best common law rule because it protects minors from being taken advantage of and being deceived. I respectfully request the Supreme Court to affirm the ruling of the Superior Court that the best common law rule for the Virgin Islands is to allow minors to disaffirm their contracts and avoid liability. Thank you.
Well, you said that she didn't show up to receive the T-shirts. Doesn't this affirmance of the contract require some affirmative act?
Well, not exactly, Your Honor. In the Bagley versus Bachelor case, the defendant, after reaching the age of majority, exploited his key pass 119 times. He took affirmative action to affirm the contract. But Your Honor, if he did not take no affirmative action, he would have disaffirmed the contract. Therefore, Ms. Flick's inaction was sufficient enough to disaffirm the contract, Your Honor.
So you rely on a case where affirmative action was taken to say that disaffirmance doesn't require action.
No, Your Honor. It's sufficient enough.
Inaction is sufficient enough.
Yes, Your Honor.
So how is Mr. Tommy Z supposed to know that he shouldn't bother print these T-shirts if there's no indication to him that the contract is being disaffirmed?
Well, Your Honor, Ms. Flick, as I said, he should have had insurance, Your Honor. He should have had some type of insurance so he can be compensated for his time and resources that was spent on T-shirts, Your Honor. Thank you.
Yes.
Thank you.
All right, thank you. Our next school that we'll be arguing is St. Croix Central High School appellants. And while the judges are completing their score sheets, please get ready. Like other squads, there is an alternate who helped prepare the squad today, Erin Flynn. She will not be arguing, as the other two will be the litigators arguing. So could litigators Pickering and Alexander come up and be prepared to give your notices once the judges give me the all clear?
Okay.
That's 1, 2, 3.
Okay.
And 4. The time will commence, or sorry, please state your name, state and spell it, the school, the party you represent in the issue. Are you frozen? Can you hear me on St. Croix?
Looks frozen.
Oh no. Okay. We'll wait and give them a second. Oh, okay. Well, they're not frozen. Okay, St. Croix, your notice of appearance, please.
They sent a note saying they're working with IT.
Oh, okay. Oh, I see.
Yeah, he looks like he's a statue. So yeah, I think it's frozen.
They can hear us.
There, now it's moving a little bit. Yeah,
Oh,
okay.
Can someone speak? Oh, okay, they're logging in again. Sorry.
Can you hear us?
Yes.
Good afternoon, Your Honors. My name is Carmen D. Pickering. My first name is spelled C-A-R-M-I-N-D-Y, and my last name is spelled P-I-C-K-E-R-I-N-G. I attend the St. Croix Central High School and will be addressing the First Amendment issue on behalf of the Department of Education, St. Croix North High School, its principal and assistant principal.
All right.
Good afternoon, Your Honors. My name is Yuna Alexander. My first name is spelled U-N-A. My last name is spelled A-L-E-X-A-N-D-E-R. I attend the St. Croix Central High School and will be addressing the issue of contract liability on behalf of Tommy Z.
All right. Ms. Pickering, when you begin speaking, the time commences.
Mr. Chief Justice, and may it please the court. The U.S. Supreme Court has long held that students do not shed their constitutional right to free speech at the schoolhouse gate. But the court also recognizes the special characteristics of schools to instruct and provide students with a safe, orderly environment which authorizes them to regulate student speech. While students are entitled to a significant amount of First Amendment protection, schools still have considerable freedom to discipline students for conduct that may otherwise be protected. In order for a school to rightfully regulate student speech, it must show that that speech materially and substantially interrupted with the operation of the school, or that it had reason to predict that the speech would materially disrupt the school. Because the teachers and administration of the St. Croix North High School had evidence to show that the actions of Ms. Flick satisfied both tests, we ask this court to reverse the decision of the Superior Court and find that there was no violation of Ms. Flick's First Amendment rights. Ms. Flick's protest went beyond the peaceful demonstration allowed in Tinker. Tinker held that a school violates students' First Amendment rights when it disciplines them for conducting a peaceful demonstration on school property. In making that decision, the Supreme Court explained that the special interests of a school allow it to prohibit specific expressions of any opinion if that activity substantially disrupts the appropriate discipline in the operation of the school or threatens the rights of others. Tinker found that the black armbands worn by students in school to protest the Vietnam War consisted of pure political speech entitled to comprehensive protection under the First Amendment. The court went on to say that the armbands worn by the students may have caused a discussion outside the classroom, but it did not interfere or infringe on the rights of others. The record shows that the protest against T disrupted not just her AP government and civics class, but also the entire school. The school has a uniform policy that does not include the words F-U-T, you suck, and an arm raised in the air. The uniform policy requires all students to wear a specific uniform from 8 a.m. to 3 p.m. during the hours of virtual school. Tracy Flick's protest shirt was not just an armband, but clothing entirely different from the school uniform. And the record does not show that she alerted or got permission from her teacher or school to be out of uniform. Her protest generated so much attention that it moved beyond the AP government and civics class through social media during and after class. As students shared screenshots of the demonstration, the impact was felt throughout the school for 2 days. As other teachers had to stop their lessons to address the teachers, not just in the AP government class, but other classes as well. The distraction made her own AP instructor fail to complete no more than a quarter of his lesson. All 25 of his students were out of uniform for 2 consecutive days. And their teacher, Mr. Keating, became so frazzled that he forgot his lesson plan and instead uses classroom time not to talk about tea, but to talk about the current state of online learning instead. The manner.
If I may, isn't this summation of uniform policy violation and the fact that the faculty member was frazzled, I guess, and didn't teach the lesson? Isn't this more a uniform violation rather than a First Amendment issue?
Your Honors, it's both. The conduct in which Ms. Flick performed was an act of pure speech, but it was pure speech combined with profanity. Imagine this.
Well, where's the profanity? I've seen worse on television, in the news. So I'm not sure I follow you on profanity. It was political speech, I would agree with that, but what we have here sounds like a uniform policy violation and accompanied by political speech. Now, I don't know whether the faculty member was associated with one party or another, but should the analysis depend on that? That he supported a political position different from Ms. Flick?
Chief Justice Hong, this was not only an act of uniform policy violation. Ms. Flick had the shirts printed with the words F-U-T, you suck, emblazoned across them. Put yourselves in Mr. Keating's position. Imagine waking up ready to start your day of virtual learning to only find that not one, not two, not even three, but all 25 of your AP Civics and Government students are all wearing a t-shirt emblazoned with the words F-U-T. F-U-T. And we all know what that means. Your Honors, this disruption was not only caused in Mr. Keating's class, but other classrooms as well, leading to the substantial disruption that we are here for today. Ms. Flick had the intention of writing F-U-T in bold words. Why aren't the rest of the letters in the word forget folded up? The answer is because Ms. Flick had negative intention, and her influence on the students caused an infringement on their education. The manner in which Tracy Flick conducted her protest contributed to the substantial disruption of the school. The Supreme Court in Cohen and Mahoney stresses that the way someone exercises her constitutional right to free speech matters. Page 2 of the record shows that Tracy Flick had a platform to express her reviews and opinions on tea, which is the virtual whiteboard. But instead, she brought her protest directly to her class and school, where all cameras were on. The Department of Education expressly provided this learning platform with no restrictions to students during virtual school and to allow them to store their electronic assignments and collaborate and interact with others. This being the perfect environment for her to succeedingly express her values on tea.
Counselor, I have a question. How is intent relevant to this discussion? You mentioned intent, and I want to know why it's important here.
Your Honor, Tracy Flick's intent is more than relevant. She had an initial plan to order 200 t-shirts and distribute them across the school. But her AP Civics and Government class only had 25 students. So what was she going to do with the other t-shirts? She was going to cause a school-wide disruption, which is exactly why the principals expelled her.
Well, does this mean that we have to look beyond the actual speech and look at what the intention of the speaker is before we can decide this issue?
Yes, Your Honor. Her intentions had a negative influence on her peers and took away their right to a free education. To conclude, we ask this court to reverse the decision of the lower court and find that there was no violation of Ms. Flick's First Amendment rights. Thank you.
All right. Ms. Alexander, please come up and be ready to speak while the judges are scoring. As usual, judges, give me a thumbs up and when you're ready to go. All right, I see we got Ray.
Ready to proceed.
Paul's ready, and McLean, it looks like you're ready. All right, I wasn't sure if I missed. All right, time will commence when you begin speaking.
Mr. Chief Justice, and may it please the court. When a mature minor contacts a fair deal in business, makes a deal, has the opportunity to cancel the deal the following Monday, Tuesday, Wednesday, Thursday, or even Friday, and does not, we can conclude that the minor has accepted the agreement and should be held liable. This is the essence of the benefit rule. In the absence of a law that addresses a former minor's contractual liability, the benefit rule strikes a perfect balance between minors who want to do business in a marketplace and businesses willing to make that risk. To protect those interests, this court should reverse the decision of the lower court and find that although Ms. Tracy Flick may disaffirm from her contract, she may do so and be liable to the cost borne by Tommy Z. We ask this court to reverse the decision of the lower court for two reasons. First, Ms. Flick ratified the agreement when she took no clear steps to avoid it. And second, Ms. Flick benefited from the task she asked Tommy Z to perform. When Ms. Flick let the protections afforded under Virgin Islands law lapse on her 18th birthday, she ratified the agreement. Virgin Islands law, sections 221 and 261, together state, unless emancipated, former minors become liable for the contract they have entered into. In 1959, the Attorney General Office stated that when a minor executes a contract, that creates an obligation to pay for the value use of the premises. Restatement second, section 14, continues to add, once a former minor comes of age, she must take action to disaffirm. As Engelbert explains, disaffirmance occurs by some clear, unmistakable act. Otherwise, as Bagley makes clear, the contract would be ratified as a matter of law. In this case, Ms. Flick took no clear steps to avoid the contract, even though she was the one that initiated the agreement and even took alternative steps from Kmart to purchase shirts for her protest. 6 days before her 18th birthday, Ms. Flick contacted Tommy Z to have him produce 200 protest shirts. The terms of those agreements were for her to have the shirts for him to have the shirts ready for pickup 7 days after she initiated the agreement on April 20, 2020. The record is silent as to whether Ms. Flick emailed, WhatsApp, used Facebook Messenger, or even called Tommy Z to produce protest shirts. Because she did not effectively disaffirm by telling him she was not interested, this court can conclude Ms. Flick ratified the agreement and became liable to Tommy Z. Even if this court believes that Ms. Flick disaffirmed her contract
within a reasonable time, it should adopt the benefit rule as a matter of sound public policy and hold her liable for any costs borne by Tommy Z.
Excuse me. This benefit rule that you're talking about, now, you said that she benefited. I mean, I'm at a loss to how she benefited. I mean, she was thrown out of school. She didn't get the shirts. She really had a bad rap. So how is that a benefit to her?
Well, Your Honor, Ms. Flick had the opportunity to make a deal with a fair businessman. When Ms. Flick ordered the 200 shirts, she ordered for them to be picked up. They were ready for her to be picked up, but she did not. Ms. Flick had an obligation to pick up the shirts, and she did not. So in this case, Ms. Flick received the benefit. As Porter explained, businesses should be able to recover any benefit conferred upon a former minor seeking to avoid a contract. Though not the majority rule, the benefit rule preserves the right of the former minor to disaffirm and respects the right of businesses that assume the risk of offering services to the public at large. The benefit rule aligns with the long-standing principle that the right to disaffirm shall not be applied indiscriminately to all contracts in all situations. While it may be questionable whether Ms. Flick's parents' attempts to disaffirm the contract with Tommy Z on their daughter's behalf was effective on this day Ms. Flick turned herself 18, one thing for sure, Tommy Z used his materials, time, and other resources to create not 10, not 20, but 200 protest shirts, Your Honor. 200. If Ms. Flick could take affirmative steps to organize a protest for her classmates and even use an alternative store like Kmart, she had a similar responsibility to inform Tommy Z. Holding otherwise would discourage businesses from engaging with people in the marketplace. Your Honors, we ask this court to reverse the decision of the lower court and find that although Ms. Flick may disaffirm her contract, she should do so and be liable for the cost borne by Tommy Z. Thank you.
Counselor Alexander. The legislature has spoken, and the legislature has identified very specific instances where we hold minors accountable for otherwise adult actions. Contracting is not one of those exceptions. Why should we now violate the legislature's policy in this area?
Your Honor, the legislator has held minors accountable for their actions in most criminal cases. This is not a criminal case. This is a civil matter. Even though Ms. Flick was 17 when she entered the contract, she turned 18, the age of majority, on April 19, 2020, one day before the request pickup time. Ms. Flick had an obligation either the day of or after to disaffirm from her contract, and she did not. In this case,
but we're not. Why are we supplanting the legislature's authority in this area? The legislature says, "Tough cookies for you." The person is underage. It has been the rule and the practice in our case law. We've adopted the restatement. It's the law. What are we to? Why should we change it? And the legislature has been clear. It's the law. If you're not 18, you can't enter into a contract. But in some instances, if you're not 18, we'll still hold you liable. But that's one of those areas they say, oh, we don't want to hold minors accountable. So why are we usurping the authority of the legislature in this area?
Well, Your Honor, you are correct. I do understand that once minors reach the age of majority, they can vote or be drafted into the military. We are not sure as to why this is, Most states have adopted the law, and we respect it. In this case, when Ms. Flick turned 18, she had an obligation to disaffirm with my fair client, Tommy Z. And she did not. Even if her parents called, even if when Tommy Z called her parents, and her parents said, I did not know anything about this. Her parents, we could have assumed that her parents could have told her and she could have called Tommy Z. In this case, Ms. Flick had an obligation, Your Honor. Which is why we believe that this court should reverse the decision of the lower court. Because, Your Honors, a deal is a deal, is a deal, is a deal. And Ms. Flick had an obligation to uphold her end of the deal. Thank you.
All right. Judges, question. We're about one squad behind. We'd be about 10 minutes into lunch right now. Do you want to do lunch now, or do you want to complete the squad that was scheduled before lunch? My biggest concern is if you guys haven't eaten and you need something to eat. I don't want a judge with their blood sugar crashing and passing out on us.
My recommendation would be that we break for lunch.
Okay, if that's the case, then let's, we are going to take a half-hour lunch, and it's 1 o'clock, so we will be back at 1:30, which I believe, Marjorie confirmed, you won't be the timekeeper, then it'll be Adam, right?
Correct, yeah.
Okay, so I will introduce the new timekeeper at that point. Judges, please email your score sheets. This is Rob and I's first big swing at tallying the scores and getting everything ready for the end of the day during this time. Questions?
Yes, I've made notes and suggestions. It's gonna take me a little while to tabulate what I have so far. Clean versions.
Okay.
That's okay. Can I give them to you a little later?
Yeah, so long as, you get them to us at the end of lunch, but
okay.
We need a delivery because we have to input them and calculate everything.
Okay.
So.
Okay, we may have to eat and email at the same time. That's going to be an
Apparently so.
If there's ever a judge panel that's qualified to do multiple things at the same time, it's you guys.
Right. Yeah.
You can multitask.
So now you see why I don't want to be a judge. It's more fun being a lawyer. We don't have to do that. No multitasking for us. Yeah.
Fair enough. With that, the link will stay up, and everyone can just take some time, and we'll be back here at 1:30 to start.
Okay.
Report for 3 reasons. Firstly, her protest did not cause a significant amount of disruption at the school, therefore exceeding their authority. Secondly, her protest didn't include any fighting words as described in Cohen v. California. And lastly, the punishment that was received was far too severe for the offense that was committed. Firstly, Your Honors, Ms. Flick merely took the reins in an ongoing problem that affected many of the students that attended the St. Croix North High School and during their time in the learning environment. She tried to make a difference, and in doing so, her First Amendment rights were violated. During this protest, she didn't cause a substantial disruption to have been punished as severely as she was, as described in Tinker v. Des Moines. It states, when he is at the cafeteria, the playing field, or on the campus during authorized hours, he may express his opinions, even on controversial topics, if he does so without materially and substantially interfering with the requirements of the appropriate discipline in the operation of the school, and without colliding with the rights of others. We know that a teacher, John Keating, did become flustered when he initially saw the t-shirts and he forgot his lesson plan. But instead of continuing his own class, he, on his own accord, questioned the participants of the protest and held an entire classroom discussion on the matter. Him not being able to complete more than 75% of his lesson was on him and not because of Ms. Flick's protest. Your Honors, Ms. Flick's protest didn't collide in any way with the other students' rights, and although some disruption was present because of her teacher's interruption of his own class, it was not substantial enough for the school to punish her in the severity that was received. Secondly, Your Honors, the protest that Ms. Flick planned and orchestrated was a harmless one. Cohen v. California states that offensive conduct is behavior which has a tendency to provoke others to act in violence or to turn to disturb the peace. Fighting words serve as the messenger of offensive behavior, words which are not present in any way on Ms. Flick's t-shirts. She simply wore the t-shirts in protest of the power company T for not providing the most reliable power so that she could excel academically. She decided to have her.
Let me ask you at this point that wouldn't it have been more appropriate for the protest to be done at the power company rather than at the school? I mean, the school was the innocent party. It too was a victim of the power company. So why do this in your classes? Why not go to the power company and march there and wear your t-shirts?
Your Honors, Ms. Flick chose to have her peaceful protest at the school because the issue surrounding T had an effect on her schoolwork itself. So her performing the act and the protest at the school had to do with the school, therefore she held the protest there.
But you're not asking, their goal was not to make the school change its policies. Their goal was to get the power company to do its job. So why do all of that at the school and run the risk of disrupting classes, which it did because some of the professors were so distracted that they had a very hard time working?
Your Honors, she held her protest at the school to also shed light on an issue that many students were having an effect on that the school never addressed as well. She wanted other students to have information on what was happening to her and many other students, which she succeeded in doing without substantially disrupting other students. As I stated before, John Keating interrupted his own class, and instead of continuing on with his own class, he went and held an entire classroom discussion on the matter without continuing. She decided to have her innocuous protest at the school because the issue of power was affecting her schoolwork. Also, in Chaplinsky v. New Hampshire, it is stated that the word offensive is not to be defined in terms of what a particular addressee thinks. The test is what men of common intelligence would understand to be words likely to cause an average addressee to fight. The viewers of the t-shirts were not targeted, forced to listen to loud noises, or encouraged to cause violence in any way. Finally, Your Honors.
Is it the case that the teacher could have turned her image off on Zoom, or did she have a First Amendment right to have the other students and the teachers see her t-shirt?
Your Honors, Ms. Flick's protest is in her rights with the First Amendment. She, like I said, she wanted to bring light on an issue. She was not interrupting.
I'm not sure if you understand my question. Would her First Amendment right have been violated if the teacher said, you know what, these images are too disruptive, and he had turned her image off, kept her sound on? Would that have been a violation of her First Amendment right?
Yes, Your Honors, it would be a violation of her First Amendment right. Her purpose was to use the t-shirts as a message as akin to pure speech. That was her protest. She did not cause any disruptions with her voice herself. The t-shirt itself was her protest. And for the teacher to shut off a camera showing her protest to the other students, which was her crowd that she wanted to specifically inform, that would be a violation of her First Amendment rights, Your Honor.
But
finally,
doesn't the case law make a distinction between being on campus versus being off campus? Would that same distinction apply to her image as well? That if you want to see her, then see her off campus? You don't have to see her on the Zoom equipment of the school?
Your Honors, seeing her on, yes, it is known from the facts that she was provided with a school laptop and a school MiFi. Yes, she was not on campus. I do believe that her being on Zoom still means that she is a part of the school. Finally, Your Honors, Ms. Flick technically broke the school rules in that she was supposed to be wearing her school uniforms even while taking part in virtual learning. That aside, Ms. Flick receiving expulsion from the institution for a possible first offense is absolutely unwarranted and inequitable. Regardless of Ms. Flick's infringement of the school uniform rule, she overall had her First Amendment rights violated. And if it were lawful for the St. Croix North High School to punish her for it, it would be far too severe. In Snyder v. Blue Mountain School District, Mr. Begonical gave JS a 10-day school suspension, which is equivalent to what other students would receive if they brought weapons and drug paraphernalia to the school. The main reason Mr. McGonigal acted so rashly in this situation was because the incident that occurred had to do with him personally and did contain some vulgar language, both infractions which Ms. Flick's protest lacked. Also, in Mahoney Area School District versus BL, it is stated that schools can regulate speech in 3 situations. First, indecent, lewd, or vulgar speech uttered during school assembly or on school grounds, speech uttered during a class trip that promotes illegal drug use, and finally, speech that others may reasonably perceive as bearing the imprimatur of the school, like appearing in a school-sponsored newspaper. Your Honors, I see that my time has elapsed. May I please briefly conclude?
Yes.
To conclude, Your Honors, I cite Tinker v. Des Moines. The school officials sought to punish petitioners for a silent, passive expression of opinion unaccompanied by any disorder or disturbance on the part of the petitioners. My client, Ms. Flick, was robbed of her First Amendment rights at school, a place where her beliefs and ideas should be heard and respected. And because of that, she lost her right to attend and flourish academically. So I ask that you please affirm the ruling of the Superior Court and give my client her due justice. Thank you.
Thank you.
All right, Mr. Blake, while the judges are completing their score sheet, please come up and get ready to speak. Judges, as usual, give me the, all right, we got 2. And 3. And Sam, you ready?
I'm ready.
All right. Mr. Blake, the show is yours.
May it please the court? I stand before you today and ask that the court affirm the ruling of the Superior Court. The Superior Court did not err when it determined that the best common law rule for the Virgin Islands was to allow minors to disaffirm their contracts and avoid liability. Your Honors, too often, young adults are taken advantage of in this community, whether by banks, managers, or even their own teachers. In today's case, I represent a teenager who is susceptible to the dangers of the outside world, particularly as it relates to legal obligations. Today, I am not only arguing to protect my client, but to protect the other youth in the community from their own mistakes and from deceitful people. If I may, I would like to review 3 points. 1, this law is the best rule for the Virgin Islands. 2, this law is fair and just. And 3, the widespread use of this principle to why it should be kept and unchanged. Firstly, this rule is the best rule for the Virgin Islands because it prevents minors from making significant legal commitments. There are many adults in the world who know of minors' inability to comprehend legal documents and take advantage of that by using coy words and sweet actions. The reason this law is being contested by several individuals is because of the viable protection it provides minors. In the case of Kiefer versus Fred Home Motors, it stated, "We believe that the reasons for allowing that obstacle to remain viable at this point outweigh those for casting it aside." In light of this, we can see that the Supreme Court agreed with the protection of the common law, knowing the consequences that would take place if a new rule was adopted. I ask the court to think about the children running in the street, the teenagers going to their part-time jobs, the ones who are the new generation of our islands. To put them at a great disadvantage because it suits some adults' needs would be a misrepresentation of what compassion is. To summarize an important part of this same case, it was deemed that since minors are immature in both mind and experience, they should be protected from their bad judgments, making the common law understandable and comprehensive. Secondly, it is up to the contractor to determine whether they want to enter into a contract with a minor or not. It is well known that minors have a lot of advantages of this law on their side, making all adults wary of entering contracts with them. If one knows a law is unfair, why partake in actions you know will not harm the other party? It is an adult's carelessness that causes these processes above the common law, where there is still a level of fairness that resides within it. This law is not one-sided. It allows the contractor to get some restitution if what they provided is a necessity determined by the court. In Porter versus Wilson, it emphasizes the common law rule that a minor was liable for necessaries was thus extended to require the minor to make restitution to the extent that he received a benefit under the contract.
Let me ask you this for a second, if I could, though. In this case, is there any evidence at all that the merchant was dealing with someone that he knew or even suspected was a minor?
Yes, Your Honor. We can infer in the fact pattern that Tommy Z knew Ms. Flick was a minor when Ms. Flick did not answer the call, he called her parents. Why call her parents if she's over the age of majority? Now we can determine that Tommy Z knew she was underage and now is seeking restitution for his carelessness.
Well, is it equally possible that he, obviously when he made that call, this was after she was in her majority, we know she was 18 by that point. He knew at least that she was in school and she wasn't paying, and so he called her parents. That doesn't indicate that he had any idea when he entered into the contract what her age was, does it?
No, Your Honor, it does not. But may I reiterate that my client still has time to disaffirm the contract based upon the common law of the Virgin Islands.
And so I guess the person who's damaged is the merchant, not your client, because the merchant physically undertook to produce hundreds of T-shirts that your client had told him she wanted, and then she doesn't disaffirm the contract when she becomes 18, and he's the one who takes the heavy loss. Why is that fair?
Well, Your Honor, though it is sad that Tommy Z does not get restitution for his services, it is appropriate given the underlying circumstances of this case. In Porter versus Wilson, it did state that a minor is liable for restitution for the benefits they have received. But in this case, Your Honor, Ms. Flick never received the T-shirts and should not be held responsible for the loss of funds Tommy Z may have experienced. According to the law, my client has the power to void this contract, and we should follow the law accordingly and not intermingle carelessness and fact.
Well, how should that disaffirmance be done?
Well, Your Honor, the disaffirmation should be done when a minor does not have any more contract with a contractor, or she does not deem that the contract suits her needs anymore. And in this case, my client correctly disaffirmed the contract because that is why we're here today. Nevertheless,
does she have to call him and tell him she's disaffirming, or write him a letter that she's disaffirming, or an email? Is she required to give him some kind of communication indicating I disaffirm it?
No, Your Honor, she is not. Even so, her parents did disaffirm the contract for her. And since nevertheless, if the court did not deem this as a disaffirmance, she still has a reasonable amount of time since she was a minor at the time of entering into the contract. Your Honors, the only ones who contest this law are those who don't provide necessaries to minors. To change a sound and just law for careless adults who are not aware of the law would be unfair to minors who will be open to deceit and their own immaturity. Lastly, the common law that allows minors to disaffirm their contracts and avoid liability is one of the most important laws protecting minors from the deceitfulness of this world. As we continue to progress as a society, so do the standards of the youth in the community. Due to this, many minors have started negotiating contracts with federal institutions, jobs, and many businesses. Though it is great to see young adults taking initiative and displaying independence, they make mistakes, big mistakes. The common law we speak about today has been widely adopted by various states in America. proving the significance it holds in prominent areas of the world. A law that protects minors from mistake made in a state of immaturity and unawareness is one that should be kept and emphasized in the case today.
How can you say that this woman was immature when she had accomplished so much at her young age?
Well, Your Honor, I never said my client was immature. The one may seem immature if they are a minor at the time of entering into a contract. They have the rights to vote, supported by the common law. The age of majority is not a magical time limit that separates maturity and immaturity. It separates when a person is liable for their contract, depending on if they were an adult at the time. To come to a conclusion, the best rule for Virgin Islands is to allow minors to disaffirm their contracts and avoid liability. In the midst of immaturity and deceit, minors should have the ability to protect themselves and others when it comes to contracts and other legal obligations. Ms. Flick was under the age.
Why is that the best rule for the Virgin Islands? If Tony Z, isn't compensated or reimbursed, or explain to me why you think that's the best rule for the Virgin Islands.
Your Honor, this is the best rule for the Virgin Islands because it protects minors from making irrational decisions because of their immaturity. And
what about adults? Is there any protection for adults?
Yes, Your Honor, there is. Because at this state in Puerto Rico, we'll say a minor is liable for the benefits they have received under a contract. But if the person did not receive any benefits or necessaries, Your Honor, I see that my time has expired. May I briefly conclude? Answer your question?
Yes.
As I stated before, adults still have a level of fairness because in Puerto v. Wilson, it did state that minors are liable for the benefits they have received under a contract if it was determined by as a necessity.
So you think that should be part of the best rule for the Virgin Islands then?
Yes, Your Honor, I do think it should be the best rule for the Virgin Islands because it is an equal amount of law for adults and minors because it provides necessaries to minors, but also makes them liable so adults do not have to lose their funds.
Thank you.
Ms. Flick was under the age of majority at the time of the contract and is eligible to void it, supported by the common law of the Virgin Islands. I humbly ask the court to affirm the ruling of the Superior Court and continue to protect minors in the Virgin Islands. Thank you for your time, patience, and questions, and hope that we can all continue to protect the youth in the community. Thank you.
All right, up next is St. Croix Educational Complex appellants. Can we get you up and ready to do your notices of appearance while the judges are scoring? Okay. And judges, as always, give me the notice that you're ready to go. I see 1, 2, 3, 4. All right. So the squad for St. Croix Educational Complex appellants are the yes. Sorry. Isabella Cruz is the alternate. She will not be part. Ooh, someone's giving me a few. Can you hear me? All right. So Isabella Cruz is the alternate. She will not be arguing today. And then Alani Arnold and Nancy Parija are the litigators. Could you two please give your notices of appearance?
Good afternoon. My name is Alani, A as in Apple, L, A, N as in Nancy, I. Arnold, A, R, N as in Nancy, O, L, D. I attend the St. Croix Educational Complex High School, and I am on the appellant team. The issue I will be addressing is that the Superior Court erred when it held that the high school its principal and vice principal violated Ms. Flick's First Amendment rights.
Good afternoon. My name is Nancy Parija. That's Nancy, N as in nice, A, N as in nice, C, Y. Parija, P as in park, A, R, R, I, L, L, A. I am with the St. Croix Educational Complex High School, and I am representing the appellate team. My argument addresses whether the Superior Court erred when it determined that the best common law rule for the Virgin Islands was to allow minors to disaffirm their contracts and avoid liability.
All right, Ms. Arnold, when you begin speaking, the time will commence.
Your Honors, may it please the court. Your Honors, the judgment of the Moot Superior Court should be reversed because a school should be an institution of learning, not a courtyard through which adolescent demonstrators strut, virtual or in person, trying to prove a political point. Ms. Flick, along with her cohorts, clearly intended to disrupt the learning of the day, thereby violating a universally established school culture, and she received the punishment she deserved. St. Croix North High School did not violate Ms. Flick's First Amendment rights in expelling her from the institution because Ms. Flick planned the protest intentionally to interfere with the work of the school, infringe on the rights of other students, and encourage students to break the uniform policy. Firstly, I would like to address the fact that Ms. Flick caused disruption within the virtual class and the school had the right to discipline her. For example, in the Des Moines versus Tinker case located in Primary Authorities Part 1 on page 30, it states that in order for a school to be justified in their disciplinary actions against a student, the student's actions must either interfere with the work of the school or impinge on the rights of other students. Within the Des Moines case, the school failed to yield evidence that they had reason to anticipate that the armband worn would be a distraction to those in school. Secondly, it also states in page 36 that school is an appropriate place to exercise symbolic speech. However, this is only permitted if school functions are not unreasonably disrupted. Within the fact pattern, it says that no more than 25% of Mr. Keaton's class was completed. Please note that for each class session, there is a total of 90 minutes. Ms. Flick's protest prolonged for the 2 consecutive school days within that class, which then totals to 3 human hours multiplied by the number of students in that class. Also, it states that she engaged others in the protest while planning it during his class and broke the school uniform policy. Therefore, Ms. Flick's actions infringed on the rights of her classmates to be in an environment that is conducive for learning. This leads me to address the fact that there is a time and place for everything. Why did she feel the school was the most effective place to carry this protest out? This protest occurred during school hours, in class, and on the school-issued computer. On average, students spend 1,080 instructional hours in school per year, which only accounts for 12.5% of the year. She could have used the remaining 87.5% of her own time to carry this protest out instead of wasting the school time. The cause of the protest.
If Ms. Arnold, if this presence of this Flick by Zoom was so disruptive, why did the teacher not just turn her monitor off and not allow any of the students to see the image of or the T-shirt of any other students? Why not? Why didn't they just do that? Couldn't they have done that without violating her First Amendment right?
Your Honor, the teacher, Mr. Keating, could not do that in his class because Ms. Flick engaged a number of students, her cohorts, to actually participate in this protest. So there were numerous minimized cameras that had "Forget UTEA" all over the screen. And one teacher versus the amount of the amount of misflicks in that classroom is tremendous. A school, Mr. Keating does not have that much backup. He does not have like a party behind him to help him. In physical school, there's monitors and so on that can help you when there's a disruption in class. However, in virtual class, it's only one Mr. Keating and the numerous misflicks.
But couldn't you just turn the video off?
Well, I'm arguing that she's disrupting the class, right? And then she's disrupting the class. So with her disrupting the class, Mr. Keating had to take every second of that class, that 90 minutes, to continuously turn off cameras for the amount of students in that class. So that leaves him with a little bit of time to actually teach his lesson. The cause of the
If he had turned off the video, would that have been a violation of her First Amendment right?
Yes, it would have, Your Honor.
Why is that? I mean, she would have been off campus, so why would that be a First Amendment violation?
That would be a First Amendment violation because she's not causing disruption in the class. In the virtual school, when your camera's on, the school has a uniform policy, which is white polo shirts. Ms. Flick engaged other students to wear the t-shirts. So with her wearing the t-shirt, she came to school intentionally wanting to steer the attention of the students in the class from the lesson and to her protest. She came intentionally to distract other students. So therefore, if she wasn't wearing that shirt and he turned off the camera, that would violate her First Amendment rights. The cause of the protest is the territorial power outages being a nuisance to her virtual learning. However, she later proceeds to disrupt the class for others. The irony and hypocrisy of her actions is alarming. As an educated student involved in numerous extracurricular activities, shouldn't Ms. Flick be familiar with the protocol when there's an issue concerning her virtual learning? The disturbance is caused by TEA, not St. Croix North High School. Her shirt worn even states, "Forget you, TEA." Why didn't Ms. Flick carry her protest outside of school hours on TEA's doorstep being the root of the protest? The school has no power or authority to control the power outages because faculty and staff members are affected as well. After all of this, she achieved nothing from this reckless matter. Moving to my last point, referencing the Mahanoy case, BL was disciplined due to her speech protesting her not making the cheer team. However, her speech did not occur on school grounds and did not disrupt the class. She also used her own computer. Therefore, the court ruled that her suspension violated her First Amendment rights. In Ms. Flick's case, she used a school-issued computer, did it during school hours, and encouraged others to break the uniform policy. Even though virtual school isn't physically on campus, lessons are conducted, teachers are grading, and students are logging into the class. Virtual school is an extension of school grounds and Ms. Flick's actions should still classify as a disturbance. Just as how court proceedings occur on virtual Zoom due to the circumstances of COVID, rulings are still giving, and the virtual class is an environment for learning. With Ms. Flick's action causing a disturbance on school grounds, interfering with the work of the school, and infringing on the rights of other students, the school has the authority and jurisdiction to discipline Ms. Flick.
Don't you think it would have made better sense, though? It would have been fairer if instead of simply, there was no violence involved or anything like that. Wouldn't it have made better sense for the school to have perhaps stopped things and said, look, this might be bothersome to some students, this might be bothering some professors. We'd ask if you could desist and give her an opportunity to do that rather than just suspend her.
Well, Your Honor, Principal Rooney went in the direction of expelling her because she intended to have 200 students break the uniform policy. In the fact pattern, it states that she ordered 200 shirts from Tommy Z. She wanted 200 students to break the uniform policy. And when it was a possibility that admins found out about the protest, taking her rebellious side took over, and she went to Kmart with people and got 50 white shirts. Your Honors, my time has expired. Can I finish the question and conclude?
Yes, please.
Well, Your Honor, she took her time and went to Kmart with 50 to purchase 50 shirts. So her rebellious side took over, and her protest was an act of rebellion. Your Honor, since the infraction of Ms. Flick's action both infringe on the rights of others and well as interfered with the work of the school for 2 whole days, we respectfully request that this honorable court reverse the lower court's decision by stating that St. Croix North High School, its principal and vice principal did not violate Ms. Flick's First Amendment rights. Thank you.
Thank you.
Very good. All right, while the judges are scoring, Ms. Parija, please get ready to speak. Judges, you know the drill. Give me the signal. All right, we got 1, 2, 3, 4. All right, Ms. Parija, when you begin speaking, the time begins running.
Sorry, Your Honors, we're having a little bit of technical difficulties. We're good? Can you hear me all right?
Yes, you're coming in. Fine.
Okay. Good afternoon, Justices. May it please the court? Your Honors, the judgment of the Moot Superior Court should be reversed simply because of our Virgin Islands morals and legacy, as we pride ourselves in raising the next generation with the necessary skills of responsibility and accountability. As the saying goes, with great power comes great responsibility. Ms. Flick was powerful and mature enough to organize tens of students to protest a quasi-government agency and demand efficient services. Thus, she should have been named responsible enough to hold up her end of the bargain with Tommy Z. Her efforts to avoid being taken advantage of by the TEA seem inauthentic, seeing that she, in the same efforts, now wishes to take advantage of a local businessman, allowing an uprising adult and fully functional activist to disaffirm liability simply because her birthday was a few days later in the week does not stand with our Virgin Islands morals and should not be used as an excuse to crutch the future citizens and members of our community. The judgment should be reversed for the following reasons. 1, Tracy Flick and all 17-year-olds are afforded numerous opportunities to establish their maturity and prepare themselves for adulthood. 2, the contract was binding up until she was considered a mature adult and thereafter in court. And 3, being a student who upholds academic power and responsibilities, she should have understood her end of the bargain when the transaction was placed. Now, Your Honors, 16-year-olds are allowed to have a driver's license and physically operate 5,000-pound death machines while being fined as an adult if the situation results in the case of an accident. The ability to operate an automobile in our current society may as well be a way to justify the roles that 17-year-olds play in sustaining their adultism. If a 16-year-old can possess the ability to operate motor vehicles, they should be accountable in holding liability for a pen and paper signature and a firm decision. 17-year-olds, which is the age of Tracy Flick when the contract was bound and never voided, may I note, is allowed to have blood transfusions, be questioned by an official officer as an adult, operate a helicopter, own an administered debit card with their signature attached to the account, and are allowed to own a job and receive their own form of money, which in turn would be used to uphold their end of financial transactions with full liability. This is very different from the picture my opposing counsel is trying to paint of a young child who does not have any form of way to support themselves or any financial advantage or knowledge. It is also shown in certain cases that the events in which certain actions take place, especially when the person in question is close to legality, is important. Taking into account the Galvin versus Hess Oil Corporation case, Galvin was found responsible for the injuries that were received because he was 18 years when the point of injury was caused. Similarly, when the t-shirts were ready for pickup and administered to Tracy Flick, she was 18 years of age at the time. This is because her birthday was on April 19th and the shirts were given April 20th and the contract was not voided at this time. Also, given in the Kiefer versus Motors Incorporated case, it is given that a person in question who was not an adult due to the district mature age given should be bound to the contract made if they are mature enough. Kiefer in this case was drafted for military service, allowed to bear arms, and was justified to be mature enough to make binding contracts in the marketplace. It is stated that the magical age limit does not serve to justify a person as an adult, but rather is just another person who has grown in age. Similarly, the age limit in relation to contractual maturity was no longer valid in fact or in public purpose. In this case, we have a person who is president of student council, a moot court debater, as well as a well-known activist and known for her ability to speak out and gain responsibility and attention for countless actions. Taking into account her ability to plan a ceremony for a friend, which would have included other supplies and items needed. She in turn should have the same accountability for ordering supplies in this instance and holding up her end of the bargain. Your Honors, we constantly mention the importance of a moment, where Ms. Flick is not considered an adult in the moment. However, signatures do not last this long and is a written fingerprint to establish any new age adult. Tracy Flick, like all driver's license, which is a legal document containing their signature. As 17-year-olds get closer to their age of maturity, they begin to receive these basic rights and routines to assist themselves in the real world. Becoming an adult is nowhere near compared to the actions of day and night. Therefore, we, the 17-year-olds and future leaders of the island, should be made prepared to access these adult requirements, and in society have proven in numerous occasions that we are mature as a whole. Thank you.
What would be the standard that you would propose for a court to apply to determine whether someone was mature enough to enter into a contract and whether that should be binding?
Well, Your Honors, I would relate to this to the fact mentioned in the fact pattern, where the legislature had chosen that in specific instances, we can allow those under 18 to be liable, and the court would then decide. Given that Tracy Flick has the responsible factors and character traits to understand the circumstances being placed under, she should have been made accountable for her actions thereafter.
So you would get rid of the bright line rule of age and look more at underlying evidence concerning the ability to comprehend and understand what they were doing?
I'm sorry, Your Honor, you broke out here. Can you please repeat the question?
Yes. So you're advocating that we get rid of the bright line age rule of 18 and instead look at the circumstance of the individual who went into the contract, be they 17 or 16 or even 15?
Yes, Your Honor.
Okay.
Because this also would apply to the Kiefer case, where Kiefer was not of the legal maturity age, but because he displayed certain characteristics, the ability to bear arms, the ability to have a child, and own responsibility for that child, he was also seen justifiable in his actions to affirm a contract.
So, Councilor Parija.
Yes, Your Honor.
At the stage we are, the legislature is clear about this. If you are under 18, you may disaffirm a contract within reasonable time. And we know it's clear because the legislature has not specifically stated otherwise in the statutes. Are you asking us to infer an exception that is not there?
Your Honor, I believe you're asking as to whether we should stray away from the legislature's rule. I believe that's what you're asking.
That is correct. That is the law. Why should we depart from it?
Well, Your Honor, the law does state for 18 years to allow a majority, but because of the circumstance that we are in, the law is also subjective to certain circumstances. And because of the traits that Tracy Flick has shown, and 17-year-olds alike just like her, she should be made accountable for the actions that she has shown in pertaining her end of the bargain, understanding the contract that she is entering. And like I said, turning 18 is not as easy or as simplified as day and night. Her mental capacity does not change when the clock strikes 12:01 on April 19, 2020.
But Councilor Parija,
Yes,
we are
sir.
a court of law. We're bound by legal precedents. We're bound by the law. When it comes to these arguments, I'm hearing a lot of policy, a lot of subjective determination. Isn't that a more appropriate, so isn't the legislature a more appropriate venue to raise those issues?
Yes, Your Honor, and like the legislature has named that in specific instances, also relating to this subjectivity, there are individuals under 18 who should be liable because of specific traits or certain circumstances that were definitely portrayed in the situation of Ms. Flick.
So you probably need to take that up with the legislature. Why do you think this court can help you? We're not the legislature.
Well, Your Honor, because of the overall view and giving the rules that the legislature has put in place, this is why when these certain instances do take up, they allow the court to decide. And by the traits that Ms. Flick has shown of accountability, responsibility, and her leadership roles in the community, she should be given the accountability to uphold her end of the bargain, like the legislature has named.
Thank you, Counselor.
Thank you, Your Honor.
All right. Well, the judges are scoring. Peter Gruber International Academy appellees. You will be up next. Judges, give me the signal when you are ready. We got 3.
I'm ready.
All right. So, Ms. Etmaramani, I apologize how badly I just said that. And Ms. Popple, please put your notices of appearance on the record.
Good afternoon. My name is Ella Popple. That's E-L-L-A. P for Papa. P-O. P for Papa. P for Papa. L-E. I attend Peter Gruber International Academy, and I am representing the Kelly, Ms. Tracy Flick. The issue I'll be addressing is whether the Superior Court erred in its finding that St. Croix North High School and its principal and vice principal violated Ms. Flick's First Amendment rights.
I'm sorry, I didn't get your name.
No, Ms. Popple, you weren't muted, but the first person was. We didn't hear anything she said.
She was doing the first issue, so she went
okay.
first. Yeah. Good afternoon. My name is Britta Marmani. That is R-I-D-D, D as in dog, H-I-A-T, T as in tank, M-A-R-A, M as in mom, A-N, N as in nose, I. I am with the Peter Gruber International Academy, and I am representing the appellee student Tracy Flick. I will be arguing the second issue, the contracts and infancy.
All right, Ms. Popple, when you begin speaking, your time commences.
Okay, just give me 1 second.
And unless it's required, you don't in there. You don't have to have your mask on.
Sorry about that. Okay. Your Honor, may it please the court?
Please proceed.
Your Honors, the finding of the Superior Court should be sustained as Tracy Flick was well within her First Amendment rights when wearing a t-shirt that passively expressed her opinion on a matter of public concern without vulgarity, offense, or disruption. Based on the image included in the case that there was no profane or violent language, I would like to point out that the students were all in high school and the font choices were purely aesthetic. The capitalization of the letter F is because it was at the beginning of a sentence, and the U, T, E, and A were all capitalized because it was an acronym. There is also no profanity in the words forget, you, and T, and can all be used in everyday sentences without association to profanity. These words are not gang-affiliated, violent, or fighting words, and did not directly make fun of a single person. I would like to emphasize that the teacher, John Keating, was an AP government teacher, and due to the fact that the protest was against the government, he could have taken it as a teachable moment. I would like to take a second and state that according to the Virgin Island government, in the U.S. Virgin Islands, the U.S. Virgin Island teachers are required to have a minimum of 1 semester credit in the following subjects: teaching skills, classroom management and evaluation, as well as social studies. To state teaching skills, classroom management and evaluation, and social studies. This means that the teacher had training in order to maintain classroom management in the classroom, and should have evaluated the situation and taken action based on the point that there was a protest against the wing of the government. Finishing up, and lastly, I would like to claim that Ms. Flick and the other students who participated were under protection with the First Amendment. Looking at Chaplinsky versus New Hampshire, a rule was set in place because of the First Amendment was, quote, too vague. They state that any speech that is lewd and obscene, profane, insulting, or uses fighting words are restricted. The rule also says that any words which immediately breach the peace fall under the same restrictions, or do not fall under the same restrictions. After the incident, the admin and staff of the school never stated that any of the other teachers had to comment on the issue, meaning there was no resigning disruptions. Looking into the Mahoney Area School District versus Yale case. I'm sorry, did someone have a question?
No, go ahead.
Okay. The Mahoney Area School District versus BL case, the school could not have regulated the speech because it was not, and I'm quoting directly from the case brief, 1, indecent, lewd, or vulgar speech uttered during a school assembly on school grounds. 2, speech uttered during a class trip that promotes illegal drug use. Or 3, speech that others may reasonably perceive as bearing the imprimatur of the school, like appearing in a school-sponsored newspaper. To conclude, Miss Flick's shirt was allowed to be worn and was protected under the First Amendment due to lack of vulgar, offensive, or profane language. Ms. Flick and the other students in the protest all got around the restrictions which would have removed the protection of the First Amendment. Thus, we ask Your Honors to affirm the lower court's ruling and allow Ms. Flick to remain learning in her original school. Thank you.
Council Popple,
Yes? Yes, ma'am?
the case law has instructed us that whenever there's a material and substantial disruption of the educational process, speech is not protected. Given that the students here lost 2 days of learning instruction, as well as 75% of the first day,
Yes, ma'am.
does that not rise to a level of material and substantial disruption?
I'm sorry, I don't believe I understand your question.
Given the number of time, the length of time that students were unable to learn in this case, do you consider that to be a material and substantial disruption of the educational setting?
Well, I feel that since the class was a government class and the teacher could have taken that as a teachable moment and elaborated on many different points of that, from protest to the government association and many different, the list can go on.
So had it been a science class, it would have been more disruptive?
Well, the science teacher never claimed to have been interrupted by the protest.
I understand, but had this occurred in a science class, would you consider it to be a material and substantial disruption of the education process?
I feel that the teacher could get distracted, but science is one of the subjects where you can teach it in other ways, so it wouldn't necessarily have to be a lecture, for example. So there are other ways that the teacher could have taught the lesson and not given a lecture.
So are you saying that if this happened during an art class, because of the fact that these were artistic expressions, that somehow escapes the speech issue?
No, ma'am. I don't believe that if it was an art class, I feel it may have been an interruption, but the students are creating art, and that the shirt could have been a creation of that art.
All right, time has expired. Thank you very much for your arguments. Judges, while you're scoring, as always, give the signal. And could the second moot litigator for the appellees from Peter Gruber please be ready? Sorry, if you were silent, I definitely wasn't looking at you to the judges, and send the signal again. Oh, okay, 1, 2, 3. And 4. All right. When you begin speaking, the time will start running.
May it please the court. Your Honor, before I begin, I would like to mention that Ms. Flick was a minor at the time that the contract was made. While making the purchase, Mr. Tommy Z didn't ask her for her age or any proof of her age, such as an ID, before they agreed on the purchase of the t-shirts. Usually, when making an order, you pay in advance, whether it's the full payment or just a down payment. Mr. Tommy Z did not ask for that. Though he said it would be done by April 20th, he did not ask for a payment, which also guarantees confirmation. Ms. Flake and Mr. Tommy Z had a verbal agreement, and there was no further confirmation from the businessman's side. For example, when you shop online, you receive a confirmation number. Ms. Flake deserved a confirmation, and Mr. Tommy Z should have taken the responsibility to follow through by updating her about when he began to make the t-shirts. Ms. Flick did not use his t-shirts. Instead, she made her own t-shirts, and her classmates made their own t-shirts. She was not entitled to cancel the order as she didn't have any confirmation to notify that the order was going to follow through. In addition to that, Ms. Flick had already been expelled from the school before she received the t-shirts. The Porter versus Wilson rules that a minor may disaffirm a contract, but the minor is responsible for seeking restitution for the benefits that they have received, whether or not the benefits are necessary. I understand that Tommy Z spent money on the t-shirts and made them, and he chose to spend his own money instead of asking Ms. Flick for a payment, which, as I said, reassures confirmation. Ms. Flick did not receive the t-shirts, therefore she is not liable to pay him because she didn't get any of the benefits. Going back to the matter of her minority, the bank's analysis rules that the minors are allowed to avoid contracts for a reasonable amount of time. The restatement of contracts points out, and I quote, "No one can be bound by contract who has not legally capacity to incur at least voidable contractual duties," end quote. Though Ms. Flick gave her consent, the consent of a minor is not legal. Mr. Tommy Z should have talked to her parents before she made the purchase, as she is a minor. He was aware of the fact that Ms. Flick was not of majority at the time and did not take responsibility to talk to her parents until he had a personal problem with her not making the payment. Ms. Flick is not responsible, and instead, Mr. Tommy Z becomes responsible as he did not choose to contact her parents. As he did not choose to contact her parents until it came to his personal benefit. Engelbert versus Troxel states, and I quote, "Contracts made by minors for items other than necessities are voidable and may be disaffirmed when the minor comes of age," end quote. Before Ms. Flick could disaffirm the contract, her parents already did, as they were allowed to since she was a minor and her parents were responsible for her. Mr. Tommy Z was not happy and chose to bring the matter into reporting for the violation of her First Amendment rights, whereas Ms. Flick also disaffirmed the contract. Your Honor, I would respectfully request that you affirm the Superior Court's decision.
Counselor, aren't we just dealing here with a really devious teenager taking advantage of a few days?
I'm sorry, I think I'm having some technical difficulties.
Okay, are you hearing me now?
Yes, I can.
Okay. Aren't we just really dealing with a devious teenager who's taking advantage of a few days between being 17 and being 18? Should we allow a devious teenager to disavow a contract?
Yes, Your Honor. I think we should allow her to disaffirm the contract because though she was a minor at the time, she was allowed a reasonable amount of time after, and she was not liable for the t-shirts since she did not receive them.
But she ordered them. She discussed the details of the t-shirts. She made a plan to pick up the t-shirts. And she only changed her mind because she heard something through the grapevine. Why is that Tommy Z's issue?
I don't think it's Tommy Z's issue. I think it's the fact that she didn't get confirmation and she chose to change her mind. So if she chose to get different t-shirts and didn't run it through with him, she wasn't really entitled as he didn't do his part to give her the confirmation.
But why did she not call him? It was by the next day she decided, I'm going to change the plan. She had ample time to call Tommy Z. She knew to call him to put the order. Why couldn't she call him to cancel the order?
I'm not sure, Your Honor. I'm sorry.
But you're asking us to enter a decision allowing a person who is calculated and knowledgeable to disaffirm a contract just because she made it 6 days before her birthday. How is that good public policy for the Virgin Islands?
I'm sorry, can you repeat that?
Why should someone like Ms. Flick benefit from this doctrine when she had ample time to cancel the order?
She had ample time, I do agree with that, but she did choose on her own part to not cancel the order because she didn't know whether the order was going through or not, and it seemed really formal because they were just, it was a verbal agreement. It was formal, and he didn't do his part to make sure that she was going to get the t-shirts.
What if we were to come back with a ruling that says, fine, Ms. Flick can disaffirm the contract, but Tommy Z is still entitled to restitution for the work that he did? What would be your argument to that, Counselor?
I would agree, honestly, but she did not receive the t-shirts, so he chose to spend his own money too, and she didn't pay him, so it was his own choice to make the t-shirts out of his own money, and she should be able to disaffirm it, and he shouldn't get his restitution because she did not receive the t-shirts, and she got expelled before she could even use the t-shirts that he made.
Thank you, Counselor.
Thank you.
All right, well, the judges are tallying. Could we get Charlotte Amalie High School appellants ready to make their notices of appearance? Like with other squads, this squad has had a alternate participate this year. Amonique Francis was the alternate for them. She will not be arguing today, but we do want to recognize that she was a part of the team and was a part of this. Charlotte Amalie High School, I don't see you. Are you on here?
We are. We don't have to make the show video at the moment.
Oh, there, I see it. Okay. All right. All right, when you are judges, give me the heads up. I'm sorry, I'm getting ahead of myself. Okay, McLean, Ray, Quigley, Hall. All right, Charlotte Amalie High School, could you please have your first person put their notice of appearance in?
Could you see us? Could you see us?
No, your video feed is not on.
So it's stating that the host has stopped our video for the moment. There we go.
Okay, I should be on your screen now, right?
Yes, you are.
Okay. Good afternoon, good day to you justices and all in attendance. I am Jeb Jordan. I'm from the Charlotte Amalie High School. I will be representing the Virgin Islands Department of Education, and I'll be addressing the first question of appeal, which is whether there was a violation of Ms. Flick's First Amendment right.
All right, Mr. Portalatin. I went to basic training with the Portalatin. Please enter your notice of appearance.
Good day, Your Honors, and all in attendance. My name is Carlos Morales Portalatin, spelled CarlosMorales Portalatin. I am representing the appellant Tommy Z, and I will be addressing the second question on appeal, whether the best common law rule for the Virgin Islands is to allow minors to disaffirm their contracts and avoid liability.
All right, Mr. Jadon, you are up. When you begin speaking, the time will commence.
Okay. May it please the court. Your Honors, substantial disruption has no place in school, whether it is virtual or in-person schooling. And here we have a substantial disruption that already begun and will have exploded in the near future. Ms. Flicks realized that her plan was disturbing the peace, in this case, the normal operation of school, and her intent was not just to persist, but it was also to escalate. The Superior Court erred in finding a First Amendment right violation and that the ruling should be overturned for the following reasons. The reason number one, Ms. Flick's actions were a substantial disruption and threatened to cause a greater disruption. Reason number two, Ms. Flick's speech aligned more closely with on-campus speech, which is limited for students. And lastly, her actions and speech taken together and the violation of a long-standing unchallenged uniform policy is not speech protected by the school, in schools. To my first point, Your Honors, for 2 days in a row, Ms. Flicks was the ringleader who sat and appeared on the computer screens in her t-shirts. From the time she appeared on the screens, the school official has all right to step in. Her actions started in school and spread through the good use of technology. JSV Blue Mountain School Districts provide two important things for us. It is a burden of school to meet the requirement of material disruption outlined in Tinker. Two, the school's official does not have to wait until the disruption actually occur before they can act or step in. Ms. Flick's initial plan had her contact business owner Tommy Z with the intent of purchasing 200 t-shirts. When the school got a word of her actions, her follow-up was not to counsel, but also to provide a taste of what's to come. She would be one of many students using her idea on white shirts that they made in the meantime. The fact shows that Mr. Keating's class specifically, to the point of him being only able to complete 25% of his lesson plan for 2 days, and other teachers who had to address this uniform violation in their classes faced disruption. This disruption goes back to Principal Rutney and Vice Principal Vernon, despite the remote nature of the school due to the pandemic. This is a substantial disruption, but the 200 t-shirts would have been far worse. We are precocious individuals. We know that there are not 200 individuals in one classroom setting. For any school, 200 t-shirts would be a clear sign of disruption and is a clear sign of a future substantial disruption. That brings me to my second point. While JS and Mahanoy BBL both identified off-campus speech that can be regulated in a manner similar to on-campus speech, Ms. Flick's speech falls squarely in the on-campus category. Although the Supreme Court in BL shied away from creating a broad, highly general rule stating what counts as off-campus speech, Justice Breyer's note that the brief from BL and the amnesis supporting her outline all speech taking place over school laptops and speech taking place during remote learning is on-campus speech. Ms. Flick's speech isn't speech taking place anytime, which I'm alluding to JS, Your Honor. It is during school hours, during class time, on a school device, through a school platform. In this instance, even though Ms. Flick's speech is physically away, her speech is on campus or situationally, it should be treated as such. If this court feels otherwise, then at a minimum, virtual schooling is spatial extension for the school's environment as outlined in the concurrence by Justice Alito in BL, and should be regulated in the same manner as on-campus speech. Lastly, Your Honors, JS and BL both hinge on the speech being off-campus speech and not have to do nothing with the dress code. Tinker, however, does. But in Tinker, a rule was just temporary, enforced to block all armbands as a means to stop the students from protesting the Vietnam War. Unlike Tinker, we do not have a temporary armband.
Attorney, let me just ask you some questions because I think I understand your argument, but I'm not sure I hear from you a recognition of the fact that the exercise of First Amendment rights can be a little bit rough around the edges. I mean, you hear about things in the news like the press can't publish the truth in some countries, citizens can't protest and risk and go to jail, and they can't assemble in public without risk of going to jail. So should the courts err on the side of allowing freedom of the press and speech and assembly? Should it allow a certain roughness, if you will?
Well, Your Honor, are you asking that if Ms. Flick's First Amendment speech was not violated?
I'm not arguing anything. I'm asking a question that.
But, Your Honor, can you repeat that question again, please? Because it not really came out clear.
Okay. I'm trying to get at whether or not let's assume that there was some element of disruption in Ms. Flick's conduct in school, and she prevented a lesson plan from being fully taught. Granted, those are things that are not good in the abstract, but is it appropriate to have a heavy hand and suspend her from school when she's trying to do something that has a very strong societal interest?
But Your Honors, although Ms. Flicks had the right intention to protest on TEA, the school did not state that she did not have a problem. She has a problem with the way she protests about it. But what the school is looking at is a substantial disruption of the future disruption that she may cause by when she purchased the 200 shirts. And therefore, there was many things violated. For example, the uniform policy, along with the future substantial disruption of the 200 shirts that forced us to regulate her speech and cause for this hearing right now.
Right, but the Superior Court heard all of that evidence and decided, you know what? She had a First Amendment right, and no way did the court suggest that it's limited. I mean, it's unlimited, but nevertheless upheld her right to freedom of her First Amendment rights. So I'm trying to understand, are you saying there's some part of the Superior Court's decision you're disagreeing with in light of the important principles involved here?
Yes, Your Honor, that is why we are here today. Because in the Superior Court, the Moot Superior Court, they stated that the school did in fact violated her First Amendment rights. And I'm here to argue that the school did not violate her First Amendment rights. Because there were many, repeat that again.
Go ahead.
Because there were many rules that she broke, and on top of that, there was a future substantial 200 t-shirts that she was willing to buy from business owner Tommy Z, which forced us to get in. And as outlined in Tinker, the school's official does not have to wait until a substantial disruption to actually occur before they can step in.
Counselor.
Yes, Your Honor.
But a school, as we know, it's the nursery of democracy. It is a place where the free exchange of ideas should occur. Why, if that is the essence of free speech, how is a t-shirt disruptive of that process?
A teacher is disruptive of that process when you have a class that the teacher could only get through 25% of his lesson plan. Two, where that disruption been going on for 2 days. And three, we have a future substantial 200 t-shirts. In any instance, 25 is a substantial disruption, yet alone the 200.
But counselor, the teacher actually took the disruption, as you called it, as a moment to teach about government, about the issues with tea. And in fact, this exchange of ideas, this discussion, it spread to all the other classrooms and all the other teachers. Isn't that the essence of education? And if it is, then arguably we can say Ms. Flick contributed to the school environment that day when she got others to wear the t-shirt. Why punish her so harshly?
Well, Your Honors, I agree with you when you said that Mr. Keating did in fact stop his lesson to address this problem. Mr. Keating did what we expect the teachers to do in this type of situation. And yes, Ms. Flick did contribute to that instance, but it was a negative contribute because it stopped other teachers from getting through their lesson plan. It was okay when Mr. Keating addressed this situation in his classroom because it was AP Government Civics, which is relevant in that course. But Your Honors, we are smart. We cannot talk about world history in math class. We cannot talk about world history in art class. So therefore, that's how this substantial disruption got out of hand, and our school official had to step in order to stop this.
Thank you, Counselor.
Yes, Your Honors.
Let me ask you this question. The Superior Court is the trial court, basically, right?
That's correct.
That's the court that's supposed to decide, listen to the various facts and arguments and say, here's what the facts are. It's a fact-finding court, right?
Correct.
And that fact-finding court, after it heard everything, decided as a matter of fact that there was no substantial disruption, correct?
Correct.
So why should we, as an appellate court, say, who haven't even heard the evidence, say that the Superior Court, the trial court, the fact-finder, was wrong?
Well, Your Honors, may I answer? I see that my time is almost elapsed. Could I answer your question and conclude?
Yes, fine with me, yes.
Okay, Your Honors, as outlined in Tinker, they only had 3 students who violated the temporary armband, when we have at least 25 in Ms. Flick's first period class, and then we have a future substantial of 200. As stated in Tinker, the school's official does not have to wait until the disruption to actually occur. When my school's official saw that there was a potential 200 students in the same t-shirt that Ms. Flick wore and her first period class wore, my school official had to step in order to stop this crisis. In brief, Your Honors, Ms. Flick had an issue with TA. She has the right to. She can do that on TikTok, Twitter, Snapchat, Facebook, and other off-campus platforms. What students cannot do is violate the school's rules while using a school platform to create a disruption while laying down the groundwork for a more substantial disruption. My clients had to act in order to stop this. It is for these reasons that there is no First Amendment right violation in this case, and this court should vacate the most superior court ruling, installing judgment in favor of my client. Thank you, Your Honors, and thank you for your time.
Thank you.
All right. Judges, give me the signal when you're ready. Mr. Portalatin, please come up and be prepared for your argument. 1, 2, 3.
I'm missing a picture. I'm missing a paper. My argument.
Sam, you ready?
Yes.
All right. 4. All right, Mr. Portalatin, the floor is yours. Time will start when you begin speaking.
See me? Okay. May it please the court. Your attorney Morales on behalf of Tommy Z. We are not here to rob minors of their ability to disaffirm. That protection does not exist for those who execute contracts when they are adults. The Superior Court erred in this decision, and that decision should be overturned for these reasons. Point 1. Ms. Flick was an adult on the date the contract was executed. Point 2. Ms. Flick, by not canceling her request, showed affirmance to the benefits of a contract with Tommy Z. It's the analysis of these points that will provide the best common law for the Virgin Islands. I will address this in my conclusion. To my first point, look into Restatement Second of Contracts 14, which states that a natural person has the capacity to incur only voidable contractual duties until the beginning of the day before the person's 18th birthday. To clarify what this means in our case, hypothetically, if on Monday the 13th, Ms. Flick called to see if a hotel had availability on the 20th and asked them to hold a room, a contract does not exist on the 13th. When she arrives to claim that room on the 20th, she would be at the age of majority, an adult, Your Honors. At that point, the contract would be entered into as an adult. This is similar to our case because with a contract between Tracy Flick involved placing an order of 200 customized t-shirts that were to be printed and picked up at a later date, it was merely a request up until Monday the 20th, when the request became official. Now, if the best common law is to follow restatements mechanically, opposite is the decision in Government of the VI versus Connor. Ms. Flick is not an infant or any other person who lacks the full capacity to contract at the time of the execution of this contract. Ms. Flick knowingly planned for the future, but she was capable of acting in full. But if this court views this span of time as a gray area, then the cases and the additional analysis of sections of restatements that the Moot Superior Court looked at are also not in her favor. To my second point, even if she was a minor at the time of the contract, Ms. Flick affirmed her contract. As we've noted, upon the execution of the contract, Ms. Flick was at the age of majority. However, by not reaching out and actively letting my client work on her project, the school may have However, by not reaching out and actively letting my client continue work on her project, even after the school may have gotten wind of her plan, even after she put a contingency in place at the school, even after a second day or her additional activity, this showed she affirmed the contract. In Bagley v. Bachelor, the court addressed a similar situation. In that case, Bagley used the lift to ski 119 times before and after his 18th birthday, and sought to disaffirm a full year after his injury. That court found he ratified his contract, waiving his ability to disaffirm. Similarly, Tracy Flick manifested an intent to let her contract stand. She wanted the benefits of this agreement. She could have canceled Monday afternoon, all day Tuesday, all day Wednesday, all day Thursday, all day Friday. Your Honors, she potentially even had Saturday, a day before her 18th birthday, to cancel her agreement, but she did not. She affirmed her contract with my client. So what then is the best common law for the Virgin Islands? We could look to New Hampshire and Porter v. Wilson, where a minor can disaffirm, but they are still liable in actions seeking restitutions for the benefits they have received. Ms. Flick benefiting from my client's time, talent, and t-shirts. If this was the rule, she would be liable. But the truth is, Your Honors, the lower court looked at the right place, but did not read the full history or full text. That court went as far as looking at the provisions and statutes of Alaska, which pulled from Oregon, that the Virgin Islands adopted. The court found this highly persuasive. Even if we look to the slight majority of jurisdictions, I'd like to bring this court's attention once again to Bagley v. Bachelor, which also occurs in Oregon, and provides the 21st century reading of the early 1915 Highland v. Thompson case. As stated earlier, if the best common law rule is that a minor can disaffirm their contracts and avoid liability, then conversely, they can ratify their contracts and face liability. This is not a new rule. This is the same standing rule in full. We still contend that Ms. Flick was an adult upon the execution of her contract, but by affirming her contract, she would be she will still be held liable no matter the best common law. It is for these reasons stated, this court should find in favor of my client Tommy Z and overturn the Moot Superior Court's ruling. Your Honors, thank you for your time.
Thank you.
All right, while the judges are completing their scores, St. Croix Central High School appellees, you are the next team. Are you online? Yes, there they are. Like with other teams, Angelina Springer was the alternate for St. Croix Central appellees this year. She will not be arguing, just as all the other alternates haven't. But we do want to recognize that she participated and fully was a part of this program. Judges, when you are done, please give me the heads up that you. 1, 2, 3.
Adam, there's a note. I don't know if you saw it.
Oh, sure. We normally deal with IT through the notices of appearance, but okay. I guess St. Croix is having some sort of IT issue. What's going on? Oh, are we having trouble hearing you again? Can you hear us? All right. Last time it worked when you logged out and logged back in. Do you want to do that again? Okay. They just message, well, I think it's a group chat, but they just messaged they're going to log out and come back in order to try and correct this. Well, we have a little.
I think what's really going on is St. Croix is protesting. And it's causing substantial disruption, right?
Apparently.
Better than the power going out, that's for sure.
While we have a little bit of time, judges, if you have a moment to forward some score sheets right now, that would be wonderful. You don't have to if it'll delay you or whatever, but since we're dealing with this anyway, this would be a good time to give me and Rob an update for tallying.
Okay. Do you mind if I walk away from the screen so I can take a picture of my things? Okay. Yep. I'll be listening.
All right. St. Croix Central just logged back on. Let's hope that this corrected the issue. Okay, I just heard something. I think that was St. Croix.
Can you hear us?
Yes, we can hear you.
Thank you. We're going to put the camera on now. Thank you for waiting. We appreciate your patience.
Not a problem. Doing it remotely. All right. We have an image. So could we put our notices of appearance in, please, St. Croix?
Good afternoon, Your Honors. My name is Bernice Burley. My first name is spelled B-R-Y apostrophe capital N-I-C-E. My last name is spelled B-E-R-L-E-Y. I attend the St. Croix Central High School, and today I will be addressing the First Amendment issue on behalf of the appellee, Ms. Tracy Flick.
All right, and then Cornelius, your notice of appearance.
Good afternoon, Your Honors. My name is Leah Cornelius. My first name is spelled L-E-A. My last name is spelled C-O-R-N-E-L-I-U-S. I attend the St. Croix Central High School, and today I will be addressing the question of contract liability on behalf of Tracy Flick.
All right, Ms. Burley. When you begin speaking, the time will commence.
Mr. Chief Justice, and may it please the court. Courts have long recognized the comprehensive authority that teachers and other public school officials have over their students. But this power is not limitless. The First Amendment guarantee of the right to free speech extends to students in public schools. And although that right is not automatically equal to the rights of adults in other settings, schools must balance the right to exercise free speech against the need to maintain an appropriate school environment. A school exceeds its authority when it fails to demonstrate two things. First, that the prohibitions against speech are based on a showing that that speech substantially disrupts the school, or second, that the speech is reasonably expected to cause substantial disruption in school. Because the Department of Education, St. Croix North High School, and its principals have exceeded the same authority, we ask that this court affirm the decision made by the Superior Court and find that the school did violate Tracy Flick's First Amendment rights. The principals of St. Croix North High School violated Ms. Flick's First Amendment rights when they expelled her from school. Your Honors, Tracy Flick's conduct constituted as a silent, passive political protest under Tinker. The Supreme Court has repeatedly held that students have the right to engage in a silent, passive political protest because this, Your Honors, is a form of expression akin to pure speech, the kind of pure speech that is entitled to comprehensive protection under the First Amendment. Tinker held that a school violates a student's First Amendment rights when he or she engages in a silent, passive political protest on school property. The Supreme Court explained the special interests of the school that prohibits specific expressions made by students. But, Your Honors, that authority cannot be based on a mere desire to avoid an uncomfortable viewpoint or a remote fear. The court went on to say that Tinker found in the black armbands worn by students protesting the Vietnam War may have caused an outside classroom discussion, but it did not interfere with the work of the school or infringe on the rights of others. Therefore, Tracy Flick's protest against T is the kind that is a silent, passive political protest allowed in Tinker. Your Honors, page 3 of the record shows that Tracy Flick's intentions were for the 25 students in her AP Government and Civics class to participate in the protest against T. The AP Government and Civics class is the most appropriate place to bring these protest lessons taught to life. Usually an AP Government and Civics class is a discussion-based class where students have the right to express their general concerns on public matters, which is what Tracy Flick did in her silent, passive political protest against T. Tracy's t-shirts contained no vile or obscene language, and neither did Ms. Flick nor any of her classmates encourage their peers to engage in any kind of disruptive behavior. The record is silent as to whether Mr. Keating's focus on the current state of online learning moves so far away from the topic of civics and government as to be a distraction for the class, even if that discussion lasted for a period of 2 days. So one can conclude that Tracy Flick's silent, passive political protest was a mere exercise based on the lessons found in an advanced placement government and civics class. The school uniform policy obligates students to wear their school uniform on the virtual camera between the hours of 8 a.m. to 3 p.m. However, Tracy's conduct did not warrant expulsion. Similar to the armbands in Tinker, Tracy's protest shirts are symbolic because of the manner in which they are worn. When I mean silent, Silent means that Tracy appeared in front of the virtual camera in a calm manner, passive. She was well behaved and she didn't encourage anyone to disrupt the classroom setting. And political protest, well, Tracy was just expressing her concerns against the territorial electrical agency's power outages, which continuously deprived her of her virtual education. The record is silent on the impact that Tracy's protest had on the other classes at St. Croix North High School, even if that discussion lasted for a period of 2 days. Your Honors, not even Mr. Keaton, as her AP Government and Civics teacher, expressed any kind of—
Counsel, I have to interrupt you. You keep using this phrase, and I'm unclear why you keep using silent, peaceful protest. There was nothing silent or peaceful about this protest, was there?
Yes, Your Honors. There was something silent about Tracy's protest. Tracy entered the virtual class in a silent manner. She wasn't loud or disruptive. She was passive because in the manner in which she appeared. And is a political protest because, yes, this was a political protest based on—
Against whom is she protesting, Counselor? Against the school? I don't see tea at the school.
Your Honors, Tracy Flick's t-shirts simply says, "Forget UT, you suck." Her intentions weren't directed at the school. They were specifically directed against the Territorial Electrical Agency.
But the Territorial Electrical Agency is not present in that room. And yet, Ms. Flick deliberately engaged in actions directed at the school. She messaged her friends. She went on TikTok. She sent all kinds of social media posts. She incited the students to get together and wear t-shirts. In fact, she had 200 t-shirts planned. And none of this has happened. T is not aware of any of this. So how is this a peaceful protest against T and not a disruption of the school?
Your Honor, this is a peaceful protest because Tracy specifically wore these t-shirts in her AP Government and Civics class. She did not take it to her math class or her science class. She specifically wore it in this Civics and Government class because an AP Government and Civics class is a discussion-based class. When teachers bring the real-life scenarios to the lessons taught in that class. Therefore, Tracy did not substantially or materially disrupt the school.
Except, Counselor, Tracy initially came up with the idea that everyone in her AP Government class would wear the t-shirts. And then she went on to plan for 200 t-shirts. And the plan was that students would wear the t-shirts exclusively for 2 days, in violation of the uniform requirement and with offensive language written in red and black and yellow writing on those t-shirts. How is that not, that is designed and calculated to cause a disruption? Was that not Tracy's purpose for doing this?
No, Your Honors, that was not Tracy's intentions. She simply stated, "Forget UT." Tracy's t-shirts did not contain any type of profane language to materially or substantially disrupt the other students' educational rights.
And the plan got around school quickly. And students shared screenshots, photos, stories on social media. During class, teachers were unable to teach. They had to address the t-shirts in their classes. Mr. Keating became frazzled and frustrated. He could only complete 25% of his lesson plan. That is precisely the kind of disruptive behavior that we don't want speech to generate.
Your Honor, while Mr. Keaton appeared to be frazzled and couldn't complete no more than a quarter of his lesson plan, he still did not express any kind of disappointment to Tracy's protest because this is a public matter. It's a real life scenario that can be incorporated into an AP Government and Civics class because this was a discussion that Tracy wanted to be held inside the classroom, which is why she specifically wore the shirts in that one class period. She never encouraged any of the other students to wear it in the other classrooms. That's just social media. Those students chose to to spread that message throughout social media, but that was not for Tracy Flick's fault. And Your Honor,
Counselor, I have another quick question. Are you saying that anything that is nonverbal communication is peaceful, is a peaceful protest? Is that what I'm hearing you say? That
Yes, Your Honor, you're correct. Tracy Flick's protest was a silent, passive political protest. She did not encourage her peers to engage in any kind of disruptive behavior.
But can you, so are you equating that with any type of nonverbal communication? Are you saying that whatever somebody wears or whatever sign somebody carries, that's tantamount to a peaceful protest because they haven't opened their mouth and said something?
Your Honors, Tracy Flick's protest received that protection by Tinker, because similar to the armbands worn in Tinker, the black armbands were just symbolic, and that's what Tracy t-shirts were. They were just symbolic. Your Honors, I see that my time has expired. May I conclude?
Yes, go ahead.
Your Honors, we ask that this court affirm the decision made by the Superior Court and find that the St. Croix North High School, the Department of Education, and its principals did violate Tracy Flick's First Amendment rights. Thank you.
Thank you.
Thank you.
All right. Well, the judges are scoring. Ms. Cornelius, please prepare to give your presentation. As usual, give me the thumbs up or however you want to let me know. 1, 2, 3, 4. All right, Ms. Cornelius, when you begin speaking, the time will commence.
Mr. Chief Justice, and may it please the court. Virgin Islands law is clear. Under Title 16, Section 261, persons ages 18 years of age or older have total control over their actions and the liabilities they may assume. This law may apply to anyone that has reached the age of majority, the age of 18 years old, but it does not eliminate the protections intended to shield former minors from any mistakes they've made. This is because minors can't enter into legally binding agreements unless otherwise provided by law. Locally, there is no law that protects the rights of former minors when they've entered into contracts and shortly thereafter have reached the age of majority. As a result, we are asking this court to extend protections implicit under the Virgin Islands law and find that my client, Ms. Tracy Flick, may be able to disaffirm her contract with Tommy Z. We are asking this court to affirm the lower court's decision for 2 reasons. First, Ms. Flick made no affirmative steps on the contract and she made no benefit from it, so she should be able to avoid it. Secondly, Ms. Flick lacked the capacity to enter into any agreement with Mr. Tommy Z because she lacked her parents' consent. Because Ms. Flick made no affirmative steps on the contract and received no benefit from it, she should be able to avoid it. Sections 221 and 261 of Title 16 determines what persons at what age assume responsibility for their business decisions and any other related liability. Together, these provisions allow for anyone 18 years of age or older, unless emancipated, to enter into legally binding agreements. Penn explains that Section 261 does not mean former minors become responsible for contracts they've entered into prior to turning 18. Bagley sheds light on a former minor that executed a season pass to use a lift 119 times over a 26-day period. They found that he could not disaffirm his contract. Locally, the Virgin Islands Attorney General advised that only persons who have reached the age of majority or have been emancipated can execute any binding agreement. Restatement seconds Section 12 confirms only persons at age 18 can enter into legally binding agreements. Your Honors, Miss Flick was a 17-year-old high school student, a high school senior. Your Honors, high school seniors are normally getting ready for prom. They're getting ready to fill out college applications. They even go to college, Your Honors. Some get their first cars. Miss Flick entered into an agreement with Mr. Tommy Z to create 200 protest shirts. 200 protest shirts, Your Honors. Let's say these protest shirts were $15 each. 200 times $15 each would be $3,000 for 200 t-shirts. How can a fair dealing businessman expect a 17-year-old high school student to have $3,000 on hand to pay him for these 200 shirts? Your Honors, Miss Flick's parents were never aware of this agreement. So, and she was a minor at the time this contract was made. So she should not be held liable.
Okay, I have a question. This Miss Flick, who was going to the prom, who was making arrangements probably to rent a limo, and she goes into Divvy Divvy fabric store and decides that she's going to buy $35 worth of material, and the nice lady in Divvy Divvy cuts the material, and she goes up to the counter and she says, "Oh, I decided I don't want that material." So under your reasoning, because this is a woman who has made arrangements to go to the prom, who has rented a limo, who has probably made arrangements with her friends and others, very many agreements and contractual relations, because she hasn't yet turned 18, she can walk out of Divvy Divvy, and the material that was cut for this woman's dress, she doesn't have to pay for.
Your Honor, I understand where you're coming from, but in this case, Miss Tracy Flick, Mr. Tommy Z actually printed 200 t-shirts for Miss Tracy Flick. They had an agreement, and Miss Tracy Flick had no legal obligation to uphold her end. Miss Tracy Flick was a minor, Your Honors. Even if she went to the DVDB store and said that she wanted a couple yards of fabric, Your Honors, that cannot speak to this case because Mr. Tommy Z created 200 shirts for a minor, and she cannot be held liable.
So what happens if 20 young women who were going to Central High School decided to go in and buy each $50 worth of material, and all that material was cut, and then they all walked up to the counter and said, "We don't have to pay because we're 17." Do you think that's right?
Your Honor, it may not be right, but we have to recognize that they may be under the age of 18, which is not the age of majority, and they will have no legal obligation to pay for these materials because they are not 18. Because Ms. Flick lacked any capacity to enter into any agreements with Mr. Tommy Z, she cannot and she should not be held liable. In Bagley, the court noted that the minor's father had executed a release agreement on his son's behalf before the former minor had turned 18 and he had used the facility. It was only after Bagley himself had reached the age of majority that he executed the release agreement on his own and availed himself to the resort's facility 119 times, that the court found that he had ratified the agreement. Your Honors, let's not forget, in this case, Ms. Tracy Flick did not receive any benefit from this agreement with Mr. Tommy Z. Restatement 12 also points out that the circumstances of each case are important to determine if a former minor has full capacity to enter into binding agreements. Similarly, the Virgin Islands Attorney General explained that minors under the care of their parents must obtain parents' consent prior to receiving certain third-party services. Your Honor, to reiterate what has been said here today, Your Honor, I see my time has expired. May I conclude?
Go ahead. Go ahead.
Thank you. To reiterate what has been said here today, Your Honors, a deal may be a deal, may be a deal, may be a deal, but it cannot be a deal if it is unfair and harmful to the minor. Your Honors, the infancy doctrine protects these minors from those unfair and harmful contracts, Your Honors. In this case, my client, Ms. Tracy Flick, should be able to disaffirm her contract with Mr. Tommy Z and not be held liable for his negligence. Thank you.
Thank you.
All right. That concludes that round of arguments. Our next squad that will be arguing is Antilles appellants, Tatwani and Elwani. Is Antilles on the line? There we see. All right. Judges, give me the 1, 2, 3. Four. All right. Please say and spell your name, the school, the party you represent, and the issue you will be arguing.
Good afternoon, Your Honors. My name is Ronit Tatwani. First name R-O-N-I-T, and last name T-O-T-W-A-N-I. And I'm from Antilles School. Today, I will be representing the appellant, St. Croix North High School, and I will be addressing issue 1, whether the high school violated Ms. Flick's First Amendment rights. Thank you.
Good afternoon, Your Honors. My name is Ritesh Alwani. R-I-T-E-S-H-A-L-W-A-N-I, and I'm from Antilles School. Today, I will be representing the appellant, Tommy Z, on issue 2, whether the Superior Court erred in determining the best rule for the Virgin Islands was to allow minors to disaffirm their contracts and avoid liability.
All right. Mr. Tatwani, when you begin speaking, the time will commence.
Good afternoon, Your Honors. May it please the Court. Our position is that the judgment of the Moot Superior Court should be reversed because Ms. Tracy Flick's First Amendment rights were not violated by the school for 3 reasons. First, Ms. Tracy Flick's message on the teachers was vulgar. Second, Tracy Flick was substantially disruptive to the high school. And third, the protest she organized occurred during school hours. The t-shirts designed by Tracy Flick for the protest contained vulgar language, and Tracy Flick, as well as many of her classmates, wore those t-shirts on school grounds. Therefore, according to the Supreme Court case in Mahanoy, the court found that the school can regulate this form of speech. In Mahanoy, the court found that school can regulate speech if it is indecent, lewd, or vulgar speech, and if it occurs on school grounds. Tracy Flick organized a protest against TEA, Territorial Electrical Agency, because of power outages caused by this company. To organize this protest, Ms. Flick messaged her classmates and her friends on social media about TA during class time and encouraged other students to join her in this protest. Specifically, she wanted all of her classmates to wear t-shirts with the saying, "Forget you, TA, you suck," where the first two letters of the first two words were disproportionately large. Clearly, the large nature of these first two letters of the first two words showed that these students were trying to convey the popular four-letter expletive instead of just "forget you." Tracy Flick persuaded all 24 other students in her class to wear t-shirts with the slogan, a slogan that clearly contained lewd language and sent a vulgar message across, again, during school hours. The t-shirts that Tracy Flick specifically designed for this protest and encouraged others to wear caused substantial disruption to many classrooms environments and to the learning process. In Tinker, the Supreme Court held that schools have the right to regulate speech that, quote, materially disrupts classwork or involves substantial disorder or invasion of the rights of others, end quote. In that case, students wore black armbands as an expression of their feelings about the Vietnam War, and the court ruled that they had a right to do so under the First Amendment due to the fact that they had not caused any substantial disruption or material disruption to the operation of the school. Contrary to these armbands not being disruptive in Tinker, these t-shirts ended up turning into a very disruptive protest on school grounds. One of the reasons for this may be due to the fact that the armbands contain no vulgar language or text or words, unlike the vulgar t-shirts which we are discussing today. To detail about the specific nature of the disruption, on April 14th, the first day of the protest, many students wore these t-shirts with lewd and vulgar speech in class. Also, students wore these t-shirts in a direct violation of the school uniform policy, a policy that was made to foster student engagement. We encourage the court to consider the novelty of the pandemic and the global effects it has had, especially on education. It is noted that many students were attending virtual learning without truly being engaged in the material, which is why this policy was made, so that the students would have to turn their cameras on and be wearing these uniforms. It was a policy made to get students engaged in the classroom, and it was a policy that Tracy not only broke, but encouraged others to break. Understandably, the teacher's ability to maintain focus within the classroom was severely affected. Just on this day, April 14th, teacher John Keating became frazzled and frustrated upon seeing 25 students wearing the same t-shirt instead of the mandated uniforms, to the point where he completely revised lesson plan. Over the next following 2 days, where the students wore the same t-shirts during class again, Mr. Keating was not even able to complete 25% of his lesson plan due to the distraction and the disruption that this caused. In addition, as news of Tracy Flick's plan spread throughout the school, other teachers at the school had to address this protest, halt their lesson plan, and this added to the class interruption. Throughout these days, students shared screenshots, photos, and other stories on social media during class, and their use of social media to discuss this issue during class hours caused an even greater disruption to the learning environment. Moreover, Your Honor, the school was an improper venue for this protest because despite being extremely disruptive, the protest had no effect on TEA. Instead of approaching TEA directly, Tracy Flick organized this protest at school. The school had provided the students with many resources, such as laptops, MiFis, which gave them individual wireless access, a virtual whiteboard platform for them to collaborate and share their ideas. Instead of recognizing that the school had made every single effort to foster a good learning environment for the students, Tracy Flick continued to harm the school and do a disservice to her classmates by organizing this protest during school hours and thus disrupting the learning environment. This provides empirical evidence of the disruption that Tracy Flick's action directly caused, and based on the ruling in Tinker, the school had the authority to regulate her speech. Tracy Flick organized and persuaded her classmates to join her in a protest during school hours, in class, using a school laptop and a school MiFi. Therefore, contrary to the ruling in Mahanoy, in which a student used profanity off campus on a Saturday, which was not a school day, the school had the full authority to regulate this inappropriate and indecent speech and behavior. This protest occurred during school hours and virtual learning, It was on the educational facilities of the school. Therefore, we encourage the court to consider this virtual campus similar to a traditional physical campus, as students had not been provided with access to go to a physical campus. And therefore, this was their only means of getting an education. In conclusion, we respectfully request that this court reverse the decision of the lower court and find that Tracy Flick's expression was not protected by the First Amendment. Thank you.
Question, Counselor. Tracy talked to her friends through social media. This was COVID. She didn't encourage anybody to do anything. They're teenagers, they talk amongst themselves. They all made, 25 people made the independent decision to wear these t-shirts to school. Why should only Ms. Flick be punished?
Your Honor, Tracy Flick took a monumental role in organizing this protest, and talking on social media was one part of her organization of the protest. She played the main role in starting this protest, getting the idea, and spreading this idea to multiple students. Therefore, it was her who started this protest, and it was her idea, and it was her who was the one who kept organizing, despite. Your Honor, I see that my time has expired. May I finish?
I have one more question for you, Counselor.
Counselor.
This was a public school, and she was speaking on an issue that affects the public, the unreliability of the electric company. This kind of speech on public issues, we've been told through our case law, deserves First Amendment protection. And the connection between that kind of speech, it does not have any negative impact on the school setting, because that's exactly where that sort of speech should be taking place. Why did the school not see this as an opportunity to engage in a First Amendment discussion? Why be so punitive?
Your Honor, although my time has expired, may I answer your question?
Please do, thank you.
Your Honor, although you are correct, it is noted that students should give a deference to administration. As a public school, the teachers have a curriculum that they have to get out to all of their students. And if they are not able to get through this curriculum due to substantial disruption or vulgar language on the teachers, which causes more disruption, or it happening during school hours, they will not be able to teach and effectively give this education to many students with a variety of socioeconomic backgrounds, as public schools have the obligation to do.
Thank you, Counsel.
All right. In between these two, while the judges are completing their scores, Jacob, Attorney Gower, are you on here to keep time? Our timekeeper our current timekeeper has to leave.
I am on board, yes.
Okay, do you have a video feed too? Or are you?
I will in 2 minutes. I didn't know if you needed me on video, but I can in 2 minutes, yes.
Okay. And do you have signs to give the warning?
I do not.
All right. I'm trying to think then, does 5, 3, 1, and time work? C for time? Is that what you're saying?
That will work, and I'll just have to do it manually with my hands, I guess.
C is 30 seconds is C.
Oh yeah, that makes sense. Yeah, and then I guess just you can unmute and say time. That would, at that point.
If you do the hook.
Oh yeah, there you go, that one. All right, everyone understand? I apologize for that. We struggled scheduling the timekeepers, and this was a big favor that someone stepped in to do.
Yeah, my apologies. I'm a last-minute substitution. Forgive me.
So while we're doing that, while he gets his camera up, let's see here. That's all we're waiting for. Okay.
Adam, I've got time to do one more if he needs a little bit more time to pull over and get situated.
Okay, let's do that then. I would rather not make someone stand there and wait. With that then, or judges, you're all ready? I don't want to.
Thank you.
All right, then, Mr. Alwani, the time will begin to run when you speak.
May it please the court. Good afternoon, your honors. Our position is that the court erred in finding Ms. Flick not liable for damages. Ms. Flick's decision to completely and utterly disregard her agreed upon contract violated my client's contract rights. Your honor, my client Tommy Z is a hardworking small business owner that prints customized designs on t-shirts. On April 13th, Ms. Flick called my client Tommy Z to negotiate a contract for the purchase of 200 t-shirts with the words, "Forget you, TEA, you suck." A design made specifically by Ms. Flick for her own use. Understandably, Tommy Z, as a businessman, agreed to terms as Ms. Flick presented herself as a capable adult. It is not unusual for Mr. Z to conduct business over the phone, as he had no reason, based on the conversation, to believe that Ms. Flick was not responsible or a trustworthy person. The following Monday was the day Ms. Flick agreed to pick up and pay for the t-shirts. Ms. Flick never showed up to pick up the t-shirts and failed to ever contact my client to collect and pay for the shirts. It is not reasonable nor acceptable for someone to have absolutely no contact with my client after he has expended his resources to fulfill their request. Your Honor, due to the circumstances of the case, it is quite apparent that Ms. Flick has wronged my client Tommy Z and should be held liable for damages. There being no definite rule for the subject at hand in the Virgin Islands, the court should conduct a Banks analysis to determine the best rule for the Virgin Islands in regarding contracts entered into by minors. The Banks analysis requires 3 steps. Step 1, has a BI court adopted a particular rule? Step 2, what is the position of majority of courts in other jurisdictions? And step 3, what is the best rule for the VI? First, whether any Virgin Islands courts has previously adopted a particular rule. Your Honor, the answer is no. In Innis v. Innis, the court determined that although sections 261 and 221 of the VI Code define the age at which a person is emancipated as 18, the VI Code is completely silent on the liability of minors for contracts they enter. Your Honor, there is no rule in the book, but we know that maturity doesn't magically come when one turns 18. The age at which a contract should be is one's actions that speak about their maturity. At the time Ms. Flick signed the contract, yes, she was 17 and turned 18 in less than a week later. That next week of Ms. Flick's life did not create any substantial opportunity for the development of her brain. Taking this into account, it is of the utmost importance that Ms. Flick is considered to be someone capable of entering a binding contract. Moving to the second Banks question, what is the position by majority of courts from other jurisdictions? Although there are many jurisdictions that allow minors to disaffirm their contracts, let me draw your attention to the jurisdictions that look at the actions of the minors after contracting with the vendor. For example, in Badgley v. Mount Bachelor, where the court considered whether Badgley intended to either disaffirm or let his contract stand. In this case, the intent of Badgley to let his contract stand was very clear with his extensive use of the mountain pass 119 times after he reached the age of majority. The court showed that there must be some affirmative action. However, in the current case, Ms. Flick has shown zero intent to disaffirm this contract, which violated my client's contract rights. Another case, Alum v. State. Further, it is not unusual for courts to not adhere to the standard for age set by a statute. In Alum v. State, the court discusses that Alaska's age of majority to possess marijuana as 19 years of age. When Alum was caught rolling a marijuana cigarette, he was 18 years of age. Similar to Ms. Flick, Alum pleaded his case, stating that he misunderstood the age of majority. The court determined that his argument was not sufficient to avoid him being charged criminally. The court said minority is not shed like a cocoon by the child on his or her 18th birthday. This is the same view I ask you to consider today. Ms. Flick initiated the contract with my client and provided the design to my client. Ms. Flick was mature and aware of her actions and should be held liable for her damages. The third question of the bank's analysis, most importantly, which approach represents the soundest rule for the Virgin Islands? Your Honor, the case of Gallivan v. Hess Oil VI Corporation must be considered in this determination. The case determined that statutes cannot be amended by implication. Title 16 VI Code, Section 261, simply does not say anything about entering upon a contract. Following Gallivan, the court cannot simply adopt the 18-year marker as the age at which a minor may not contract. Instead, we suggest that the court adopt a rule that considers all of the circumstances of the contract agreement, including the maturity of the minor. The court should consider Ms. Flick mature not on a certain number, but taking into account the qualities that make someone mature. Your Honor, it is our position that Ms. Flick is fully capable to enter this contract, a contract where Ms. Flick was aware of the price and negotiated the price with my client. Ms. Flick is not only an outstanding student, but is thought to possess the qualities of a future U.S. Virgin Islands governor. She also takes part in a number of extracurricular activities, such as swimming, moot court, and chess, as well as student government. On the weekends, she volunteers at many community outreach organizations as it is her passion.
Counsel, let me interrupt you for a minute. You're explaining these characteristics of Ms. Flick, but these are all after the fact. At the time your client entered into this contract, did he ask any of that information?
Well, no, Your Honor.
So at the time, he presumed she was an adult and entered into a contract with her accordingly. He cannot now be heard to complain because he was mistaken in his assumption that she was an adult. Why should we go against the law for your client?
Well, Your Honor, when Ms. Flick called my client was just carrying out normal business operations that he would do with any individual. As Ms. Flick presented herself as a capable adult, negotiated on a price, negotiated a contract, my client had no reason to believe that she was not of the age of majority.
And isn't that a risk he takes? Isn't that just the risk that all business people take? That they'll enter into contracts with people who may or may not be able to pay for one reason or another?
Well,
why should this be any different?
Well, Your Honor, that is a risk that business owners take. And that is why our position is that the minority rule would be the best rule for the Virgin Islands, as it would protect these small business owners.
But the minority rule says that if the minor retains a benefit, then the business person has a right to some sort of restitution. Miss Flick did not get any benefits in this case. She didn't even go to pick up the t-shirts. She went to Kmart instead.
Well, Your Honor, in protecting these small businesses, my client has already, I see that my time has expired. May I answer your question?
You certainly may.
Thank you. My client has already expended his resources to print this customized design on the t-shirts for Ms. Flick. He has spent money and expended his resources, and he has gained no benefit either. So it would be unjust to my client for Ms. Flick not to pay for those t-shirts, for him not to get just compensation.
Thank you, counsel.
All right. That concludes that. While the judges are completing their scoring, could we have All Saints appellees come up? And while we're doing that, Mr. Adam, thank you very much. Our timekeeper for these rounds is now done. Mr. Gower, are you ready to go?
Yes, I am.
All right. Can you turn your camera on? There we go. Okay. Can you speak again so everyone will?
Can you hear me?
All right. That's so you should pin that person's screen for anyone who needs to be looking at time. He's the one who will be giving the warnings. As we said, he will do 5, 3, 1, 30 seconds time. I do apologize. We have to accommodate as we go. Judges, are you ready?
Yes.
Yeah. And McLean, ready? Okay. Okay then. Ms. KB and Fleming, can you please put your notices of appearance on the record? Say and spell your name, school, party, issue.
Good afternoon. My name is Makeda Elizabeth KB. M-A as in apple, K-E as in echo, D as in dog, A as in apple, dash, E as in echo, L, I, Z, A as in apple, B as in boy, E as in echo, T, H, C, A as in apple, B as in boy, E as in echo, Y. And I am representing All Saints Cathedral School, arguing issue number 1, whether the Superior Court erred in its findings that St. Croix North High School and its vice principal and principal violated Miss Flick's First Amendment rights.
Go ahead.
Good afternoon. My name is Zania Fleming. X-A-N-I-A-F-L-E-M-I-N-G. And I am representing All Saints Cathedral School. I will be arguing question 2, whether the Superior Court erred when it determined that the best common law rule for the Virgin Islands was to allow minors to disavoid contracts and avoid liability.
All right. Before I even start, Jacob, I just want to make sure you're now parked and everything. You're all good?
All good.
All right then. Time, and also the time I had said, but the time stops while the judges talk, but the time commences as soon as the judges stop talking. So, all right. With that, you may begin. Time will commence when you.
May it please the court. Your Honors, the Supreme Court should uphold the decision of the Superior Court as they were correct in finding that Ms. Tracy Flick's First Amendment rights were violated when the principal and vice principal expelled her from St. Croix North High School. The First Amendment right to free speech is one of the most sacred, protected, and important constitutional rights. Ms. Flick's conduct was within the protection of the First Amendment. As in Tinker, where the court found that the wearing of armbands as a political statement was within the protections of the First Amendment, this court should uphold the findings that the wearing of t-shirts as a statement is within Ms. Flick's First Amendment rights. The t-shirts Ms. Flick wore contained protected content. It was not profane and did not incite immediate lawless action or violence. Ms. Flick wore the t-shirt in silent protest and did nothing to actively disrupt the class. It was the teacher, Mr. Keaton, who disturbed the class over her silent protest by getting totally flustered and making it a big deal. Mr. Keaton could have ejected her from the Zoom class or asked her to turn off her camera or sign off. Ms. Flick should not be penalized for the behavior of the teacher, and even if punishment should have ensued, expulsion is a drastic measure that should have been left for final measures after other actions to punish her proved insufficient to control the situation. The rule in Tinker states that the school officials must show that forbidden conduct would materially and substantially interfere with the requirements of appropriate discipline in the operation of the school, where Ms. Flick was responsible. Ms. Flick's clothing choice would not have substantially interfered with the normal operation of the class if the teacher did not decide to react the way he did and interfere with his lesson. Only very narrow exceptions exist where United States citizens cannot freely express themselves, which include hate speech or conduct or speech that immediately incites violence. In Mahoney, the court held that schools may only regulate speech in certain limited circumstances, such as lewd, indecent, or vulgar speech or uttered during school grounds, speech uttered during a class trip that promotes illegal drug use, and third, speech that others may reasonably perceive as bearing the school-like appearing in a school-sponsored newspaper. Here, Ms. Flick's conduct did not meet any of those exceptions. There were no profanities used or lewd, indecent, or vulgar speech. Ms. Flick exercising her free speech rights was not disruptive to school operations. As in JS versus Blue Mountain, where the court found that the conduct did not create any substantial disruption and should be protected, the Superior Court was correct in finding the same here. Even in Cohen, where it was a courthouse, which is on public grounds, he was wearing something that had blatant obscenities, it was still found that he couldn't be punished. Here, she did not use blatant obscenities or vulgar language. Ms. Flick was on an online Zoom platform and was not physically on school grounds. And there were plenty of other options that were not expulsion that could have been taken to punish her. The action the school and its officials took was a violation of Ms. Flick's First Amendment rights. Your Honors, the Supreme Court should uphold the Superior Court's findings that Ms. Flick's First Amendment rights were violated by the actions taken by the school and its principal and vice principal.
Counselor Cavey, we're talking about a public school. A public school is an extension of the state. When you send your children to public school, the state has every right to restrict some speech to maintain an effective instructional atmosphere. The principal in this case was worried, not just about Ms. Tracy, but about there being many of her. Now, that is a legitimate concern of a public school. Are you saying that we should disregard the school's concern?
No, Your Honor, I'm not saying that we should disregard the school in their discipline. It's that they did not take any effort or measures before expulsion. Ms. Tracy Flick has a right to education, and they did not even, they could have asked her parents, they could have suspended her, they could have emailed her. They just decided that since they knew what they were doing, they were going to straight expel her.
Well, Counselor, Ms. Tracy, I'm calling her Miss, and she sounds older than she is, but her parents have already consented. We have the doctrine of in loco parentis, where once you as a parent decide to send your child again to a public school, you have in effect delegated some of your parental duties to that school. And this school was just merely carrying out its responsibility to regulate the public school environment for the protection of all students. So, again, why is expulsion not the best remedy under such a scenario?
Your Honor, expulsion is not the best remedy because there are other ways that they could have disciplined and apprehended Ms. Flick and others from doing such activities in the future. They could have suspended her. Expulsion is just a drastic measure that they took, that they did not put any time into thinking. The principal and vice principal just ruled her off as being something that should not be in school anymore. She had the right to be in school, and because of that, expulsion was drastic.
But is it really drastic in light of Miss Tracy's history? She's very much an insider. She's very much a fomenter of discord among the students. She's always stirring that. She wants to be governor one day. I mean, we know she's an attention seeker. Could this just have been the last straw?
No, Your Honor, this could not have been the last straw because she was a student. She participated in moot court. She was an upstanding student. And so none of her previous actions called for straight expulsion. There were other measures that could have been taken. She could have been suspended. It was over her silent expression of the problems that she faced in school. And because of that, she should not be penalized. She should be penalized, but not to the extent of expulsion.
Thank you.
Her beef, as I understand it, was with the power company, not with the school, right?
Yes, Your Honor.
But so far as we know from the record, she did no protest at the power company. There were no marches or anything over there, correct?
Yes, Your Honor.
And so she basically decided to go ahead and express her discontent with the power company in the context of a school that really had no control over the power company. Is that fair enough?
Your Honor, she took it upon the school first because the school did not do anything to combat this problem. Now, other students could have been expressing or could have been going through the same exact thing that Ms. Tracy Flick was going through. So Ms. Flick decided to take it upon herself to make the school aware because she goes to the school and if she took it upon herself to get other students aware of the fact that the UTEA was not doing a good job, then they could have further in the future gone to UTEA. But going to the school was her showing that the school did not do anything to fix the efforts of UTEA.
This is the timekeeper. That is time.
Right. Okay, thank you.
Thank you. Your Honor, I know that the time has run out, but may I conclude my argument?
Yes, go ahead.
Your Honors, the Supreme Court should uphold the Superior Court's findings that Ms. Flick's First Amendment rights were violated by the actions taken by the school and its principal and vice principal.
All right. Just a reminder, coaches, we have to submit pictures before 5 p.m. in order for the news to run them. So if you've taken pictures today, can you please email them to me and Rob, or for those who have my contact info, you can text me. For those who have Rob's info, you can text him. But if you have pictures, please forward them right now so that we can get them to the press. Judges, give me a thumbs up when you're done scoring. 1, 2, 3. All right. Then with that, Ms. Fleming, the time will commence when you begin speaking.
May it please the court. Your Honors, the Supreme Court should uphold the Superior Court's decision that the best common law rule for the VI is to allow minors to disaffirm their contracts and avoid liability. As there is no clear precedent on the issue in the Virgin Islands, the Superior Court properly undertook the required analysis this case demanded by conducting a Banks analysis, as outlined in the decision in Connor. It properly noted that the court here had not adopted a particular rule.
that the slight majority of courts in other jurisdictions do allow minors to disaffirm their contracts, and then they wisely determined that the best rule and soundest approach for the VI was to allow minors to disaffirm their contracts in a reasonable amount of time. There is a strong public policy in the VI for protecting minors. The legislature makes laws and the courts enforces them. The court should not be making the law or deciding each case on case by case basis subjectively. The VI law generally is that the age of majority is 18. Tommy Z has been a businessman for quite some time. While Ms. Flick was almost 18, the fact is she is not yet 18. Regardless of what Tommy Z thought or assumed in terms of Ms. Flick being above the age of 18 or how mature she appeared, the law is in place for a reason and is made to protect minors from entering contracts. As a businessman, she should have asked for ID or verification that she was of age. When you start to allow minors to be held responsible for contracts, it becomes a slippery slope. How many days before 18 is 18? Is it 5 days? Is it 10 days? Is it 20 days? The 18-year-old mark is set for a reason and is universally accepted as the point of becoming an adult. The fact that she was only a few days shy of 18 is not the point. She was not 18, which is the required age. Tommy Z has been a long-time businessman. The money that he lost from printing of the shirts is his business loss for not doing his due diligence and ensuring that she was of age when allowing her to enter this contract. He did not check for any identification to see if Ms. Flick was legally able to make this contract and make this purchase. The cost of making 200 t-shirts may not be a big expense for a business owner, but it's a big expense for a 17-year-old. Any legitimate businessman should always ask for young clients' ID, and no matter how mature they may seem. The Virgin Islands and many other places, it has been maintained that minors cannot enter contracts for any amount. Although it may seem unfair to Tommy Z, the court got it right. There's a good public policy reason to maintain the rule that minors should not be able to enter a contract and hold it firm at 18 years. The Virgin Islands legislature has changed the law to hold minors responsible for other things, like criminal charges and allowing them to consent to and make certain medical decisions for themselves. But notably, they did not change it to make minors able to enter contracts. As they have had the opportunity to change it, but have not, the court properly interpreted that they did not intend for it to be changed. And the Superior Court was correct in not making or changing the law for them. The Kiefer case is even more convincing in terms of what the courts have held when it comes to minors and contracts. In that case, even though he had driven off with the car, the court still found that he could cancel the contract and get his money back because he was a minor at the time. Clearly, where she has not picked up the t-shirts, she should not be able to cancel the contract and should not have to pay for the t-shirts. Tommy Z couldn't rely on the fact that Ms. Flick seemed mature. It takes maturity and sophistication to buy a car, and that does not mean you can be held to the contract. Also, Porter held that an infant was only required to make restitution where they had gotten a benefit. Other than that, the court and Porter agreed that the contract could be disaffirmed. Here, she never picked up the shirts and never got the benefit. So the Supreme Court was correct that the contract could be disaffirmed and she should not be held liable to pay for anything. In Highland, the court also decided that because Elisa was a minor at the time she entered the contract, it could be voided, even though it was years later. Here, it wasn't even years later. The Superior Court was correct that she should be able to cancel the contract. This case is different than Bagley's, because in Bagley, the minor continued to use the contract after they got to be of age. He used it past for a total of 119 times. In this case, she never went back and ratified the contract for the t-shirts after she came of age, so she should not be held liable to pay for them. In Engelbert, he was a minor when his mother died, and when he came of age, he wanted to avoid the contract. The court agreed and determined that because he was a minor at the time of the transaction, the contract could be voided in a reasonable time. Here, the Superior Court was correct in determining the same thing, that the minor should be allowed to disaffirm the contract. The court should uphold the Superior Court's decision that a best common law rule for the Virgin Islands is to allow minors to disaffirm their contracts and avoid liability within a reasonable time.
I have a quick question. would the result have been the same in your view if she picked up the shirts before she was 18 and decided that she didn't like them? And then she went back and said, well, I'm not 18, so you can keep your shirts and give me back my money. How is that any different from the current situation?
Your Honor, in that case, it would be a situation of whether Tommy Z would be willing to give Ms. Flick a refund for the shirts she made purchase, or she would just have to use whatever Tommy Z made and have to do with what she received.
But do you think it would be fair in that other situation for her to be able to return the t-shirts solely because she was 17?
Your Honor, in that situation, Tommy Z should have taken the time out to realize that Ms. Flick was 17. The law is still there that minors shouldn't be able to enter these contracts, and she shouldn't have been in the contract in the first place, which is 100% Tommy Z's fault, because he never went back and checked for any verification that Ms. Flick was of age to enter this contract. Your Honor,
Yes.
I realize that my time has expired. May I conclude my argument?
Yes, go ahead.
This court should uphold that the Superior Court's decision that the best common law rule for the Virgin Islands is to allow minors to disaffirm their contracts and avoid liability within a reasonable time.
Thank you.
All right. Thank you very much. With that, our next squad, while the judges are tallying or scoring, is St. Thomas Seventh-day Adventist School appellants, Mr. Philip and Mr. Baptiste. Are you guys on here now?
Yes, we are.
There we go. All right. Judges, when you are ready, let me know. 1, 2, 3, and 4. All right. Please say and spell your name, your school, the party you represent, and the issue you're arguing.
Good afternoon. My name is Danny Phillip, D-A-N-N-Y, P as in pan, H-I-L-I, P as in pan. I represent the St. Thomas and John Seventh-day Adventist School, and I am on the appellant, Department of Education, and I will be arguing if the St. Croix North High School violated Ms. Flick's First Amendment right.
Good afternoon. My name is Zion Baptist, spelled Z-I-O-N, B as in boy, A, P as in panda, T-I-S-T-E. I represent the appellant, Tommy Z, and the issue I am arguing is whether the minors are allowed to disaffirm contracts.
All right. With that, could we get Mr. Phillip up? All right, the floor is yours. Time will start when you commence your argument.
Good afternoon, Chief Justice and Associate Justices. May it please the court. Honorable Justices, the U.S. Virgin Islands Superior Court erred when it found that the state, vis-a-vis St. Croix North High, violated Ms. Flick's First Amendment when it expelled her from the high school for organizing a protest among the students. Indeed, it is within this court's discretion to review the Superior Court's case de novo and reverse the holdings for errors in conclusion of law. Honorable Justices, this case isn't a matter of freedom of speech. It's a matter of a student being disruptive and breaking school policy and using freedom of speech as an excuse. Title 48 of the United States Code, Clause 23, Section 1561 provides that here, the United States Congress extends the Bill of Rights to the U.S. Virgin Islands, namely the protection of freedom of speech. However, it is well established that the individual citizen's right to free speech is not unlimited. Therefore, the Superior Court erred when it found that the St. Croix Nor High School violated Ms. Flick's First Amendment rights for the following three reasons. First, the First Amendment's protection of freedom of speech is not unlimited, and the Supreme Court has recognized circumstances where the state may regulate speech, namely in institutions of learning. Second, the department's regulation was a time and manner, not content-based restriction, granting greater deference under constitutional standards. And lastly, Ms. Flick's actions in her attempt to express herself led to being substantially and materially disruptive. Honorable Justices,
Let me ask you a question, Counsel. I think you recognize that the Superior Court found in Ms. Flick's favor, correct?
Yes, it is.
Now let's unpack that. In order to find that her rights were violated, they would have had to have found that there was no substantial interference with the functions of the school, correct?
That is correct.
All right, and with regard to the language, that it didn't run afoul of the strictures against foul language, hate speech, vulgar speech, correct? Otherwise, they would have found her not found in her favor. So, what is it you want this court to do, given the facts as found by the Superior Court?
I would like this court to overturn the ruling in the department and favor of the Department of Education, because Ms. Flick went across the boundaries and created substantial
disruption. Right.
Substantial disruption.
And on this record, how would we find that the Superior Court's findings were clearly erroneous? I mean, is this a record where there's overwhelming evidence to the contrary, that we should somehow conclude the Superior Court ignored?
Indeed, there are 4 reasons for showing that this was a substantial disruption, and severely so. First,
drill down and tell me what they are.
First, there were multiple teachers that had to stop their classes to address T-shirts in their class, which were a direct violation of school policy, according to page 4 of the record. Second, the AP Government and Civics teacher, John Keating, did not get you 75% of his lesson plan for those 2 days, according to page 4 of the record. Thirdly, the students were violating the St. Croix High School uniform policy. When students are present in Zoom, students must have their cameras on, be visible, and be in their uniforms, according to page 2 of the record. And even the principal, Edward Rooney, stated that he was not being able to control and govern the student body properly due to Ms. Flick's action, disruptive protests, and her inciting of the other students, according to page 4 of the record.
Okay. Well, why don't you deal with the issue of the language that was used? Was it foul? Was it hate speech? Was it vulgar speech? Was it lewd?
Not at all.
All right, so we can put that issue aside.
Yes. The restriction that the school made, it was not content-based. It was a matter of time and manner. St. Croix North High School regulation of speech at the school constituted a time and manner restriction, not content-based. Indeed, the U.S. Supreme Court has decided on this issue on multiple occasions, recognizing that...
Let's take the case that the record cites. the Supreme Court case of Mahanoy Area School District versus BL. Does that case involve time and manner distinctions?
Indeed it does.
Well, good, let's hear.
So the student may have been off campus, but she was having schoolwork done during a virtual platform. And Mahoney has talked about how off-campus speech can be regulated. There are under three situations: local parentis, which is schools will hardly stand in the role of parents. But in this case, the students were still under the school's jurisdiction because these protests happened between school time from 8 to 3. Then secondly, since they are at home, and this would end up showing 24 hours of checking their speech. But again, they're only looking at the time they were under their jurisdiction from 8 to 3. And lastly, the schools are supposed to have an interest in what the students are saying and to protect unwanted or unvaluable speech. So in that case, it brings me back to the second point, that is not content-based. It was a time and manner restriction of where she did it.
You would agree that a substantial part of her conduct occurred off campus, correct?
Yes, but in school, on school time and in the school platform.
And so how do we weigh that evidence? How do we do that on this record?
Could you repeat the question, Ron?
How do we weigh, how much I can't tell from the record how much time she spent at home versus how much time she spent in school that you're focused on.
But we're focused on the time period of where school is, 8 a.m. to 3 p.m. And it was in this area of time where Ms. Flick's protest took place.
Okay.
So they were under the jurisdiction of the school. So in JS versus Blue Mountain School District, a case about a student who made a mocking Facebook of her teacher. In this case, the Third Circuit concluded that a student could not have punishment for speech that occurred off school campus and off campus hours. In our case, the school has no problem with what Ms. Flick and the other students protest. Ms. Flick and the other students talked about TAA's effect on the students' learning ability, which is the school's officials' responsibility. The problem is that it occurred at the wrong place and time. According to the record, these protests occurred during Synchronote High's hours in the school Zoom, while the teachers for this school were present. These things are the polar opposite of what happened in the JS case, because JS was at home and not on school time. Ms. Flick was in school on school time. These facts bring us to the third point.
Time.
I see my time has elapsed. May I briefly conclude?
Yes, go ahead.
In conclusion, honorable justices, the court erred that Ms. Flick's First Amendment right of freedom of speech was not violated because she went out of the restrictions of freedom of speech for students in school. Ms. Flick organized and gave her protest at the wrong place and time. And lastly, Ms. Flick disrupted school learning and violated school policy by the actions committed that has been shown in the evidence. So the school being put in that position had to give punishment and deem her speech as not pure, so that learning and school order could continue. And that is why her expulsion did not in any way violate her freedom of speech. So for the following reasons, we ask that the U.S. Virgin Islands Supreme Court overturn this ruling in the favor of the Department of Education. Thank you.
Thank you.
All right. Mr. Baptist. While the judges are scoring, please get prepared to give your arguments. Judges, as usual, give me a signal that you're good to go. 1, 2, 3. McLean, are you? Oh, okay. You look frozen. That's why I was asking. All right. By all means, the floor is yours, Mr. Baptiste. The time will start running when you begin your arguments.
Good afternoon, Chief Justice and Associate Justices. May it please the court. Honorable Justices, I ask that this court review the issues of this case in the de novo and for clear error. While the state of the law in the Virgin Islands may yet to be resolved, the facts of this case strongly weigh in favor of my client, Tommy Z. When a contract is made, both parties are supposed to provide what they agreed to. In this case, Mr. Z with the t-shirts and Ms. Flick with the money. However, after my client, Tommy Z, made the t-shirts and arrived at the pickup spot, Ms. Tracy Flick conveniently did not show up, nor did she pay him. She has not complied with the terms of this contract and must be held fully liable for this. I have 3 reasons as to such. First, in weighing the factors, as laid out in this court's holding, in Banks versus International Lease, the best and soundest rule for the Virgin Islands is to allow minors to disaffirm their contracts within a reasonable amount of time. Emphasis on reasonable. Second, the Virgin Islands legislature has clearly manifested its intent to subject minors to liability upon emancipation, such intent being codified in Title 16 of the Virgin Islands Code, Sections 221 and 261. Third, the uncontroverted facts of this case strongly favors an outcome that does not allow Ms. Flick to avoid liability under the contract. More specifically, allowing Ms. Flick to disaffirm the t-shirt contract is neither reasonable, nor does it comport with the realities of the circumstances faced by my client. Because of this court's recent establishment, not everything has a case or a law to say what the soundest rule for the Virgin Islands is. Because of this, the court ruled in the Banks analysis that if a particular case does not have an example for the issue presented, we must then look to what the majority of jurisdictions are doing and then decide the soundest rule for the Virgin Islands. Because there is no case law on our particular case today, we must look at what the majority of jurisdictions are doing. The Bakley versus Mount Bachelor case, taking place in the Oregon Appeal Court of 2013, is a case where a minor tries to disaffirm a contract. However, they are not allowed to disaffirm the contract because they use the ski contract 119 times past their 18th birthday, showing that they agree to the terms and conditions of the contract, as well as the fact that they did not act within a reasonable amount of time. Because they did not act in a reasonable amount of time, the court held that Mr. Bagley was liable for his contract. Now, in the opposite manner, we see in the Engelbert versus Traxel case, taking place in the Nebraska court in 1894, a minor was able to disaffirm a contract because he acted in a reasonable amount of time. Second, on April 19th, 2020, Ms. Flick turned 18, and the day after, Tommy Z contacted her parents so that she could pay him and she can receive the t-shirts. However, the parents said that she would not be paying anything, considering she was a minor at the time she made the contract. However, because Tracy Flick was 18, she is now an emancipated adult, according to Title 16 of the Virgin Islands Code, Section 261, and is fully liable for all contracts that have not yet been disaffirmed. Now, within the span of the Monday meant for pickup, and when my client Tommy Z contacted Mrs. Tracy Flick's parents, she never once tried to contact Tommy Z in any way to disaffirm the contract. Inaction does not equate to intent to disaffirm, and because of this, Ms. Flick should be held fully liable for the t-shirt contract she entered into with my client Tommy Z. Third, Title 16 of the Virgin Islands Code, Section 261 states, all persons are deemed to have arrived at the age of majority at the age of 18 years, and thereafter shall have control of their own actions and businesses, and have all the rights and be subject to the liabilities of the persons of full age. Because Ms. Flick is an emancipated adult and has shown no intent to disaffirm the contract she made with Tommy Z, Tracy Flick should be held completely liable. Though Tracy Flick's parents said that she would not be affirming any contracts because she was emancipated, they had no say in the matter. In conclusion, Your Honor, my client understands that the legislature is the best suited forum for the development of the public policy in the Virgin Islands. However, because of this court's recent establishing, not everything has a case or a law to determine what the best course of action may be. Because of this, we understand that no two parties can enter or exit a contract without at least showing intent to do so. However, the law does not support that inaction is equal to showing intent to disaffirm.
Well,
What
why
is
not?
clear, however,
Why isn't inaction evidence of disaffirmance of the contract? I mean, if you wanted the contract, wouldn't you say so?
correct, Your Honor. And Tracy Flick did want the t-shirts as to why she called Tommy Z in the first place. However, my client is not sure why Miss Flick did not recontact him. She could have been busy preparing for her birthday, which was the April 19th, or doing anything else as to why she could not contact Mr. Z.
So are you saying that because she didn't contact him, that's evidence that she wanted the contract to go forward, or it was evidence of disaffirmance?
Incorrect, Your Honor. Tracy Flick not contacting my client Tommy Z is not showing inaction. Inaction is not intent to disaffirm.
So what is it evidence of?
May you repeat your question, Your Honor?
What is inaction evidence of?
Inaction simply shows that she did not want to do anything yet. She did make the contract with my client as shown how they wanted. There was a set pickup time and there were several calls. However, it does not show that Ms. Tracy Flick did not want to receive the contract's benefits again.
Let me ask you just a quick question. When the contract, quote, was entered into when Tracy Flick was in her minority, when she was 17, would you agree that there was really no binding contract at that point?
Correct, Your Honor. There was no binding contract at that point. And at any time, if Ms. Tracy Flick wanted to, she may have disaffirmed. However, she did not do so.
If there's no binding contract, what is there to disaffirm?
Your Honor, the contract is now binding because Ms. Tracy Flick is 18 years old. She has become an emancipated.
If she had no binding contract before and has done nothing, then why does she suddenly have a binding contract?
Because she has been emancipated and must take liability, Your Honor.
But she hasn't said, I've got a contract with you.
Your Honor, I see that my time has elapsed. May I conclude?
Yes.
Yes.
Your Honor, my client understands that the legislature is the best suited forum for the development of the public policy in the Virgin Islands. However, because of this court's recent establishing, not everything has a case or a law to say what the best course of action may be. We understand that no two parties can enter or exit a contract without showing intent to do so. However, the law does not support that inaction is equal to showing intent to disaffirm. What is clear is that Tracy Flick, while she was a minor, did not take any steps to manifest her intent to disaffirm the contract. Accordingly, this court should reverse the Superior Court's holding and find Tracy Flick liable under the T-shirt contract. Thank you.
Thank you.
Thank you.
All right, very good. While the judges are completing their score sheets, our next arguments will be from Antilles appellees. Antilles had a alternate, Kayla Bellew. She will not be arguing, but she was a part of the team this year. with that, judges, when you give me the all clear signal, I will have this team enter their notices of appearance. 1, 2, 3. And 4. All right, please say and spell your name, the school, party you represent, and issue.
Good afternoon, Your Honors. My name is Kashish Chanani, K-A-S-H-I-S-H, Chanani, C-H-A-I-N-A-N-I, and I'm from Antilles School. I represent the appellee, Tracy Flick, and I'll be addressing issue 1, whether the Superior Court erred in its finding that Ms. Flick's First Amendment rights were violated.
Good afternoon, Your Honors. My name is Aisha Kimani. Aisha, A-I-S-H-A, Kimani, K-H-E-M-A-N-I. I'm from Antilles School, and my client is Ms. Flick, the appellee. I'll be addressing issue 2, whether or not the Superior Court erred when it determined that the best rule for the Virgin Islands was to allow minors to disaffirm their contracts and avoid liability after reaching the age of majority.
All right. Ms. Tanani, when you begin speaking, the time will begin running.
Good afternoon, Your Honors. May it please the Court. Our position is that the lower court was correct when it found that Ms. Flick's First Amendment rights were violated. The judgment of the Superior Court should be affirmed for 4 reasons. 1, the expression is protected because it's considered symbolized speech. 2, it was not substantially disruptive to the learning environment. 3, the language on the shirts was not vulgar. And 4, fear is not sufficient to take away someone's First Amendment rights. With the switch to virtual learning following the COVID-19 pandemic, Tracy Flick and many students got extremely frustrated with the unreliability of TEA. Tracy Flick and all the students designed their own t-shirt and wore it outside of school and they designed the t-shirt outside of school and outside of school hours without violence or profanity on it, to wear while they were at home off campus to voice their opinions against TEA. The school was not targeting any member of the school community and is protected by their First Amendment rights. Moving along, it is protected because it's considered symbolized speech. In Tinker, the United States Supreme Court established that symbolized speech is protected by the First Amendment. The court also said that students don't lose their First Amendment rights while in school. In Tinker, the students wore wristbands to show their opposition to the Vietnam War, and the court ruled that such expression was protected. And considering our case today, the students wore t-shirts, which are still articles of clothing, therefore considered symbolized speech. In both cases, the students were not engaging in a violent, distracting, or disruptive demonstration, and instead were just wearing clothing to express themselves and to display their message. Their actions did not materially or substantially interfere with the learning process. As the court stated in Tinker in many cases that followed, if a student's conduct is not substantially disruptive, it is protected by the First Amendment. When Tracy Flick and the other students wore the t-shirts, they were not substantially disruptive to the learning environment. They were just publicizing their objections to TEA. The students lost at least a whole day of school every month because of TEA's unreliability, which was the actual hindrance to their education. The school wasn't being accommodating, as they weren't trying to make up for any of the lost time. Since it's the school's responsibility to effectively provide the education to the students were right to bring their concern to the school officials. In JS v. Blue Mountain, a student was suspended for creating a mocking internet profile for her principal, which she made on her own computer. The court decided that the actions of the minor did not constitute of a substantial disruption immediately or in the future. Similar to that case, In our case, Tracy Flick communicated with her friends on TikTok on her personal device and designed the t-shirts outside of school hours. Her actions were not substantially disruptive to the learning environment and would not be in the future either. Furthermore, her symbolic speech was not directed at any school official, while in JS, the social media account was directly attacking the principal. In Mahanoy, the court said that schools can only regulate speech in certain situations, when it's vulgar speech uttered during a school assembly on school grounds. In our case, the speech was not vulgar, was not uttered during a school assembly or on campus. Therefore, the school does not even have the right to regulate the speech.
Counselor, I keep hearing you say that the school, I heard you say the school doesn't have the right to regulate the speech, but the school has a purpose. Its purpose is to teach. And when that purpose is disrupted, then the school has a right to do what it must to ensure that that purpose is carried out and is not derailed by actual or even symbolic speech. Are you asking us to go against that precedent, and why?
No, Your Honor. I'm asking you to consider the precedent already set in Mahanoy, which said that schools can only regulate the speech if it is vulgar speech uttered during a school assembly on school grounds. And in our case, none of it fits that criteria.
Thank you, Counsel.
In Mahanoy, the court also stated that public schools have the duty to teach students that freedom of speech is essential to self-government. Restricting Tracy Flick from using her First Amendment rights to freedom of speech is directly in violation of this duty. They also said that students are allowed to express their opinions even if it's unpopular, expressed in an inappropriate manner or harmful manner. And in our case, they were neither inappropriate because it was largely supported by all the students. It was not expressed inappropriately or in a harmful manner, but either way should be protected by the law. In Cohen v. California, Cohen was arrested for wearing a jacket with vulgar language on it in public to show his opposition to the Vietnam War. The Supreme Court ruled that it was indeed a violation of his First Amendment rights because Cohen had not engaged in any acts of violence, did not make loud or disruptive noises, and his speech did not consist of fighting words directed at anyone. In addition, his speech was not causing violence, and anyone who felt uncomfortable or offended could simply look away, which is what the court said. In our case, Tracy Flick and the other students wore a shirt which had no vulgar language on it, and her actions neither incited violence or made any loud or disruptive noises. It was simply a form of self-defense.
But Counsel, while it was quiet, it was disruptive. Do you agree or not?
No, Your Honor, I don't agree.
What would be considered disruptive?
Well, in our case, TEA was the actual hindrance to their education because TEA was causing them to lose at least a whole day of school in a month because of how unreliable they were. In our case, Tracy Flick, when wearing the t-shirts, she caused discussion with her AP government teacher, which is considered a key part of the AP government curriculum.
And what about those students who wanted to learn government that day and did not want to discuss T and how ineffective it is? What about their educational disruption?
Yes, Your Honor. It is shown in this case that all of the students supported the issue. All of the students wore the t-shirts and all of them made it themselves, which showed that they all largely supported this issue. And an AP government curriculum covers First Amendment rights and constitutional rights. So this was very pressing and very important to the curriculum of AP government. Moving along to my fourth argument, fear is not sufficient to take away someone's First Amendment rights. Tinker, Mahanoy, and JSC Blue Mountain all emphasize that undifferentiated fear or apprehension of disturbance is not enough to overcome the right to freedom of speech. Principal Rooney said that Tracy Flick was dangerous to the other students, therefore he expelled her. The expulsion simply based on his fear. Your Honor, I see that my time has ended. May I please conclude?
Yes.
Because Principal Rooney suspended her just based on his fear, it is unconstitutional, and in conclusion, the Moot Superior Court was correct in ruling that Ms. Flick's First Amendment rights were violated. We respectfully request that you affirm the lower court's decision to allow Ms. Flick to be reinstated and to receive the tutoring services. Thank you.
Thank you.
All right. Let me know when you're ready. One, two, three.
May it please the court.
Just a second.
Oh, sorry.
I was going to turn on a light because it's getting dark where I am.
Okay.
The sun's going down. Okay, I'm good.
You ready, Sam?
I'm ready.
All right. You may begin.
May it please the court. Our position is that the lower court was correct in ruling that minors can disaffirm their contracts and avoid liability after reaching the age of majority. Firstly, Tracy Flick didn't benefit from the agreement. Secondly, the t-shirts aren't a necessity. Thus, the contract can be disaffirmed. And lastly, Tracy Flick was 17 at the time that she entered into the contract. The Virgin Islands Code, Title 16, Section 261, states that all persons are minors until they reach the age of 18. We believe that the court should also apply these sections of the code to contracts. On April 13th, 2020, Tracy Flick was a minor when she placed an order for 200 custom printed t-shirts from Tommy Z's Mediocre Tees. On April 20th, Tommy Z let Miss Flick know that the tees were ready for pickup. However, she did not go to pick up the t-shirts. Upset with the situation, Tommy Z contacted Miss Flick's parents, who refused to honor the contract. Under the law, Tracy Flick should not be held liable for the contract. Since there is no definite rule for the subject at hand in the Virgin Islands, the court must conduct a Banks analysis to determine the best rule for the Virgin Islands. A Banks analysis requires 3 steps. How have Virgin Islands courts previously ruled on the issue? In this case, there is no case law nor statutes on point. Secondly, to consider the position taken by a majority of courts from other jurisdictions. And lastly, determine what the soundest rule for the Virgin Islands is. We believe that the best rule for the Virgin Islands is to continue to protect minors from liabilities in contracts. The first thing to consider in deciding what is the best rule for the Virgin Islands is to determine whether or not a minor received benefit from a contract. Courts have stated that it is within a minor's rights to disaffirm a contract without consequence as long as they haven't benefited from it. The second part of the Banks analysis requires the court to consider how other courts from other jurisdictions have ruled on the issue. In Porter versus Wilson from the state of New Hampshire, a minor had received legal services, but later disaffirmed the contract and ultimately benefited from the legal services. In this case, the minor was required to pay. However, the court held in this case that a minor may disaffirm the contract and is not responsible for restitution if they did not receive benefit from the contract. In the case today, Tracy Flick did benefit from her agreement with Tommy Z. The court should also consider whether the contract was for a necessity. Courts have stated that minors can only be held liable for contracts that are for necessities. The tees are non-essential items since they're custom made. Therefore, Tracy Flick was free to disaffirm her agreement with Tommy Z. The court should also consider the relevant decisions out of Wisconsin and Nevada. In Kiefer versus Fred Howe Motors, the court held that Kiefer could disaffirm his contract with a car dealership because he was a minor when he purchased the car and because the car was not a necessity. Additionally, in Engelbert versus Troxell in the state of Nevada, the court affirmed that contracts made by minors for items other than necessities are voidable, and the minor may disaffirm their contract after they come of age. In this case, Engelbert attempted to disaffirm the sale of his mother's land once he had reached the age of majority.
Counsel, let me ask you a question. Did she disaffirm this contract, or did the Superior Court just decide it was going to put its own interpretation on this and apply the doctrine?
Yes, Your Honor, she disaffirmed the contract by not picking up the T's on the specified date that Tommy Z had called her, which was April 20th. It was the date he expected her to pick up the T's. When she didn't show, this was an act of disaffirmance on that specified.
How was he supposed to know that that was an act of disaffirmance based on her minority, as opposed to just thinking, hey, let me keep calling this person, maybe something happened?
Because he called her, Your Honor, on a specified date. That was the date of pickup, April 20th. And because she didn't show on that date, nor did she contact him in any other way and say that she still wanted the shirts, that should have been the act of disaffirmance that Tommy Z should have considered.
Well, it may be that she just didn't want to pay. And now he goes to court and he says, hey, just like he would for any other person who would have ordered T-shirts and not picked them up. He goes to court and she still doesn't say, well, I do not want your T-shirts. He says, hey, you're just a bad payer and I'm going to get my money. And here comes the Superior Court saying, well, the Superior Court seems to have made that argument more so than, is that the Superior Court's position? Does the Superior Court, was it within its authority to make that affirmative disaffirmance on behalf of Tracy Flick?
Yes, the Superior Court affirmed that Tracy Flick, that was her act of disaffirmance, not showing up on that specified date of April 20th, when that contract was made. So lastly, considering that there is no case law on point in the Virgin Islands, it is important to note that the Virgin Islands legislature has enacted VI Code 16, Section 261, which states that at the age of 18, one can be held accountable for their own actions and business. Tracy Flick was a minor, 17 years old, when she entered into the agreement with Tommy Z. We believe that there is no reason to diverge from the established age of 18, seeing that the statute specifically references the conduct of business. In the case Bagley versus Mount Bachelor from the Oregon Court of Appeals, Bagley, a 17-year-old, had purchased a season pass for Mount Bachelor, which included an agreement that released the ski company from liability if Bagley suffered injuries on the ski slope. Later, when Bagley turned 18, he sued the company for liability after suffering injuries, after jumping on an artificial jump. In Oregon, a minor may disaffirm a contract within a reasonable time after reaching the age of majority. However, since Bagley had utilized the ski pass and ultimately benefited from it after his 18th birthday, the court determined that he had affirmed the contract. Here, Tracy Flick didn't receive any benefit from nor did she utilize the tees. Therefore, according to the analysis seen in Bagley, she is well within her rights to disaffirm a contract. The portion of the VI Code is adopted from the Oregon Code, making this case highly persuasive. In conclusion, it is the soundest rule for the Virgin Islands to allow minors to avoid liability and disaffirm their contracts.
Why is it so beneficial for the Virgin Islands to adopt this policy? Isn't it going to encourage a lot of other minors to enter into agreements and then to just walk away from them, leaving business owners and other persons in deep trouble because they've expended money, like in this case?
Your Honor, while we understand it is a sensitive situation, a considerable amount of minors reside in the Virgin Islands. Adopting this rule would provide them with the necessary protections and allow them to grow in a safe environment. respectfully request, in conclusion, that this court affirm the decision of the lower court and find, Your Honors, I see that my time is concluded and I have finished the last couple of words of my conclusion.
Yes.
We respectfully request that this court affirm the decision of the lower court and find that Ms. Flick wasn't liable for the contract she entered into at 17 years old as a minor.
All right. Well, the judges are totaling. Our next team will be St. Peter and Paul Catholic School appellants. Alistair Carty and Ethan Farrell, are you online? Okay. Well, judges will give me the all clear sign when you're ready to go. 1, 2, 3, 4. Oh, 1 second. You ready, Gordon? Oh, okay.
Yeah, I've been ready. I don't know if you heard me.
Oh, no, okay. I thought you were telling me to wait. All right.
No, I've been done. You must have missed me the first time I stuck my hand up.
Oh, I thought it was okay. Sorry about that. My bad. Yes, please say your name and spell it, the school, the party you represent in the issue you're arguing.
Good afternoon, Your Honors. My name is Alistair Carty, ALISTAIRCARTY, and the school that I attend is the St. Peter and Paul Catholic School. And the issue that I will be arguing is whether the St. Croix North High School's principal and vice principal violated Ms. Flick's First Amendment rights. And the side that I represent is the appellant.
All right.
Good evening, Your Honors. I am Ethan Farrell, ETANFARRELL, and I attend the St. Peter and Paul Catholic School. The issue that I'll be arguing is whether the Superior Court erred when it determined that the best common law rule for the Virgin Islands is to allow minors to disaffirm their contract and avoid liability. The side that I will be arguing is the appellant.
All right. With that, Mr. Carty, time will begin to run when you begin your arguments.
Good afternoon, Your Honors. May it please the court. The Superior Courts did err when it found that the St. Croix North High School's principal and vice principal violated Ms. Flick's First Amendment rights. First, Ms. Flick was punished for her speech because it caused a material and substantial disruption. Her speech also involved substantial disorder. Her speech infringed on the rights of other students. Alternatively, however, Ms. Flick was punished for violating the school's dress code. Ms. Flick caused a material and substantial disruption because her civics teacher, Mr. Keating, had to have a discussion with his students on the trimming of the shirts. Let's keep in mind that this disruption lasted for 2 days, and it not only happened in one class, but many other classes, considering the fact that many students were taking pictures of the shirts and posting it on different social media sites. We can concur that this took out 75% of Mr. Keating's lesson plan. And considering the fact that there were no TEA officials there to witness this action, the only common viewers would be the teachers in this situation. Ms. Flick's speech also involved substantial disorder, meaning that it was vulgar and profane. If we look at the "you suck" portion of the phrase, it can be considered indecent. If we refer back to the Traplinski case, it states the specific categories in which speech can be suppressed, and those categories being the speech must not be decent, lewd, vulgar, profane, and fighting words. This word "you suck" would not be appropriate in a school setting. There was no use for the word.
Is it the setting that makes the word vulgar?
No, Your Honor, it would be the context in which the word was used.
Context in which it was used makes it vulgar. The Superior Court didn't find any of the words that were used vulgar or hate speech or foul language. So how do you get around that?
Well, Your Honor, as I previously stated, the "you suck" portion of the phrase, in which the context it was used, it can be seen as indecent, Your Honor. The reason being is that the word "suck" is seen as disagreeable or disgusting.
Well, I don't quite understand that. If you clearly the word "suck" has other meanings that are not considered vulgar. I think what you're referring to here is the sort of innuendo here, but the word itself is not an inherently vulgar word, is it?
Depends on the context, Your Honor.
I see. So what about the context that the Superior Court not get?
They did not get that in which the context was the word was used. The phrase said, "Forget you, TA, you suck." As I said, the word "suck" means disagreeable, disgusting.
Isn't the word "suck" used as a slang word these days?
Yes, Your Honor. Suck
like you stink, or you're, in a derogatory way, but not necessarily a foul language. Am I wrong about that?
Yes, Your Honor, but however, let's keep in mind that Miss Flick was in a school setting. This word did not needed to be said or shown in a school setting, Your Honor. Miss Flick's speech also infringed on the constitutional rights of others. Miss Flick disrupted the learning process because she wore a shirt that was not a part of her school uniform, thereby leading the teacher, Mr. Keating, to have a discussion with his students. Miss Flick also encouraged other students to wear the shirts between intervals of her classes. In the Tinker Rule, it states that a school is permissible to punish a student if their speech is materially disruptive, involves substantial disorder, and infringes on the rights of others, in which Miss Flick's speech did. Alternatively now, Miss Flick was punished because she violated the school's dress code.
Well, she wasn't the only one, though, right? I mean, weren't there other students who violated the dress code?
Yes, Your Honor, but
so and the principal didn't penalize anybody for violating the dress code. Is that correct?
Yes, Your Honor, but Miss Flick was the ringleader of this plot. Therefore, she was punished as an example, Your Honor.
But not for violation of the dress code. I'm sorry, go ahead.
I was saying that she violated the school's dress code, Your Honor.
Right, along with many other students, but none of whom were sanctioned for violating the dress code, right?
Yes, but in this case, Miss Flick was punished to prevent chaos from brewing in the school. Therefore,
so tell me, what was there about Miss Flick's T-shirt or dress code violation, or her recommending that others wear a similar T-shirt? What about that threatened the peace and stability of the school? Because I'm having a problem finding that.
Well, Your Honor, one of the school's rules states that the students must be in uniform on Zoom online with their cameras on. Miss Flick is encouraging other students to violate the school's dress code by wearing the shirt that said, "Forget you, TEA, you suck."
I haven't seen anything in the record that indicated that she was told not to encourage others. So I'm not sure where you're getting that from. If you could help me out.
Your Honor, Ms. Flick violated the school's dress code. Ms. Flick knew that she needed to be in her school uniform, but she decided to ignore this rule and wear shirts, Your Honor, that were not a part of her school uniform in any way. Even so, if Ms. Flick wanted to convey her emotions toward the government company TEA, she could have used the virtual whiteboard that was assigned on their home issue computers. It would not have mattered if Ms. Flick wore a plain t-shirt or a dress. She still would have gotten punished for violating the school's dress code.
Except she didn't get punished for violating it, did she?
Yes, Your Honor, she did get punished.
For violating the dress code, or for encouraging people to wear t-shirts and protest as she wanted them to protest?
Yes, Ms. Flick did it. She did protest, but she was punished for violating the school's dress code and encouraging others to take part in this action.
Where was the material disruption?
It was material and substantial because Mr. Keating, her civics teacher, did not complete 75% of his lesson plan. In conclusion, simply because Ms. Flick has freedom of speech, this does not mean she is free from the consequences that follow her. Her punishment was permissible because she caused a substantial disorder, she violated the school's dress code, she encouraged other students to take part in this action, and due to all of these reasons, I respectfully request that you reverse the Superior Court's decision. Thank you.
Thank you.
Yeah.
All right, let me know when you're done scoring. One. Gotcha, Gordon.
Got me that time. Good.
That's 3.
Done.
All right. Mr. Farrell, yes, Farrell, you may begin.
Good afternoon, Your Honors. May it please the Court. The Superior Court erred when it determined that the best common law rule for the Virgin Islands was to allow minors to disaffirm their contract and avoid liability. The best common law rule for the Virgin Islands should be that a minor is bound by their contract and must pay restitution to the seller. This court should reverse the Superior Court's decision because first, the t-shirts were custom made and cannot be sold to anyone else but Ms. Flick. Second, Ms. Flick didn't attempt to disaffirm the contract after knowing she was not in need of the t-shirts. And finally, Ms. Flick had a reasonable amount of time to disaffirm the contract. On April 13, 2020, Ms. Flick contacted Tommy Z. Mediocre and requested 200 t-shirts with a message, "Forget you suck," be made by April 20th, 2020. Since Ms. Flick contacted my client, Tommy Z, via phone, it is not customary for a merchant to request a government issue ID. Therefore, Tommy Z couldn't have known Ms. Flick was a minor. Tommy Z had the t-shirts ready on the agreed delivery date, but Ms. Flick never called or came to pick up the t-shirts. Your Honors, may I remind you that it was 200 custom-made t-shirts, and my client, Tommy Z, cannot sell those t-shirts to anyone else but Ms. Flick, and must come up with the money to pay for those t-shirts. In the Porter case, it states, a contract of an infant or lunatic, whether executed or executory, cannot be avoided without restoring the other party. Your Honors, may I remind you that minors are being tried for criminal cases at a young age, and 16-year-olds are being put for accidents that they get into. It is unjust if Ms. Flick doesn't pay restitution to Tommy Z over a simple transaction. Your Honors, this law or rule was adopted in 1965, and children in the 21st century are more sophisticated and mature than children in 1965. For example, Ms. Flick was an intelligent young woman who took part in moot court, the student government, the chess club, and even hold events in her community. Secondly, Ms. Flick didn't attempt to disaffirm the contract after knowing she was not in need of the t-shirts. In the Bagley case, the court concluded since Bagley continued to snowboard at Mount Bachelor, once reaching the age of majority, he manifestly showed the intent to agree to the seasonal pass by snowboarding 119 times. In our case, Ms. Flick let the contract stand by not contacting Tommy Z to disaffirm the contract.
What would you consider to be sufficient disaffirmance? We've heard arguments that she disaffirmed by simply not showing up, and that indicated that she wasn't interested in the contract anymore, and that amounted to disaffirmance. What's your response to that?
Your Honor, a client must state it orally or in written to disaffirm the contract. And in not doing so, Ms. Flick let the contract stand, therefore making Tommy Z make 200 t-shirts that she was not going to pay for.
Well, would you agree with me that when she was 17, she didn't have the authority to enter into a binding contract?
Yes, I agree with you, Honor.
Okay, and so there was no contract for her to disaffirm. Would you agree? After she turned 18.
Can you repeat your question, please?
Yes. If she couldn't have formed a contract when she was 17, but that's when she had her conversations with your client, if there was no contract because she was too young to make one, then there was no contract that she needed to disaffirm when she became 18. Isn't that right?
No, Your Honor. It's still a contract because she didn't disaffirm the contract with Tommy Z.
But if she couldn't have made a contract when she was 17. So there was no contract that existed that she needed to disaffirm, right?
No, Your Honor, because in society now, minors are being able to order stuff online, and they are able to agree to terms and services by Apple and any social media platform. So they are agreeing to contracts online, and therefore Ms. Flick should be liable.
But if they're agreeing to contracts online and they're too young to be bound by a contract, then there is no contract, right?
Can you repeat that question again?
Yeah. Let's say a 17-year-old online agrees to a contract. There really isn't a contract, as I understand it, right? Because a 17-year-old can't enter into a contract.
Well,
so
in Ms. Flick's case, it was 6 days before. It was 6 days of the contract. Therefore, she didn't gain any knowledge about contracts during the 1 week she made the age of majority.
Mm-hmm.
In our case, it states that same evening that Ms. Flick contacted Tommy Z, someone let the school was going to stop such actions from happening. So the students decided to pool their money together to buy $50 white t-shirts from Kmart and customize it with paint and markers. Your Honors, Ms. Flick knew that same evening she was not in need of the t-shirt, and she should have called Tommy Z and disaffirmed the contract. Finally, Ms. Flick had a reasonable amount of time to disaffirm the contract. In the Engelbert case, it states items other than necessities are avoidable and may be disaffirmed when the minor becomes of age. Your Honors, if this rule stands, business owners will be losing profit from the scandalous act that these teenagers are committing, such as my client Tommy Z, who wants to come up with the money to pay for the t-shirts, 200 t-shirts that Ms. Flick ordered. Therefore, I request Ms. Flick pay restitution to Tommy Z. To conclude, Your Honors, this court versus the Superior Court's decision that the best common law rule of the Virgin Islands should be that minors should be bound by their contract and must pay restitution to the seller. Because the t-shirts were custom made and cannot be sold to anyone else but Ms. Flick, Ms. Flick had a reasonable amount of time to disaffirm the contract, and Ms. Flick didn't attempt to disaffirm the contract. Also, Ms. Flick should be held accountable for her actions and pay restitution to Tommy Z. Thank you.
Thank you.
All right. Well, you are all totaling that. Could we have Charlotte Amalie High School appellees? This is our last round of argument coming up here. And this squad had an alternate participate this year, Aliziana Caceres was the alternate. She will not be arguing today, but we do appreciate that she participated and put the effort in. Judges, when you are ready, Gordon's good. DeLace, Sam, Felice, all good. All right, please say and spell your name, the school, the party you represent, and the issue you're arguing.
Good day, Your Honors. I am Sade Richardson. That is SHAUDAE, Richardson, RICHARDSON, from the Charlotte Amalia High School, representing the respondent, Tracy Flick. And I will be addressing the first question on appeal, whether there was a violation of Ms. Flick's First Amendment rights.
All right.
Good day, Your Honors, and all in attendance. I am Shania Martin. That is SHANIA Martin, MARTIN. I am representing the respondent, Tracy Flick, and I will be addressing the second question on appeal.
All right. When you begin your arguments, the time will begin running.
May it please the court? Your Honors, my client, Tracy Flick, is intimately familiar with disruption, actual, tangible, substantial disruption. In fact, every student residing in the Virgin Islands has experienced some form of upheaval in the past 5 years. Twin Category 5s, the death of a friend, a world-altering pandemic, the TEA interrupting remote learning, and now a clear violation of her First Amendment rights when her entire class were simply expressing themselves and their frustrations in a respectful manner. The Superior Court correctly found the First Amendment violation, and ruling should be affirmed for the following reasons. Point 1, the speech of my client that is actually being punished, which is the idea she presented to her classmates, is off-campus speech. Point 2, no part of Ms. Flick's speech caused or would have caused a significant disruption. And point 3, even if any part of her speech was considered on campus, a student's rights or their speech does not disappear at the schoolhouse gate. To my first point, let's address the nature of my client's speech. The facts show that she utilized TikTok, a social media platform, which is primarily used by minors on cellular devices. She was also in her home. This alone shows that my client's communication, unrelated to her coursework in her 4 classes, is off campus. In both Mahanoy VBL and JSV Blue Mountain, the students used social media, and although their speech did enter the school's campus, the speech itself was off campus. The start was not the start of my client's conversation. It was the end. A conversation that involves 25 students. They argued or defended themselves respectfully, quietly, and non-disruptively. That conversation was not defamatory or obscene. In BL, the Snapchat video was explicit and was directed at the school's chair program and the chair team. In JS, the MySpace page was filled with crude and juvenile jokes. Nothing my client said is obscene, but like JL, BL, and JS, it occurred off campus. Unlike BL or JS, however, Ms. Flick did not antagonize the school, its staff, nor did she curse out the TEA. She stated the feelings and frustrations of many of her peers, hence why they, as a collective, decided to wear a shirt. This shirt was not accompanied by anything other than arriving to class, intent on learning, with cameras on, in the exact way that the Virgin Islands Department of Education wanted. The entire class was in attendance and prepared to learn. To my second point, Your Honors, the purpose of the school uniform being worn at home with cameras on was to ensure attendance, not attire. My client was in attendance, actually. Her entire class was. Cameras on, all visible, and all ready to learn in their homes. If there was any disruption, the cause was Mr. Keating, not his class and not my client. That statement is not to besmirch Mr. Keating. He rightfully listened to and spoke with his students. As a teacher of AP Government and Civics, his lessons shifted from the theoretical to the real world. The issue before the court is two principals seeking to punish one student based upon their whims. In Cohen v. California, Mr. Cohen wore a shirt in a courtroom which clearly had an expletive condemning the draft. The Supreme Court of the United States ruled Cohen had not engaged in any acts of violence, did not make any loud or disruptive noises, and did not deliver speech that consisted of fighting words that were directed at any reader. Ms. Flick's situation is exactly the same, except there is no profanity and no disruption caused by her attire. Tinker provides the unmistakable holding of this.
Except counsel Richardson.
Yes.
Except the two cases are not the same. We have an adult going to a courthouse with a jacket over his arm that he appropriately and discreetly put the offensive language away. In contrast, we have your client going to the school, violating the school code of dress, wearing a t-shirt that she knows is provocative. I mean, otherwise, why do it? She knows this t-shirt is provocative, and yet she's saying, oh, she now wants to hide behind the First Amendment. Where do you draw the line between school discipline and the right of your client to say such provocative things via her t-shirt?
Your Honors, I understand where you're coming from, but at the same time, Ms. Flick did not wear the shirt by herself. She wore it with her classmates. If that was
and
the case,
that makes it all the more dangerous, does it not? Because it would be one thing if it were one student, but now you have a classroom full of students ganging up to participate in this kind of behavior. How do we maintain law and order and discipline in such a setting?
Your Honor, at the same time, if I may finish,
yes.
That's why I was trying to say that maybe the whole class should have been punished in that case, not just my client.
But you do agree that it is a punishable offense?
Yes, Your Honor, I agree it's a punishable offense, but at the same time, you cannot punish one and not punish all if it's something that we did as a collective.
So had the principal expelled all 25 students, we would have been on firmer ground here. Is that your argument?
Your Honor, that's not the case before the court today. I'm arguing for my client. Tinker provides the unmistakable holding of this court for then almost 50, now almost 100 years. Students nor teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. This brings me to my final point. Even if this court was to say a portion of the speech or a part of the conversation happened on campus, students still have the right to express themselves. In Tinker, those students wore armbands, physically on campus. People addressed the armbands on campus. Some students raised objections. This occurred at multiple schools in that district. The punishment given to multiple students was harsh, but not near as harsh as the ones provided my client and only my client by Principal Rooney and Vice Principal Vernon, and the court still found that wearing armbands was entirely divorced from actual or potentially disruptive conduct by those who participated in it and should not be restricted. While the means of communication, the locations of schooling, and the method of providing instruction may evolve in ways we may not expect, it is unmistakable that the rights of students to speak freely, respectfully, and non-disruptively must be protected. It is for these reasons that this court should affirm the Moot Superior Court's ruling and maintain necessary protection. Your Honors, thank you for your time.
Thank you.
All right. Give me the thumbs up when you're ready, judges, and Ms. Martin, get prepared. 1, judge. Two, Gordon. 3, Felice. We got McLean. And Hall. All right. The time will begin when you begin your arguments.
May it please the court. Minors need to be protected from crafty adults. Based upon his actions as outlined in the facts and the nature of his complaint, Tommy Z would fall into this very category. The infancy doctrine exists because even with the improvements in communication and technology, minors are still minors, still learning, and protections must still be afforded to them. The Superior Court saw the need for these protections and provided analysis of the best common law rule. Their decision is correct, and that decision should be affirmed for the following reasons. 1, no matter the rule, this affirmance still exists for minors who come of age. 2, Ms. Flick was not provided the required time to disaffirm. 3, even with another rule, Tommy Z remains in possession of the shirts. To my first point, the Moot Superior Court began by looking at Restatement 2nd of Contracts 12 and 14. They then analyzed Oregon statutes and code, which is what the Virgin Islands Code was initially based on. Both parties already agreed that the principles of Restatements 12 and 14 have both been used in the Virgin Islands in the past, and that under a bank's analysis, this weighs heavily in the adoption of Restatements 2nd of Contracts 12 and 14. Restatements automatically provide minors with voidable contractual duties until the beginning of the day before their 18th birthday. Ms. Flick's contract started on April 13, 2020, which gives her the right to void the contract. Ms. Flick, at the time of the agreement in question, was a minor, unable to assent to a contract. The day before Ms. Flick's 18th birthday was April 18, 2020. Ms. Flick still has the ability to disaffirm. Highland v. Tolleson, a case that the Moot Superior Court referenced by name in their analysis, states that minors can disaffirm their contract within a reasonable time after coming of age. If this was Oregon in 1915, 10 years would have been a reasonable time. Tommy Z didn't give her 10 days. As a matter of fact, he didn't give her 24 hours. As Ms. Flick fought a violation of her First Amendment rights, he came seeking restitution for a voidable, incomplete contract. That brings me to my second point. Opposing counsel may say that my client had more than enough time to contact Tommy Z, but the fact shows that other events took priority. If we look at the timeline of events, Ms. Flick went from initial contact with Tommy Z to respectful and controlled sitting, to a meeting, to an expulsion hearing, to an expulsion, to a challenge before the Moot Superior Court, all within less than a week. Even her birthday was likely the last thing on her mind. These facts illustrate the exact reason why protections are afforded to infants. Even in cases where goods were exchanged, like Kiefer v. Fred Hull Motors, Inc., even an emancipated minor is afforded protections. In that case, Kiefer purchased a car and was able to return the vehicle in return for the money he paid. The contract was voidable by Kiefer, the minor. To tie this point to my first, the comments in Restatements of Contracts also states a minor need not take any action to disaffirm a contract until they come of age. In our case, Ms. Flick still would be able to disaffirm, but she was never provided the time to do so. To my final point, the rule should be the one outlined by the Moot Superior Court. Minors who disaffirm within a reasonable time can avoid liability. A majority of jurisdictions operates in this way. The jurisdiction in which the Virgin Islands Code was initially based upon operates this way. And even if another rule was used, Tommy Z still does not benefit. Kiefer takes place in Wisconsin, and while a change could be made, that court provides that any act that shows disaffirmance is sufficient. In our case, Ms. Flick didn't arrive. This can be viewed as disaffirmance. If we went further away from the best rule for the Virgin Islands and looked to New Hampshire and Porter v. Wilson, and that court noted that it was the minority. They required the minor make restitution to the extent that they received a benefit under the contract. My client, unlike Kiefer and unlike Porter, has not seen, and did not arrive to see Tommy Z's media courtesies. Ms. Flick received no benefit. What Tommy Z should have done was have a deposit system in place to recoup a proportion of potential loss, regardless of his contract was with a minor or otherwise. If he did this, no matter the rule, he would have a more sound business practice and would not be inviting trouble contracting with minors. In brief, Tommy Z saw an opportunity and decided to jump on the bandwagon, adding to my client's stress in a trying time. The best rule is the one outlined by the Moot Superior Court. But no matter the rule, he receives no benefit. Ms. Flick can disaffirm, has disaffirmed, and has not seen or received any shirt to which she is able to provide restitution. We must defend against business owners like Tommy Z, who would seize the opportunity to take advantage of minors. It is for these reasons that this court should affirm the Moot Superior Court ruling. Your Honors, thank you for your time.
I have a question. So part of your argument is blaming the T-shirt operator for manufacturing these T-shirts. Is that correct? Which doesn't put any responsibility on the shoulders of somebody who comes in and purchases. Is that part of the argument today?
No, Your Honor, we're arguing that he didn't give my client enough time to disaffirm.
Okay.
Your Honors, if there isn't.
So I have a question. Did she disaffirm, yes or no?
Yes, Your Honor, she did disaffirm. By not showing up to pick up the shirt, that could be viewed as disaffirmance. And her not showing up was because Tommy Z didn't give her enough time.
Enough time to show up?
Yes, Your Honor.
So your argument is, had he not filed suit, at some point she would have shown up to collect those T-shirts?
Your Honor, on the day of the payment, Ms. Flick was in court. So if Tommy Z had given my client enough time after that, I'm positive that she would have made the payment.
Thank you.
Your Honor, there's not any more time. I'll yield the remaining of the time to the court. Thank you for your time.
Thank you.
Thank you.
All right. And that concludes our arguments. We have a little bit different of a presentation this year. Our guest speaker, Matt Campbell, should be joining us now to fill some time. Attorney Campbell is the federal defender of the Virgin Islands. In moot court, we do try to give some amount of civics education. You learned about the legislature, the legislative branch, from Senator Fred Gregory appearing today. Obviously, this fact pattern occurs in the judicial branch. And you cited two Attorney General opinions, which are from the executive branch. In the US, we also split power and diffuse it in a concept called federalism. And Attorney Campbell represents the federal branch of the United States government in the Virgin Islands. And he defends people accused of crimes in the federal courts of the Virgin Islands. So Attorney Campbell graduated from Tufts University with a Bachelor of Arts in Political Science in 1991, after which he graduated the Washington College of Law at American University in 1996, And on February 11th, 2020, Attorney Campbell became the federal defender for the Virgin Islands. He's here to talk to you a little bit today about free speech while the judges continue tallying their scores and forwarding to us, and while my co-chair and I validate the scores. For those of you who are used to the program, please don't panic. We will give the judges a chance to give you feedback after this keynote speech, but they need a little bit of time here to complete their scoring and everything like that. With that, I will turn the floor over to Matt, and if at the end of his speech, if you have questions, by all means, raise your hand in the chat and I will put it through.
Okay, thank you very much, Adam. And thank you for everybody that's still here listening to me. This has been fascinating for me to see and hear. So I was just going to talk a little bit about the First Amendment. I know you have two different issues, one being the First Amendment and one being the contract issue. I'm not going to talk about the contract issue because I haven't studied contracts since my first year in law school in 1994. So I really want to talk a little bit about the First Amendment, and I sort of thought of it as why is it first and why does it remain first? So that's kind of where I wanted to focus initially. And I think the easy answer to that is because the rest of the Bill of Rights essentially depends on the First Amendment. Without the ability to speak, transgressions of other constitutional amendments cannot be vindicated. If we think about things like the right to due process, there is no due process without the right to speak and the right to speak freely. The Sixth Amendment right to a speedy public trial relies on that free exchange of ideas and the free exercise of the press. I think the Eighth Amendment, cruel and unusual punishment clause, can't be enforced without the ability of the press to show what's going on. Frankly, the First Amendment addresses the most fundamental rights possible, the rights to think, speak, worship, and exchange ideas with others. The First Amendment affects so many different activities that we engage in on a daily basis. As you saw from, I've seen it pronounced Mahoney school district case, it affects our public schools in so many ways. But it affects so many other things. It affects politics. The McIntyre v. Ohio Elections Commission case was a statute prohibiting distribution of anonymous campaign literature, and the court found that that violated the First Amendment. It affects entertainment and our ability to comment on public figures. And I was thinking about the Hustler magazine v. Falwell case. And it certainly affects what I do on a daily basis, criminal cases. I believe you had been cited to the Cohen v. California case, which involved a message that some found obscene on someone's jacket in a courthouse, and they were cited for disturbing the peace. And I think the other huge issue that the First Amendment affects is religion. And there are numerous cases talking about the Free Exercise Clause and the Establishment Clause. I think the other reason, and I say this tongue in cheek, why the First Amendment is first is because it is complicated. If I were with you all in person, I would probably give you a standing ovation because the First Amendment is an amazingly complicated issue that asks numerous fundamental questions, such as what is speech? And I heard people refer to several of the different cases. Schneck v. United States back in 1919 talked about about falsely shouting fire in a theater and establishing the clear and present danger test. I heard somebody cite earlier the Chaplinsky case, which established the doctrine of fighting words. My humble opinion, I think Chaplinsky is probably dead law at this point. I don't know that anybody would really uphold the fighting words doctrine anymore. I think it's largely been replaced by Brandenburg, talking about whether words incite imminent lawless action. I think that's probably the applicable standard these days. But these are incredibly complicated areas that I don't know that there are hard, fast answers to. So you should all be very proud of yourself for dealing with such a complicated topic. But it also addresses complex issues like the freedom of expression in schools. And as we've seen just from your presentations, that is a very complicated issue to which we may not have clear answers. These cases are not always clear. And I think turning to Mahoney, we see that. Now, the Mahoney case had what appears to be, I think, a relatively simple holding, namely that Pennsylvania high school officials lacked the authority to discipline a student for an off-campus vulgar Snapchat post she made in frustration after not making the varsity cheerleading squad. And in some ways, it wasn't terribly controversial. It was an 8-1 decision with only Justice Thomas in dissent, ruling that the social media post did not cause a substantial disruption under the Tinker test. And I think if we state it like that, it becomes an interesting decision, because I think there's an argument to say, what really did this case decide? Typically, the Supreme Court takes cases in which they're deciding large areas or significant legal questions that are going to be applicable sort of across the country. And that holding is pretty narrow, that under the facts of that case, it didn't cause substantial disruption under the Tinker test. Everybody's familiar with the general facts of this case. Brandy Levy didn't make the cheerleading squad. She didn't get the position she wanted in softball, and she, on a Saturday afternoon, posted a Snapchat with some admittedly choice comments about cheerleading and softball. But she made that post outside, I believe it was the Cocoa Hut, a local convenience store. Somebody saw it, and I believe it was another member of the cheerleading squad, and they showed her to an assistant coach, and the school suspended her for 1 year from cheerleading. So right there, we do have the state action requirement. As we all know, the First Amendment only prevents the government from taking action against speech. It doesn't affect private individuals from doing so. But Levy, through her parents, sued in federal court, arguing that the discipline violated First Amendment rights to free speech, and arguing that her parents and not the school should be the disciplinarians. The district court, the trial court, found in her favor, as did the Third Circuit. And this is an interesting issue, I think, the way this case came up, because the Third Circuit ruled fairly broadly. They issued what I was talking about as a rule of law type of decision, where they said Tinker doesn't apply to off-campus online speech. That's a pretty clear ruling. One could argue if it's correct or not, but it's not very factually specific. And then alternatively, they argued that even if Tinker did apply, the post did not cause the level of substantial disruption. That would have been a more narrow ruling under the facts of the case. So they issued a broad legal decision as well as a more narrow factual decision. So what happened? It went up to the Supreme Court. Justice Breyer wrote for himself and 7 other justices, the 8-justice majority. And just the fact that Justice Breyer did the writing as opposed to another judge, I think would signal to court watchers that this was going to be more of a narrow factual decision. Justice Breyer is known as a pragmatist who tends to write decisions with practical import as opposed to sweeping legal rules. And in ruling that the school district improperly disciplined Brandy Levy, the court found that the school's interest in teaching good manners was not sufficient to overcome the student's interest in free expression. So there we see the court using what we would call a balancing test, balancing the rights of the school's interest and opposing that to the student's interest in free expression. You see a lot of balancing tests in Supreme Court case law, and I will tell you, those are not always easy to apply. While they tend to tell judges what they should be balancing, it doesn't necessarily give the judges a lot of guidance as to exactly how they should come out. And in a case like this going forward, while the judges lower judges might know what they're supposed to balance, I don't know that they would necessarily know how they were supposed to come out. The court also held that the school's interest in preventing disruption of the school's efforts to maintain cohesion on the cheerleading team wasn't supported by the facts of this case. They did note that the social media posts were sent outside of school hours and off campus and didn't identify the school or target any particular person. So again, a highly factually sensitive decision that is based on the facts of this case and would not necessarily be easy to define. Breyer reasoned that the school's regulatory interests are lessened when a student engages in off-campus social media speech. And I think that immediately puts up some red flags, at least in my mind, because they did distinguish between off-campus and on-campus speech. But I think that raises more questions than it perhaps answers, because the internet is hardly really an off-campus or on-campus issue. How would this decision have come out, for example, if Brandy had posted this while sitting in study hall? It really wouldn't have affected the practical import of her post. It would have been rather arbitrary to say that this decision should be different just because she was sitting in a study hall or sitting on a school bus. But I'm not a Supreme Court justice, so not my place to decide. Justice Breyer identified several features of social media that dictated such an approach. He talked about how with off-campus speech, and I heard somebody using this phrase, school officials rarely stand in loco parentis, and noted that geographically speaking, off-campus speech typically falls within the zone of parental rather than school-related responsibility. And he noted that Levy's parents should be the decider of discipline for her off-campus Snapchat, not school officials. Noting that the school's interest in teaching good manners is not sufficient to overcome her interest in free expression. So again, we're talking about that balancing approach. He noted that the court should be skeptical of school officials' regulatory interest in policing social media speech, given that such speech could take place anytime during a 24-hour day. Now that makes some sense, but I would argue that it sort of runs counter to some of these bright line distinctions between off-campus and on-campus. The internet is ever present and a forever institution, and that once something's put on it, it's there essentially forever, even if somebody tries to delete it. So while that may make sense in one way, in another way, whether or not it's made off campus or whether it's made outside of school hours really doesn't have much of a practical effect. But he did also note, and I think this is important for all free speech absolutists or civil libertarians, that schools have an interest in protecting even unpopular student speech because the public schools are nurseries of democracy. So we do see some strains of just the value of open speech, particularly in schools. We've seen this in some of the library cases, and I think that's what Justice Breyer was hearkening to, some of those library cases. Now, I think it's an interesting question. After this decision, when can off-campus student speech be regulated? And I would argue that the Supreme Court essentially punted on this issue. It declined to provide an exhaustive list of circumstances in which off-campus speech rights under the First Amendment give way to the school's need to prevent harm. But the court did list some factors or circumstances that may allow the court to regulate off-campus speech. And it noted serious or severe bullying or harassment targeting certain individuals, threats at teachers or other students, the failure to follow rules concerning lessons, the writing of papers, the use of computers, or participation in other online school activities, and breaches of school security devices, including material maintained within school computers. Again, this is just my commentary. With the exception possibly of the bullying, I think most of those other items, frankly, are probably covered by other statutes or concerns. Threats, well, depending on the nature of the threat, threats are criminalized already. Breaches of school security devices and the like, I mean, hacking is illegal. So I don't know that these factors really tell us a whole lot. And what does it mean to be serious bullying or severe bullying or harassment? These are rather amorphous terms that I think are going to require a lot more definition before we could use them. So in evaluating this decision, we see that Breyer didn't go as far as the Third Circuit, didn't rule that Tinker had no application to off-campus speech, but he reasoned that there was no evidence that her expression caused a substantial disruption. And he emphasized, and Breyer is known to do this, that schools still maintain a regulatory interest in social media speech constituting those areas that we just talked about. There was an interesting concurring opinion, particularly for people that are interested in history, written by Justice Alito and joined by Justice Gorsuch. And that really emphasized more it's almost not so much a free speech case for the concurrence as it's parental rights, and talking about how in society it's parents and not the state that have the primary authority to raise, educate their children, and form their children's character. But interestingly enough, Justice Alito actually questioned whether schools could punish off-campus student speech through rules on bullying and harassment. And he noted that those are difficult concepts to define, particularly with the precision required to regulate free speech. So I think if we're looking toward what's the next free speech case in this area that'll come, and there will certainly be one, it may very well be in rules regarding bullying or harassment. And although this case came out 8-1, I don't know that it would necessarily come out 8-1 on a bullying case or harassment case, because we have at least 2 justices saying that they have some serious problems regarding those areas. There was a dissent. It was from Justice Thomas. Perhaps that shouldn't be surprising, again, for those that are interested in the court. Justice Thomas is very much what's called a strict constructionist, meaning he believes that the Constitution should be interpreted by the understanding of it that existed when it was written in the 1790s. And obviously our concepts of free speech have changed a lot over the last 200 plus years. But he looked to history and determined that schools historically could discipline students for free speech concerns. And in the past, he's actually called for Tinker to be overruled, saying that student speech essentially should not be protected in the public schools at all. So he takes a very different viewpoint than the rest of the court. I don't know that there's much more to be said about that. It doesn't seem that that's a viewpoint that the majority of justices are ever likely to take in light of all the cases. So I think in looking at this case, there's an interesting question about whether it provides more clarity or more ambiguity. I would certainly say that I don't think it clarifies exactly what free speech rights a minor has. Certainly, our understanding of the free speech clause is much more expansive than it was at the time of the founders, as Justice Thomas would have us evaluate. But there's little consensus over the exact contours of free speech rights, even at the time that the Constitution was drafted. And I think it's similarly unclear now. Social media, frankly, has only made that situation more confusing. Tinker defined free speech rights in public schools, but that was limited to only on-campus speech. And social media has made that distinction more challenging and created more confusion, since off-campus speech can easily be replicated on campus and vice versa. And those distinctions really don't hold with things like Snapchat or Instagram or Facebook. I think there are some interesting questions that you should think about going forward. One would be obvious, which maybe isn't that interesting, but what would the result be if this had been a private school instead of a public school? I think there's a relatively easy answer to that question, which our Antilles friends and others might not like so much. But again, the First Amendment only applies to state action. So a private school could presumably discipline for this, and there would be no First Amendment concerns. So depending on what school you go to, the results may be different for activities such as this. I think it's an open question. What would the result be if this posting had taken place, say, on school grounds, but outside of normal school hours? And again, that relates to the nature of the internet. And with all due respect to Justice Thomas, I don't think our founding fathers could have possibly considered the internet and how that affects a First Amendment issue. I think there's a lot of ambiguity at what level of disruption needs to be shown under Tinker. And the Supreme Court explicitly had said future litigation would be necessary to determine when students' off-campus speech could be regulated. So even the court, in making this decision, which seems to be so clear in an 8-1 decision, admits that there's going to have to be significant litigation going forward. And I think we can expect that school administrators and school boards are going to struggle with this going forward. And it probably asks too much of them to have to analyze the specific characteristics of off-campus speech, as well as the impact of that speech, in determining whether and how to respond to it. So I say these things not because I don't like this decision or because I think it's particularly offensive. I bring this up because if you were confused at all during this process, then you were probably doing it right. This is a very confusing area that practicing lawyers for decades struggle with these First Amendment questions. I think First Amendment law is known to be one of the most difficult to interpret from the Supreme Court, and that oftentimes there seems to be an ad hoc approach. So once again, I applaud you for your efforts. I was very interested to see all your not all your presentations, sorry, I did have to do some work today, but many of your presentations. And I think you showed a level of sophistication that would indicate to me that you guys should all be thinking seriously about law school. I don't want to go on too long. I think I've hit about the amount of time that Adam had suggested. If there were any questions or comments, I'd be happy to see or hear them.
Yes, by all means, feel free, raise your hand, I will, or whatever, I will add, I will unmute you or whatever, or, and if you can unmute yourself, you can just ask a question. We're still totaling, but if there are no questions, I would also then turn it over to the judges. But I want to thank Attorney Campbell first and foremost, because he really did highlight just how complicated of a question you are tackling today. And I think he did a really good job of it. And I think he helped highlight just how much all of you have accomplished and just how much attorneys really don't know, just like you. You know, he pointed out where the court might go, and we don't really know that necessarily. With that, I would start with Attorney Ray on St. Croix, if he would like to give some feedback to the students.
Well, I can say that my overall impression was extraordinarily favorable. I thought everybody was very well prepared. You know, I spent a little bit of time having to think of arguments and points to make against you. And I did make several points, which I personally don't believe in, but it was all for the sake of giving you a hard time and seeing if we could push some of the parameters of this. But I was impressed. I was very impressed. I think there's some real talent in this group. And I do hope that this exercise we've been through, not only that you've learned some things substantively, but also that you're starting to find out a little bit more about yourselves and to have some confidence in your ability to stand up and talk and make arguments and basically fight for what you believe in. To me, that's all critical. If you decide to take that and go to law school with it, fantastic. I think on the whole, we're looking at some people who make great lawyers in the future. If you decide not to do that, and by the way, I can understand that as well. I think this whole exercise has hopefully given a lot of you a lot more confidence in your ability to handle public forums and stand up for what you believe in and make arguments. So I'm impressed.
Awesome. Attorney McLean, do you have anything that you would like to share?
I do actually. I have to say, first of all, I have coached Newport before, so I know it's time consuming. The materials are challenging. It can be a little difficult to grasp just because they're so nuanced and it's just new language. But I have to say, this group of students put on an impressive display. They really got it. And I think more than even just them getting the materials and understanding what it had to say, I liked their confidence. I liked the fact that they didn't allow the judges to throw them off or sway them too much. And there were some students who weren't even thrown off at all. And so I'm just amazed at the performance that we saw on display. These are all very, very bright students, very professional in their presentation, very, great performances all around. And yeah, everyone did well. You are a champion just because you made it this far.
Thank you, and agreed. Felice on St. Croix, do you have anything that you would like to share with the students? You're on mute.
So they were my bad comments. Now I'll say the good ones. No, I was extremely impressed. I thought, especially from a group that is coming from high schools, not colleges or law schools, you were extremely well prepared, had an excellent command of the issues, and were much more articulate than I ever anticipated. It was just very impressive. Keep up the good work. You can tell that you spent many, many, many hours preparing, and it showed. It showed. I was very impressed. So thank you for the opportunity too. I really enjoyed myself. And I can't say that I was just very impressed. So thank you.
Well, thank you for participating. It's been wonderful. And our Moot Chief Justice, Attorney Hall.
Well, the last person to speak has the least to say, because it's all been said by those who came before me. I've got somebody cutting the lawn outside, so if you hear a lawnmower in the background, that's exactly what it is. I have to say, I have never enjoyed Moot Court as much as I enjoyed this one today. And I've never worked as hard since law school on Moot Court as I did today. I really tried to ask questions that would stump you, that would throw you off your game. And I have to say, I'm just astounded at how well you did. It's not easy, even though I've been at this 47 years, to take a position in opposition to one point of view and then later come back and take the opposite side in order to try to provide you with a meaningful experience. And so I did the best I could, and I enjoyed this very, very much. And I wish all of you, the best of luck, because I think you've got a real career opportunity ahead for you if you wish to pursue it.
Sorry, just coordinating. We're still tallying. All right. With that, we need to take about 10 minutes while Rob and I coordinate with the last tallying to announce the scores. Judges, you are welcome to stay, but we have had you for a very long time. So if you wish to leave, you are welcome to do that too. But we should be done fairly quickly here. We are just entering the last few scores.
Can you leave the line open?
Yes, this will stay on. It won't be long, and we will be right back on here as soon as we have the tallies to announce.
Okay, I'd love to see the results. Can I just get a sense of time? It's 6:10 right now. About what time should I plug back in?
About 20 after, I think. I don't think it'll take us longer than that to tally.
Okay.
All right.
Okay, well, I'm going to take care of a few things, and then I'll be back at 6:20.
Sounds good. All right.
Adam, I can't open your attachments, so I'd say you should just go ahead and read them.
All right, then. For the St. Croix District, the St. Croix Central Appellees finished is In third place, St. Croix Central Appellants finished in second, and St. Croix Complex Appellants finished first for the St. Croix district. On St. Thomas, Charlotte Amalie High School Appellees finished third, Antilles Appellees finished second, and St. Thomas Seventh-day Appellees finished first. As for our scores is to best oralist through third runner up. On St. Croix, our third runner up is Alani Arnold. Our second runner up is Bernice Burley. Our first runner up is Nancy Parija. And our best oralist in St. Croix is Una Alexander. On St. Thomas, we have our third runner-up is Dekai Blake. Our second runner-up is Sade Richardson. Our first runner-up, Alicia Kamani. And our best oralist, Mariah Liu from Ivana Eudora Ken. As for the teams that advance, the top 6 teams that we just announced all advanced to Thursday for the championship. 6. The remaining 6 squads that will advance are Antilles Appellants, St. Thomas Seventh-day Adventist Appellants, All Saints Appellees, Eudora Ken Appellees, Saints Peter and Paul Appellants, and Saints Peter and Paul Appellees. And with that, that is the end of today's competition. I do have a few things, observations that were general. In general, all the students could practice speaking more slowly. It was generally noticeable that people rushed a little more than they should. And in general, there was a lot of people waited to be prompted by the court. And there was, at one point, I think someone sat there silent for nearly 30 seconds. You shouldn't be waiting for the court to prompt. If they aren't talking to you, get back into your argument. I think uniformly, it was also, most people struggled paying attention to when their time was up, so watch the timer. And some of the schools, I don't think, looking at the scores, I don't think this had a particular impact, but it's really difficult to judge demeanor when you are so far away from the camera. So some of you, if I were going to use an example of how to set up, St. Thomas Seventh Day, the last ones to go, they framed themselves well. You could see from the torso to the top of their head with relatively little excess. You don't necessarily have to be that close, but that's what I would recommend, and those are my observations. Beyond that, congratulations, and I would turn over to my co-chair for anything he would like to share before we end for the day.
Good job to everybody. I think everybody's homework should be to watch the movies Ferris Bueller's Day Off. And oh man, I can't forget the
Election with Reese Witherspoon.
Election is the other one, and then Breakfast Club, the third.
Yes.
Triumvirate of the trilogy of high school movies that this is inspired by. So if you have not seen those movies, go to your local Blockbuster and rent them.
And lastly, just thank you to the judges. One of the judges commented about all the work that goes into this, and it is clear that you four put in a monumental amount of work. You were so thoroughly prepared, and we are so grateful for that. You gave these students an amazing opportunity and an amazing experience, and we recognize just what a sacrifice that was. With that, good night to everyone. Rest up and good luck on Thursday.
Thanks for the opportunity, Adam. Bye.
Thank you.